I think if you live an interesting life, you'll write very interesting stories, which is also the beautiful thing about creative life overall.
Learning can never stop. There is always something new, and I learn from my patients.
And each one of us will use that choice based on the use that you have to put the technology to. The first film that made me sort of see how a human story and the layers of politics beneath.
पानीपत का युद्ध पढ़कर आने वाले दरोगा लोग इन्वेस्टिगेशन कर रहे हैं, तो उसमें थोड़ा विज्ञान मिश्रित होना चाहिए, ऐसा मेरी अपनी सोच है.
A person may have a very enviable lifestyle, externally appear very successful and happy, but no one really knows what's happening within.
It is not going to kill the supply chain, it is to empower the supply chain. And I'm happy to announce that, we are still very much in the pilot stage and beta testing is going on. We are gradually building up our, presence little by little as people get more and more confident.
Because of the state of our cities, we have no option but to build smart and resilient cities.
Digital India is more for the poor, underprivileged and the deprived.
Ladies and gentlemen, boys and girls, my name is Aditya Malik, and it's an honor and a privilege to welcome all of you to the third edition of the BW Legal World Future of Legal Education Summit 2024, hosted in association with BW Business World. Today, all of us gather here to celebrate and also explore the potentially transformative journey of legal education in our country. And as Yeats once said, that education is not the filling of a pail, but the lighting of a fire. And at BW Legal World, we believe in igniting that fire of knowledge and innovation in the legal profession. The theme for this year's summit is Future Ready Lawyers, integrating industry needs into legal education. Throughout the day, we are privileged to have with us some of the finest minds in the legal realm. Jurists, lawyers, general counsels, and professors, and also a lot of students as well, who will lead us into insightful panel discussions and also keynote sessions. And together, we will all delve into crucial topics shaping the future of legal education, from industry-specific legal skills to the integration of AI and technology in legal practice. Our discussions will not only envision the future of legal education, but also emphasize its pivotal role in shaping a dynamic and also responsive legal ecosystem within our country. We aim to foster a dialogue that not only addresses current challenges, but also charts a course towards excellence and innovation in the future. The summit will continue until approximately 4 p.m., followed by the much anticipated law school ranking ceremony, an initiative to recognize institutions that have excelled in legal education. And beyond the script, of course, we'll celebrate all of this in the evening. But it's especially today as all of us as Indians wake up as the ICC Men's T20 2024 champions. I think that deserves a big round of applause. इससे पहले हम आगे बढ़े. Any cricket fans here? How many of you turned cricket fans last night? Honest. Lovely. And before we move forward, a quick introduction about the BW Legal World community. Launched in 2019, BW Legal World is an offshoot of BW Business World, a 4-decade-old publication that has since consistently ranked amongst India's largest and most reputed business magazines. This exclusive GC community aims to bridge the gap between the business and the legal sector across the globe. BW Legal World brings business leaders and legal doyens from all verticals of the legal fraternity together. Pushing forward the vision of BW Business World, BW Legal World prides itself on covering the revolution in the legal landscape worldwide to bring its readers latest news and also developments from the same. May I please request our team to play the community AV to give us a glimpse of the BW Business World and also of BW Legal World. Please. Would you want a minute? He does. BW Business World, led by Dr. Anurag Batra, Chairman and also the Editor-in-Chief of BW Business World and founder of the Exchange for Media Group, is the fastest growing business media house in the country. With a network spanning across 24 niche business communities and 8 magazines, BW Business World is proud to be entrenched in various verticals in both the domestic and also the global business ecosystems. And with changing times, of course, BW now has a massive readership in the digital space as well. BW in its portfolio has 24 niche B2B communities that organize conferences and also forums to facilitate interactions between sectoral business leaders and also create a conducive environment for collaboration. To keep yourself updated of all the developments, please subscribe to the Business World Group magazines. I promise you, it will add to your professional quest for knowledge and also insights. Exciting offers for all our attendees who've come out on a not so sunny Sunday. And thank you for doing that. The latest issue on stand lists industry expectations from Modi 3.1 areas, which should be on radar in this term as he signals continuity on policy front, retaining his A-team in the new cabinet. I please request the BW team to play the promotional video of the latest BW Business World issue. Please. And while we are here to listen to your thoughts, your experience, and of course also celebrate you, if you wish to share anything online, please also use the hashtag future of legal education. And before we begin, to give you a glimpse of all that's in store for today, the event AV, please. I also take this moment to thank our partners for today. Our associate partner, ICFI Law School, Hyderabad, and GD Goenka University. Our event partners, Joy Travels Private Limited, Fandrum, Mean Me Coffee, The Thick Shake Factory, Reality Plus, Exchange for Media, IWM Buzz, Impact.com, and Pitch. And now to formally welcome all of you, please join me in welcoming on stage Ashima Uri, the Managing Editor at BW Legal World.
Welcome everyone to the third annual edition of the Future of Legal Education Summit at BW Legal World. In the words of Helen Keller, alone we can do so little, together we can do so much. It is this belief that drives us to host this conference, bringing together distinguished jurists, lawyers, general counsel, professors, and students to shape the future of legal education in India. And what a fantastic day. As Aditya mentioned earlier today, last night, our Indian cricket team showed us the power of teamwork and determination, winning the T20 World Cup. It's a great reminder that big achievements require collaboration, strategy, and a shared vision, values that we also honor in the legal profession. Today, we gather to recognize the outstanding efforts of our top 100 legal institutes who have demonstrated exceptional commitment to shaping the next generation of legal professionals. Our award ceremony will celebrate their achievements, and we are thrilled to acknowledge their hard work and dedication. Over the next 8 hours, we'll delve into crucial topics that will shape the legal profession in the years to come. Our discussions will focus on industry-specific legal skills, innovations in AI applications, and future of legal education. Our esteemed speakers and panelists will share their expertise, experiences, insights, sparking meaningful conversations and debates. Let's draw inspiration from our cricketers' victory and the achievements of our legal institutes and work together to shape the future of legal education. Thank you all for joining us. Aditya, over to you.
Thank you. Thank you so much, Ashima. And now for the first keynote. I have the privilege of introducing Justice J.R. Mehta, who's here with us today. I've been given a brief document about sir, and I will make sure that I read it word by word. I do not want to get anything wrong about his legacy. The first keynote is by Justice J.R. Mehta, former judge, Delhi High Court. Justice J.R. Mehta served as a judge of Delhi High Court from 11th April 2008 to 7th of July 2021. Justice Mehta served as a chairperson of Delhi International Arbitration Center as well. Also, Justice Mehta served as a chairperson of Judicial Education and Training Program Committee of High Court of Delhi and supervised the training of judges at Delhi Judicial Academy. Post-retirement, Justice Mehta is actively involved in reforming legal education. So is also a professor of practice in National Law University, Delhi, and is imparting value-based education to law students. He's also a professor emeritus at Galgotia University and also distinguished professor with Rajiv Gandhi National University of Law. Justice Mehta is also the chairperson of Bar Council of India Inspection Committee with respect to Centers of Legal Education. It's an honor and a privilege to have sir with us. Let's please welcome sir for his keynote address with a huge round of applause. Please. Sir.
Good morning, everybody. I thank Business World and particularly Madam Ori, who has invited me to this occasion to share my views on legal education. You see, I've been teaching law in Delhi University Campus Law Center from 1989 to 92. And teaching had been my first passion. So post-retirement, although I was offered very prestigious positions, including heading of Delhi Judicial Academy, but I thought I'll go back to legal education and didn't accept any position. So today, 10 days a month, I'm teaching law. 10 days I am doing arbitration plus Supreme Court. And 10 days I've kept for my own spiritual journey, being the administrator of Kalkaji Temple and Indian Orthopedic Association. My view is that the legal education in our country is not comprehensive. A law graduate is not market ready. Supreme Court has already commented, matter is pending in Supreme Court, where the Supreme Court has called the Bar Council to reform the legal education. And still we are far behind. Today we'll just introspect and see what are the reasons why legal education in our country is not comprehensive. Before going ahead, we'll just discuss how legal profession is different from all other professions. To my mind, legal profession is totally different from a normal profession. In legal profession, our aim is we are dealing with justice delivery system. And for imparting justice, we have to find out the truth. And how to find out the truth, we all know. We have not learned from anybody, no? All of us know when our colleague or child or employee, anybody tells a lie, we all know. We don't require any training. We have to only sharpen that skill which is there. And I will give very small example. And many people, you say, I'll give you a very small example. Very renowned Jessica Lal murder case. Murder took place in front of 100 people, some top bureaucrats. And the Sessions Court held, no one killed Jessica. How do you know what is the truth? And despite what is the use of knowing the law if you can't impart justice? In good old days, when the kings were doing justice, there was no law, no codified law. It was an unwritten law. Still, good justice was done, no? How the justice was done? What is that skill? When I knew that in front of 100 people murder is done, and by knowing the law and by studying the law and by those studying skills and doing judging for 20 years, still we hold no one killed and we acquitted. What happened in Priyadarshini Mattu matter? Who knew the truth? And Jessica Lal murder, ultimately the High Court reversed the acquittal and conveyed to conviction and upheld by the Supreme Court. Priyadarshini Mattu matter, whole world knew what happened. The Sessions Court said acquitted. Ultimately, High Court reversed and the matter was upheld by the Supreme Court. And now, as late on 26th October 23, Nethari murder in 2007, which shocked the conscience of the country, never happened in our country either prior to independence or after independence. 19 rapes, 19 murders, then rape with the corpse, then cutting the body, cooking and eating, and then putting the skull in the drain behind. All the skulls were recovered, 19 skulls recovered. Person confessed. His confession is recorded by a magistrate before Delhi. And in 13 cases, the Sessions Court convicted the accused. And the person had confessed, he didn't file the appeal. His date of hanging was fixed. He was shifted to a jail where next day morning, 7 o'clock, he was to be hanged. 9 o'clock, it came in social media that Surinder Kohli is being hanged. So matter was mentioned before the Supreme Court on Sunday that he has a right of appeal, then right of SLP, then presidential pardon, and then remaining cases are still pending. So how can he be hanged? So morning 4 o'clock, the bench was constituted. The hanging was stayed, then appeal was filed, and 26th October last year, Division Bench of Allahabad High Court acquitted him. Just go back to those scripts, everything. So what is use of studying the law and knowing the law if we don't know how to find out the truth? And many times there's a conflict in law and justice. So when there's a conflict in law and justice, whether we should bend the law and do justice or we should bend justice and do law. To my mind, you see, I am now not doing hardcore teaching. I am reforming legal education. Initially, I conducted advocacy skill course in the university where we trained the law students. Then I'm conducting mentor-mentee courses in 3 universities where we select the best 20 students and try to give perfection to them. You see, one important difference more in legal profession is that the performance of a lawyer comes in public domain on day one. It is not in every profession. It is only in 3 professions. One is cricket, other is films, third is law. So in cricket, in first day, first match, if you let's assume you score 200, one person comes, new boy comes, and he scores 200, he doesn't even get out. Or he throws the ball outside the stadium. Does he require a certificate? He will be number 1 on day 1. Similarly, in films also, he can be number 1 on day 1. We have seen there are many films. We go back to our times and when Bobby picture had come. Here also, if you see the top lawyers, they all within 5 years they came to that place. Within 10 years, the Supreme Court said we are reducing that as the extraordinary case. We are designating him as a senior. So if a law now let's see what is the most important skill. Most important skill of a lawyer is communication skill. How to communicate? Art of listening, then art of thinking before speaking, then art of speaking. Let's assume he knows 100% law, but he's not able to communicate. बड़ा अच्छा लॉयर है, बड़ी अच्छी नॉलेज है, टॉप किया, गोल्ड मेडलिस्ट है, कोर्ट में जाके बोल ही नहीं पाया. बाहर आके क्लाइंट कपड़े भी फाड़ देगा और पैसे भी छीन लेगा. क्या उस यूज का लॉयर? एंड वी डोंट टीच कम्युनिकेशन स्किल. एंड बेंचमार्क ऑफ कम्युनिकेशन स्किल इज दैट you all must have met many people, no? You see them only once and you remember them whole life. Many times you're not even talking to them at the airport or at college or some place, or you meet a person once and you remember for whole life. That should be the mesmerizing personality of a lawyer. Client से बात की तो client impress हो जाए, judge से बात की तो judge wait करे कि next अक्षर क्या बोलेगा ये. How to communicate? I was just complimenting the comparer here, Aditya Malik. I was really impressed with his communication skill. Just see, he spoke for 5 minutes. The way he walks, the way he speaks, the way he pitches, the wording which he used, to my mind, I was impressed in 5 minutes. That should be the personality. कि वो चले तो ऐसे लोग देखें कैसे चल रहा है, देख रहा है तो कैसे देख रहा है, स्माइल होनी चाहिए, इमोशंस होनी चाहिए, बात में इमोशंस होनी चाहिए. And arguments in court has to be like storytelling. Judge should wait ki next kya ho raha hai. But when we teach in moot courts, the way it is argued in moot courts, in the court, we never give, no judge gives the relief. But we don't teach him storytelling. It should be, arguments has to be like Aditya Malik was presenting. But we don't teach communication skill in law schools. Or wherever it is taught, it is not to that level that wo perfect ho jaye. Second most important skill of a lawyer is rational thinking, how to think logically. It has nothing to do with law. For that you have to, and it is in many places it is subject. In Maharashtra at 11th standard, there is a book called Logic. So for that you have to develop a questionable mind, Buddha's mind. Everything you will question, you will not believe, you will say, show me. And we don't teach rational thinking as a subject. And I have developed in my mentor-mentee courses, I have developed very simple techniques for communication skill. I tell the students that you go and talk to one new person every day. And if that person says, why are you talking? You say that my mentor has told me you talk. And then see, next day, that person should call you back. Not that if you call him and he says, I will not tolerate you today, it means your skill has not yet developed. So at the end of mentor-mentee course, 6 of my students are here today. So at the end of the one semester, they all have 100 plus contacts. And apart from communication skill, that also they build up a network. The net worth of a lawyer is his network. And for logical thinking, I have developed a very simple exercise. I said, you don't have to go through that courses. You whole day, you take up some small issues and convince the people. I said, you take out the benefits. 10, 15 benefits of drinking coffee and pick up a person who doesn't drink coffee and convince him that please drink coffee, otherwise you are wasting your life. And if that person starts drinking coffee, you have succeeded. और जो कॉफी पीता हो उसको कन्विंस करो कि कॉफी जहर है मत पियो. जो चाय पीता हो उसको कन्विंस करो चाय छोड़ दे. जो चाय नहीं पीता उसको चाय शुरू करवाओ. जो मंदिर जाता हो उसको कन्विंस करो कोई फायदा नहीं, कहीं किसी को भगवान नहीं मिला मंदिर में. और जो नहीं जाता उसको कोई और वेस्टिंग लाइफ. और अगर ये भी कन्विंस नहीं आप कर सकते तो कोर्ट में जज को कैसे कन्विंस कर दो किसने मर्डर किया या नहीं किया? Very simple things. I just pick up from the YouTube. That will show your communication skill and your rational thinking. Very simple example आप देखिए, शाहरुख खान के बेटे का जो केस था. So best lawyers were there at the magistrate level. Correct law was cited. The bail was not granted. Second level also not granted. Third level the lawyer changed. He spoke the things rationally and different logically, which convinced the human mind. So ultimately, it is answer when the case reaches Supreme Court, where the concurrent decisions of 3 courts are reversed. It is those logical thinking, which is, if you see the arguments, nothing to do with law. But we are not teaching rational thinking. Third important skill of a lawyer is to understand fundamentals of law. Fundamental of law is different from knowing the law. You have to go backward. What was the position when this law was not there? What situation arose which required this law to be created? Where this law was first created? There was a time when there was no trademark law. In one country, one case arose that government created a law, very primitive law. From that, it developed and started moving to other countries. Finally, it reached very primitive law in our country, 42. Then it was amended time to time. Still, it is not perfect. So once we go backward, many times when I'm taking faculty members interviews, and from a constitutional teacher teaching constitution, I ask him, I said, we have 6 fundamental rights. How many rights were there prior to the constitution? There were some rights still there, no? And prior to British rule, how many fundamental rights we had under Mughal rule? Prior to that, when we were free under the kings, how many fundamentals? Still we didn't had 6. How many fundamentals rights in a adjoining country? But there's no understanding. A very nice chart can be prepared. What are the fundamental rights? So that one understands the law in and out. Right to Information Act. You see, one day the Prime Minister found that a member of Parliament had charged 5 crore from an industrialist to ask a question. That, which shocked his conscience. He said, I'll give the right to everybody in the public so that the members of Parliament don't sell our country. Attacking doctors was not an offense. In COVID times, when we saw people attacking doctors, suddenly ordinance was passed. Now this NEET exam, now the ordinance is being passed to bring a 1 crore compensation and 10 years imprisonment. So if we understand, again, that law is based on logic. So to understand the law, one should go backward and understand the law in and out. Not only read the law. Apart from that, few more skills. Again, we are not teaching law in this manner. And to my mind today, although there are other skills also, to my mind, dramatics, to a large extent, if you see all top lawyers, some time or the other who had been in dramatics, they perform better. Then also knowing psychology, art of reading the mind. If you're not able to read the mind of your client, you're not able to read the mind of the judge, will not be able to succeed. So law by itself will not make a person. And my perception is that I believe that Singapore has a wonderful education policy. From the initial period itself, they keep on selecting as to which person has got the competence to become what in life. So, and they keep on separating and segregating those people. They decide that this person will be the best. He has a competence of becoming a doctor. This person has a basic core inherent talent or preloaded hardware and software to become an engineer. This person should become a judge. This person should become a lawyer. But in our country, it is the parents who decide. A person doesn't have a talent of a doctor and the parents force him to become a doctor. And then it creates miseries. But to my mind, a very good teacher can find out that this person has got a very good talent to become a judge. This person has got a very good talent to become a lawyer. This person has a very good talent to become a teacher. It can be done. So what exercise I am doing is we select the best 20 students and then try to train them. And out of 20 also we try to segregate them. And judging, I'll come back to it. Very nice book of Chief Justice Munir, Chief Justice of Lahore High Court on Law of Evidence, where Chief Justice Munir has in the introduction itself stated that substantive law only tells us what are the rights and liabilities. So if you have to find out whether A has committed murder, IPC will not give the answer. Law of evidence tells us what are relevant facts, who has the onus to prove. But on the last day when the judge has to decide the case, pick up the scales of justice, law of evidence doesn't give the answer. CPC and CRPC procedural law tells us what route to follow, but that also doesn't give the answer. Chief Justice Munir says, last day when the judge picks up the scales of justice, no law guides him. Best shoes of the world will not teach a person how to walk. How to do justice? That is not there, we don't teach. And to my mind, one thing which I don't know, everybody may not agree with it, we don't have good law teachers. Number of colleges in the country have mushroomed and the minimum number of teachers which one has to keep are not available. So, and very nice, in January, 31st January in NLU, we had a teachers conclave where the Vice Chancellor, our Vice Chancellor there, Professor Vajpayee, gave very nice, he had presented a book on teaching methods. But he said there is no process of making a teacher. A person becomes a teacher by appointment letter. You get a degree and get an appointment letter, you become a teacher. How to teach is different from knowing the subject. And all these skills which you want to impart to the law student, teacher should have it. अगर टीचर में ही कम्युनिकेशन स्किल नहीं है, टीचर में ही रैशनल थिंकिंग नहीं है, फंडामेंटल्स नहीं है, तो बच्चे को वो क्या पढ़ाएगा? तो मैं बहुत जगह आई हैव परसुएडेड मेनी पीपल टू स्टार्ट ए इंस्टीट्यूट टू ट्रेन द टीचर्स एंड क्रिएट टीचर्स. Till now, I've not succeeded, but to my mind, so many legal luminaries are here. You should start a separate faculty. To my mind, every good law school should have, number one, a, a program to create teachers. Number two, a program for advocacy skills. Number three, judicial service training. These three things, to my mind, are very important. And similarly, for becoming a lawyer, there's no process. You take a law degree, get registered, and you're a lawyer tomorrow. But you have no communication skill. Third, we have no process even for creating judges. Judicial Academy I had been heading Judicial Academy. There also it is all advocism. You see, although we give 2 years training, but there's no full-fledged, we have no, I think I would not comment much on it, but we have no professors there. Like in IS Academy, Lal Bahadur Academy, I did a research on that. I was trying to reform there. They have got people at the level of professor. They may come on deputation. They may be IS officers only. There's a teaching faculty. Here it is all advocism. So, and to my mind, every university should select at least 20 students और उसमें select करे कि कौन से ये top judges बन सकते हैं, कौन से top lawyers बन सकते हैं, कौन से top teachers बन सकते हैं, और जो बच्चा बहुत top lawyer उसमें सारी communication skill हो, और and if we tell the Chief Justice that look, today the student will argue, this is his first case, and he will argue better than the top lawyers of the country. And if the first law student argues the first case better than top lawyers of the country, to my mind, he will be recognized on that next day morning, no? He doesn't have to look back. So I was just asking Ashma, I said, what are the criteria you have kept for grading the law schools? She has given me those criteria. मैंने कहा मेरे ख्याल से तो 20 बच्चे उनको दिखाने चाहिए कि ये बच्चे हैं, तो देखो हमने प्रोड्यूस किए हैं कि this person will be the future CGI, this will be the future Attorney General, this will be the best teacher of the country. ऐसे अगर 3 बच्चे उनके देख लिए जाएं, और एक बड़ा छोटा सा एक लास्ट, आई थिंक आई हैव ओवरस्टेप्ड द टाइम. You see this moot court system. The moot court system we have created where we create a problem, 20 pages problem, such a complicated problem which does not exist on this planet, and we give it to that law student instead of telling him a simple case of say divorce or suit recovery or recovery property or breach of contract. आधे पेज की प्रॉब्लम देके उसकी रैशनल माइंड फैक्ट्स के ऊपर हम डिस्कस करें, हम नहीं करते. और ऐसी प्रॉब्लम जो आप एक बार टेस्ट करके देख लेना, किसी सिटिंग या रिटायर्ड जज को देके भी इसकी जजमेंट लिख के दिखाओ, उसकी जजमेंट भी नहीं हो सकती. I don't go to any moot court at all, except one university I've only found which had a very nice problem where I went. Otherwise, you see, I was approached by a university. They said, after 3 days, there is international moot court. You please chair the last session. I said, where is the problem? So they gave a booklet, 25 पेज की. मैंने कहा ये क्या बुकलेट है? तो वो डायरेक्टर ने कहा कि ये प्रोफेसर बताएंगे. प्रोफेसर कहा बताओ, कहते जी कोविड के रिलेटेड. मैंने कहा नहीं, प्रॉब्लम क्या है? कहते वो भी हम पढ़ेंगे. मैंने कहा ये कहाँ से आई प्रॉब्लम? कहते बेंगलोर में कोई आदमी बनाता है. मैंने कहा जो आदमी ना लॉयर बन पाया, ना जज बन पाया, ना टीचर बन पाया, वो ऐसी प्रॉब्लम बना रहा है जो कुछ सॉल्व नहीं कर सकता. और मूट कोर्ट जजेस भी उस प्रॉब्लम को नहीं पढ़ते. बाई ओरेटरी स्किल्स दे गिव द मार्क्स, जिसका कोई सोल्यूशन नहीं है उस प्रॉब्लम का. मैंने कहा एक सिंपल प्रॉब्लम दीजिए. आई गिव ए वेरी सिंपल प्रॉब्लम टू स्टूडेंट्स एंड दे आर्ग्यू. द स्टूडेंट्स आर हियर. वेरी सिंपल प्रॉब्लम. मैंने कहा कि एक, आई जस्ट गिव ए वेरी स्मॉल इलस्ट्रेशन. आई सेड दिस इज अ लेडी हु सस्पेक्ट्स that her husband has an affair with the secretary. So she goes to the lawyer. Lawyer says that, look, you have no proof. So if you make any allegation, so it will be ground of cruelty by husband to you. So I'll give you a very simple solution. You file a FIR in police that my husband beats me every day when he comes back from the office. You don't require evidence or proof. And now the husband wife files the FIR of 498A IPC. And now she's in the witness box. You please cross-examine her. Students there, and then they cross-examine first-year students. The rational mind works. And you see, very simple problems you can give. Suit for recovery, eviction suit, divorce suit, half-page problem, so that the person mind works and he finds a rational solution to it. You see, 2 days back, we were having an internship. Students were having internship. I invited Dr. Arun Mohan, who is a very legal luminary. So he circulated a very nice page. He gave it, I'll share with Ashma also, in which he has said that in a court of law, 55% is non-law for conducting a case in court. And remaining 45 also, law is only 1%. Application of law is 4%. Remaining is facts. You first, when the client comes to a lawyer, the lawyer has to understand all the facts, then see which law is applicable, then separate relevant facts from irrelevant facts, then see for relevant facts what is the evidence, then he has to draft and file a case and then prove the case. Substantive law will only tell us what are the ingredients. So in the court of law, we only have those facts. We have to decide on facts. And the problem recently in one of the universities, there was a very big problem of 20 pages where the wires of a law was challenged before the Supreme Court, and students were asked to argue. And such a complicated problem. In my 26 years of practice, I didn't have the occasion of challenging the wires. Such cases don't come. And legal profession, one more important thing you have to see, a lawyer cannot choose a client. कि जी मैं तो इसी client का case करूंगा. He can't choose a case कि जी मैं तो यही case करूंगा. And lastly, he can't even choose a judge. तो सिंपल केसेस जो डे वन उसकी लाइफ प्रॉब्लम से रिलेटेड है, उनको जो है हमें डिसाइड करना है. उसके लिए एक अलग स्किल चाहिए. और किसी और प्रोफेशन में ऐसा नहीं है कि जहां पर दैट पर्टिकुलर सब्जेक्ट इज लेस एंड इट इज जनरल कॉमन सेंस विच प्रिवेल्स. फॉर फाइंडिंग आउट द ट्रूथ यू हैव टू हैव जनरल अवेयरनेस एंड जनरल स्किल, which is the most important skill. So I will request all the legal luminaries here to reform the legal education and at least start a course on advocacy skill and justice, and people who want to go for becoming a judge, and also creating teachers, and select at least 20 students in your university and create at least 20 people who should be the future judges of our country, and who should be the future top lawyers of our country, and who should be the top teachers of our country. And unless we have got good teachers, and you see, I just discussed that Nithari case. All of you should read that judgment. But in that Nithari matter, one person who needs to be applauded, to my mind, in that case, is the lawyer. To my mind, even if I had been the lawyer, Mr. Mir is here. He's a very renowned criminal lawyer. Even I would not have been able to argue and get a person acquitted. But देखो, see the skill of that lawyer. जहां पे 19 rape, 19 murder, फिर rape with the corpse, and then cooking and eating the body and skull recovered from the back, entire circumstantial evidence. उसमें भी एक लॉयर ने कन्विंस कर दिया डिवीजन बेंच को कि ये तो इनोसेंट आदमी है, किसको ऊपर लिखे है. और टू माय माइंड दैट लॉयर उस जजमेंट के बेसिस पे, in fact, I discussed with Mr. Mir once that judgment. I had shared that judgment also. And you see, now this judgment, I gave it to my first year students who are here. I said, this is the judgment of Allahabad High Court. This is the judgment of Jessica Lal murder case. This is the case of Priyadarshini Mattu. There also the acquittal was there. I said, you draft the SLP. All the students have drafted the SLP. No law is required. You have to see reasoning, give the factual. And I said, now you argue on admission. They all have argued and we have got the videos. And I said, when the real SLP is filed, we'll test with the real SLP. And when the matter goes court, we'll take you there. Now the SLP has been filed about, I think, 2 weeks back. But tell me, in the basis of this judgment, Now that lawyer can argue in other courts, no, जहां पे एक मर्डर या एक रेप हो, जी यहाँ 19 में मैंने एक्विट कराया और 19 में एक्विटल है, इसके बेसिस पे एक को कैसे कर सकते हो आप? So unless our legal education is very strong, our communication skills, rational thinking, good judgment will also come from logical thinking. So I am strongly in favor, and I think this is a good platform, and I am really impressed the way they have conducted this course, and this platform is very good, and I think business world should also work for reforming the legal education. And Mr. Abigail Malik, you have very good communication skills and rational thinking. I am impressed with your, to my mind, if these skills are there with every lawyer, you should join legal profession. You have got this inherent skills. To my mind, if these skills are there, no, so one can succeed. And one last thing I'll share about legal profession. In all other professions, when the professional charges the money, he has to deliver. इंजीनियर है, उसको मकान बनाना पड़ेगा ना, डॉक्टर को सर्जरी करनी पड़ेगी, सीए को रिटर्न फाइल करनी पड़ेगी. लॉयर को जब क्लाइंट लास्ट में कहता है कि जी आप मुझे क्या डिलीवर कर रहे हो, सो लॉयर से नो, आई कांट डिलीवर. अगर जज को केस समझ में आ गया तो वो ऑर्डर मिल जाएगा, नहीं तो अपील करेंगे. तो उसने कहा जी पैसे, उसने कहा पैसे पहले मैंने आपसे बात की, फिर मैंने राइटिंग में नोट्स बनाए, पिटीशन फाइल की, फिर जज से बात की. तो बात करने के इतने पैसे, कितने पैसे, जितने ना तो मेरे ख्याल को एयरलाइंस वाले बना रहे होंगे, ना कोई डॉक्टर बना रहा होगा, ना इंजीनियर बना रहा होगा, ना कोई क्रूज वाला बना रहा होगा. एक तरह का मिंटिंग मशीन रख दो और एक बार टॉप लॉयर्स कंट्री को रख दो तो शायद मशीन शॉर्ट सर्किट हो जाए. किस चीज के पैसे? बात करने के. तो अगर बात करने के इतने पैसे हैं तो ऐसी बात होनी चाहिए, तो बात करनी नहीं, बात बनानी आनी चाहिए. और जुडिशरी भी, तो इसलिए लीगल प्रोफेशन तो सब प्रोफेशन से डिफरेंट है, इसके मुकाबले का तो कोई प्रोफेशन ही नहीं है. अगर सिर्फ बात करने के पैसे हैं तो आपका, यू शुड बी मेस्मराइजिंग पर्सनैलिटी. आप चलो तो ऐसा चलो कि कुछ लोग देखें कैसे चल रहा है, आप हंसो तो ऐसा हंसो कि लोग कहें कैसे स्माइल कर रहा है, आप बोलो तो ऐसा बोलो कि लोग कहें कैसा बोलता है. फूल झड़ने चाहिए. और अगर हमने ये नहीं डाला तो उसको लॉ की डिग्री देके गोल्ड मेडल भी दे दिया तो कुछ अचीव हमने नहीं किया. और जुडिशरी का प्रोफेशन भी सब प्रोफेशन से डिफरेंट है. टू माई माइंड, judiciary and teaching are the only two professions in the world. In every other job of this world, one has to act on instructions. Top post आप ले लीजिए कैबिनेट सेक्रेटरी की, he can't tell the prime minister no or the minister ki don't give me instructions, I'll invoke my soul and then do whatever I feel proper. A police commissioner can't tell the home minister ki नहीं फोन नहीं करो मेरे को, मैं डिसाइड करूंगा अपने कमरा बंद करके. But a judge has not to take any instruction from anybody in the morning, not give any answers in the evening, only write whatever he wants to write in the judgment. Nobody can contact him. He has to hear the arguments, invoke his soul, find out the truth and do justice. So where is the freedom in any other job of invoking your soul? Similarly, teacher also. Attendance to teacher और judge दोनों को लगानी है. Teacher also no instructions how to teach. He has full freedom. He has to just invoke his soul and enter the heart of the student. So teaching is also, to my mind, and teaching is more pure. You see, judging के लिए तो जब तक वो skill ना हो, मैं कई बार स्टूडेंट्स को कहता हूं, मैंने कहा भाई जज का एग्जाम देने से पहले आप ये देख लेना कि वो जज वाली स्किल तो नहीं है अपने. अगर एग्जाम में तो जजिंग स्किल आपकी टेस्ट नहीं हो गई, आपकी जो है वो स्किल का टेस्ट नहीं है, सिर्फ लॉ का ही टेस्ट है. बट अल्टीमेटली जजिंग करने के लिए तो आपको एक आर्ट होनी चाहिए. मैं बड़ा एक सिंपल एग्जांपल देता हूं. मैंने कहा तुम्हारे सामने एक केस आया, सिंपल केस की वाइफ ने कहा जी मुझे ये ऑफिस से आते हैं रोज मारते हैं, और हस्बैंड कहता है जी मैं तो नहीं मारता. कैसे डिसाइड करोगे? दोनों ने ओथ पे कह दिया, दोनों का क्रॉस में नहीं टूटे. हाउ विल यू रीच द ट्रूथ? इट मे बी ट्रू दैट द हस्बैंड एवरी डे कम्स एंड ट्रीट्स द वाइफ विद क्रुएल्टी. It is also equally possible that wife has got an affair and she wants to get rid of the husband and file a false case to send him behind bar. मैंने कहा कैसे डिसाइड करोगे? जजिंग के लिए एक वो अलग स्किल है, which answer doesn't come from law. Section 3 and 4 of the Evidence Act says effect is said to be proved when the judge, on considering the entire material, either believes it to exist or consider the existence highly probable. It is ultimate test is judicial belief. So 100 witnesses, let's assume a person files a case that I saw the sun rising from west, and he produces 100 witnesses. All the witnesses are cross-examined. They are not broken. Can we say that he has proved? We'll say no. It is against law of nature. Therefore, I don't believe it. It does not pass the test of judicial belief. Ultimate test to be applied by the judge when he holds the scales of justice is whether he believes it. So 100 witnesses may come. They are not shattered in cross. If the judge says, no, I don't believe, it will not happen like this. And justice cannot be found only by arguments alone. If I have to decide what is the taste of a liquid in a bottle, one person is saying it is sweet, other is saying it is sour. Now, whether I hear the arguments for 1 day or 1 year or 10 years, I can't decide. Answer can be wrong. Only way is to taste it. And once I taste it, all arguments become irrelevant. So my purpose today is just to have a brainstorming session so that and provoke all of you to reform the legal education and produce very good lawyers, perfect judges, and perfect teachers. Thank you very much.
Thank you so much, sir. I am now nervous as to how should I speak, how should I walk. But before that, may I please request Ashima to present a token of appreciation to Justice Munda, please. Sir. Someone nautanki mein theek hu, sir. But we can collaborate on this, sir. Once for sir, please, everybody. Thank you so much. But I've been privileged to study at NSD Delhi here, and 3 साल का basis ये सब observe करो. We were sent to Delhi Metro every day in the morning for approximately half an hour to just observe a character and come back, and then just perform that. That's it. Very quickly moving ahead with our first panel discussion of the day on future of legal education, the industry perspective. While just setting up the stage, I shall introduce a panelist for the same. Dr. Sudhir Krishnaswamy, Vice Chancellor, National Law School of India University. Dr. Mukul Shastri, General Counsel, Cube Highways. Dr. Abhishek Sinha, Dean, UPES School of Law. Dr. Karuna Akshay Malviya, Director, School of Law, DY Patil, deemed to be University. Kritika Krishnamurthy, Founding Partner, AK and Partners. Pragya Parijat Singh, Advocate on Record, Supreme Court of India. Founder, Pranutan Legal. And this session will be chaired by Ashima Ori, Managing Editor, BW Legal World. And also because a lot of students are here, I'm sure you will want to ask, and you should ask a lot of questions to all our panelists who will be here all throughout the day. अगर आपको उस वक्त मौका नहीं मिलता है, you can always find our panelists all around, and then you can of course get hold of them. Take permission and then always ask. चलिए, let's please welcome our panelists together, everybody, on the stage. आपकी जोरदार तालियों के साथ. Thank you.
industry. From our keynote before, we've learned that law is only tip of the iceberg. What really is required to be successful in the industry, how do you become future ready, is something we're going to learn from the professionals themselves. So let me begin with Dr. Krishnaswamy. Dr. Krishnaswamy, I hope I'm audible.
Yes, I can hear you. Can you hear me?
Sorry, could we do a mic check with you?
Can you hear me now?
Yes, yes. Warm welcome, Dr. Krishnaswamy. Let me begin with the very, question, that very significant question. What are the most significant opportunities and challenges facing the legal education system today? And then can we crystal gaze 5 years from now and understand what will legal education look like 5 years from now?
Sure. Good morning to my fellow panelists, as well as the audience who are sparing us valuable Sunday morning and in the room, to Business World, and for the invitation and pulling this Future of Legal Education Summit together. So I think that it's an honor to follow Justice Mida, because I heard him emphasize what were, to me, evergreen, classic orientations and skills that we would emphasize in lawyering and legal education. Nothing newfangled or, necessarily contrived in the last 5 years. And I suspect that the purpose of this panel is to broaden to focus the conversation a little bit more in assessing some of these opportunities and challenges, and also looking ahead. So let me go at this prompt in a few ways, and I'll try and take just 5 minutes. So I think the optimistic part, and I didn't get a sense, and I haven't had the opportunity to discuss this with Justice Mida, whether he thought that legal education was getting better or getting worse. And my perspective on this is unambiguous. I think legal education is not just going through a growth spurt. We're seeing newer universities and newer colleges in the space, but we also have more talented students and a better infrastructure in legal education than we have ever had, I think, historically in this country. And my view on that is that's all for the good. There is a new generation of young people coming into the profession. They will transform this profession from really low points of the 50s to the 80s. And so I think that in that broad sense, my assessment is that there are very significant opportunities ahead for the students in the room and for all of us who are engaging and educating them on a daily basis. What are the other opportunities? I guess we've been hearing from the Bar Council for some time now that they intend to globalize access to the legal profession. Those of us who follow this kind of regulatory news carefully, we would have noticed last week that there was another announcement that we might open up to UK lawyering, maybe through the FTA. It wasn't very clear from the announcement exactly how this would happen. But this is very significant because I think that Indian lawyers will have the opportunity to develop cross-jurisdictional practices. And this is a very significant opportunity in the near future. What are our challenges? And I'll emphasize a few and close and hand back to you, Ashima. Justice Mida already spoke about teachers, and do we have quality young teachers in entering legal academia? Here, my concern is not so much that young talented people are not interested in joining. They're interested in joining. And if we open the doors to that kind of talent, we would all do well. The challenge is that we don't have a good canonical set of materials that we teach. We don't have a strong textbook, casebook tradition. So young teachers are going into the classroom with very little scaffolding. And then what we are getting across the various law schools is a highly variable quality of delivery. And I think that all of us who are in legal education do very well to invest collectively in developing this canonical set of materials. We can vary pedagogy, but if we put really strong materials into the classroom, we can assure quality in a way that has simply not happened across the last 70 years. And so I think that's a core challenge. And if we grasp that challenge, we would do very well in legal education. There are two other things that we might have done a little bit of, but maybe need to do more of in the years to come. The first is the experiential learning bit. I think most law schools have struggled with this. I mean, we all do the mandatory courses, we call them clinics or some such thing, but we're not very good at parsing the three main types of experiential learning: simulation-based courses, clinical courses. And a clinical course is a clinical course only if you're doing live cases. And so all there's a rather elaborate sort of pretense about doing clinics with no live cases in the classroom. And I think that whatever else we do, we should not call them clinics. We can call them something else. And the third part is to do a very rigorous model of externships and internships into the curriculum. This too exists, but we need to do this better and more strongly. So this, I think, is a core challenge. Apart from the core canonical materials, we've got to get this experiential learning part of any professional school has to be very strong at experiential learning. And we've done this less well than we should have over the years. The last point that I'll make and hand back to you is about the place of technology. Now, I know that a lot of noise is made, and we have to kind of distinguish between the hype and what might be real and meaningful. But let me just say that even for many of your panelists, I think have gone through at least 4 types of changes so far. Most of us started our legal education with a strong paper databases model, the reporters, and very quickly we've adapted to electronic databases. We've also adapted to the internet, and reasonably well. I think Indian law schools have taken to these technologies reasonably well, and I think we're at the cusp of a sort of AI-driven a reset on the place of technology in law. And it's very important that we get this transition right. Also because it promises to be bigger than electronic databases and the internet put together. It can be particularly disruptive to legal education and to the legal profession. So my sense is 3 challenges. We'll need to rework the technology question. We'll need to get experiential learning gridded right, and we will need to reinvent the legal canon in a very substantive way. I think these are our 3 core challenges, because with the new energy and a sort of different kind of political economy developing around legal education, I think the general sense of direction is very positive. Back to you, Ashimi.
Thank you, Dr. Krishnaswamy. What I hear from you is that there is quite a need for reorientation of our system to the AI that's on the horizon. Dr. Abhishek Sinha, you've joined us. Thank you. I thought you were away from the panel. So a warm welcome, and I can pose the same question to you as well. Do you feel that the evaluation system in today's time requires a relook? Also, taking from what Justice Midda said, that putting someone through the grill of a moot court or laws or problems that do not exist, fictitious problems, that's what we're assessing students on. To your mind, what needs to change to really evaluate a student who is future ready?
That's a very relevant question, and it's not just an issue of whether the way of evaluation needs to change. I'll take a step back and talk about the entire way of imparting legal education needs to change, right from the curriculum, the way we are teaching law in the classroom, and even outside the classroom. Barring few colleges in India, the pedagogy is more about theory. And what Dr. Sudhir also highlighted, when we talk about experiential learning, clinical legal education, participatory learning, if you look at the curriculum which has been prescribed by, the governing body or regulator, whatever you want to call it, there are a handful of subjects which are set out. Even if you look at moot court or internship as a subject, we may turn a blind eye, but we exactly know what really happens in these internships. We may or may not talk about it.
So you have a bone to pick with the industry on that.
Absolutely, because just to give you a quick flavor, before getting into academia, for good 18 years, I was a partner with India's top 2 law firms, Khaitan and Company and Shadul Amarchand. So the idea is that when we talk about who are the relevant stakeholders when it comes to legal education, we'll say Bar Council of India, law schools or the universities, which includes the faculty members and the law students. The bigger question, more than evaluation, is where is the industry? Why is industry not a relevant stakeholder when it comes to legal education? I'll just quickly draw an analogy. Look at medicine as a profession. A college, imparting MBBS kind of a course will not get the license or the approval to actually run that course unless and until a hospital is attached to that university or a college.
Right.
For legal education, there's no requirement of someone having practical experience, actually who has practiced law, that they must teach. Is there any such requirement? No requirement. The only requirement is, have you done your LLM? Though UGC has come up with this concept of professors of practice, several law schools have appointed. We have also appointed top managing partners, top partners, but we all know when it comes to classroom learning, for the entire semester, when someone needs to explain that, construct, they explain that course to the students, we need that kind of involvement in the classroom. And of course, we have moved, as far as the evaluation is concerned, we have moved quite forward. Right now, everything is on a continuous evaluation basis, and that's brilliant. But the real question is, and I'm talking about generally all the law schools in India, the real question is, what is the quality of those, question papers?
Yeah.
Are we meeting that standard? Will it make the students ready right after they graduate to actually go ahead and stand in a court of law and practice law? So that's my quick, response to that.
Thank you. Thank you, Dr. Sinha. Let me take that question to Dr. Shastri. You represent the industry on the panel. Dr. Shastri, clearly there's, thought on with some of our panelists that in the industry, intervention is missing. What do you have to say about that, and where can we bridge this gap?
Thanks, Ramashma. I was taking a cue from what Abhishek has said, and he has really pointed out a very important thing, that where is the participation in law schools of the industry or of the practitioners? Now, first of all, I also would like to take a step back and to understand that in the modern world, what are the options available to a law graduate? What all you can do? And I thought, like what Medha said, he just argued about 2 points, that you can either be a judge or lawyer, or you can be a legal academia. But that is not what all the legal education is catering to. You have a huge industry where there's huge, what you call a scope for law graduates to go and join as in-house counsels, to be GCs, to be a legal journalist, to go and join as a legal tech partner, and so many options are available. So modern worlds, it is no more the old mentality where you have to only go and become a lawyer. So first we have to change that mindset. I understand that BCI right now is not willing to have lawyers or that kind of facility like in MCI has, that you have to have a practicing lawyer attached to the office, then only you can impart legal education. This means like a national law school has to also give services to the legal industry. That facility is right now not there with BCI. But then they can partner with industries. They can definitely partner with various corporates, whereby corporates are more than ready and willing and helpful to come and join, first of all, as faculties, the partner faculties, and second, to join these national law schools or top law schools, whereby we can give our work to them and we can take the expertise of the professors of those law schools, and then professors can make the students work on those problems. So that kind of partnership definitely can be there between the industry and the law colleges, which no one stops.
Right.
And industry also is open to such kind of ideas. That is what I will just rest my thought. I know the time is very short.
I will take, I hope we can increase the timer by 5 minutes, please. I'll need more time to go around the panel. Dr. Shastri, one more, if you had to pick two important or essential skills for somebody coming to your team as an in-house counsel, what would that be?
So the skill sets are just as Midas said, obviously the fundamentals of law has to be strong, the communication. But more than that, it is the business acumen. The mindset has to be there, that you have to come and adapt. Because once you are in industry, you are no more just a lawyer. You have to understand what industry you are in, what are the basics of that industry, and then have to give your legal solutions accordingly. So that adaptability to the business side is the most important key which is there. And second most important key, at least what I feel, is the technology. You have to be a technology savvy person, because I feel the time has now come. In 5 years, the entire legal industry is going to get disrupted. The AI is going to take over. All those basic mundane skills of drafting and researching is just going to go out of date. You have to be more intuitive, more strategic in your approach. So those are two important skills that which I think so industry requires.
Thank you, Dr. Shastri. I hope our students are not disappointed to hear that. That they need to be absolutely disruptive in the way that they are going to build their own careers. And on that, I'm going to take the note of business acumen and the idea of fostering a culture of innovation and entrepreneurship in our students. I'll take this question to Kritika first. Kritika, how you've built a law firm of your own, and we've discussed how the industry expects these students to have business acumen. Now, how do you develop that? Do you have some suggestions for the institutes that can help you bring in some of these students to a firm like yours? That's one. And second, suppose they want to venture out into building a firm of their own from day one. What do you think can be done for that?
I think that's a very interesting question, Ashima. The answer is not very straightforward. If we talk about startups generally in the world, you have to know that 99% of them fail. They don't fail because they have a bad idea. They fail because of so many other reasons. One of the top reasons for failure is the failure to communicate with each other, leading to disputes either within the shareholders, with the vendors, or something like that. So learn how to communicate. I'm very afraid. We have spoken so much about technology and also about my interaction with the present generation. I'm afraid of the day when cross-examinations happen on WhatsApp. Or I'm afraid of the day when a lawyer
already have a WhatsApp university, so we can have a WhatsApp courtroom now.
Oh, we already have that. Lovely. For example, when we are taking interns nowadays, we ask, okay, how many internships have you done? Of those internships, how many were actual full-time on-site?
Yeah.
And then we count only those. So you get the hint where I'm going. And so you need to learn how to communicate with actual human beings. Be persuasive, be able to express. And I keep telling people, if you need 2,000 words to explain something, you probably haven't understood what you're trying to explain. Can you do that in, say, 150 words for me? Right? So that's the kind of communication skill that we are really looking for. And the Brits are coming again. And when you enter the London airport, the first thing that you see is a hoarding. It's of someone, it's of a person who's saying, I love to swim in the lake when it's freezing minus sub-zero temperatures. It's their culture to be gritty, resilient. They can survive wherever you put them. They survived for 100 odd years in India, remember? And so we're looking for people who not just have basic skills of knowing how to read a statute, interpreting a statute, but also this personality skill of being resilient, being willing to have hustle. So startup is a hustle culture, remember guys? So having hustle, having grit, having resilience to be able to do that, because behind all these suits and these flashy watches and handbags are brilliant, brilliant minds. All those people you see at the top of this profession, they have amazing original minds, capable of their own analysis. And they're not going to be swept away by AI, because the AI absolutely cannot replicate the way they think.
Yeah, HI over AI. So
Yeah.
thank you, Kritika. I'll also bring in Pragya on the same question. What in your experience, Pragya, is beyond a hustle, communication? What are the things that you need to make a place for yourself in the fraternity?
I think, Ashima, this begins at the law school. First and foremost, I feel it is very, very important to have academic freedom at the university. We need to have a free space where there is a minimal state intervention, and then only there will be a free flow of ideas. The line has to be a little blurry between the pre-existing notion of a teacher and a student. Only when you give that sort of comfort to the students and to the teacher, they are probably being their best self. They are more creative. It takes me back to my orientation day at University of Cambridge. The first thing that they told us on that day, other than the fact they said that, I know you all must be feeling that imposter syndrome, but we don't want you to, we know that, precedence is a source of law. But we don't want to manufacture students who follow the same path, or you are not able to replicate something new. There has to be some sort of semblance between creativity, critical thinking, and at the same time, your soul should be absorbed, whatever you are producing. So law school, right now, I feel, must have some sort of pedagogical acumen that is able to deal with contemporary legal issues. A couple of changes that I've seen over the period of years are quite applaud-worthy. This is a new thing that they've started with, that there is a assistant professor or an associate professor of practice or legal studies. For subjects like CPC, CRPC, pleading, drafting, conveyancing, somebody who's not gone to the court might probably not be in the best scenario or situation to tell the practical aspects of how it actually takes place, how things actually happen in the court. So I had a brief stint at OP Jindal University, and despite the fact that I had a specialization in international law, I chose a subject which people usually don't want to get their hands into, which was civil procedure code. Unfortunately, when I was studying at DU, I don't know how I even cleared the exam, because when now I look back, I can't even recall one single thing what I had learned in CPC. I ratta-marrowed something and I puked it in the exam and got decent scores. That is what we have been doing. But when I started teaching at Jindal University, I was able to I don't know how much justice I've done, but I tried to show them what actual wakalatnamas look like. What is a process fee? What is what is the process you serve a summon to the parties? What is a plaintiff? What is a respondent? What is joinder and non-joinder of parties? Small, small things. But unless you don't go to the court, you will never be able to understand. Now, there are a couple of things, couple of startups like this project and initiative by National Law University Delhi, Project 39A. It is doing wonderful. It has collaborated with people from the industry. It has collaborated with students, with professionals, people from the legal guild, and they are making the best use of research, and then they are converting it into petitions. We are getting practical, solid results in order to achieve legal equality and justice. At the same time, we had set up a trial advocacy society at OP Jindal University. So the students are far away from reality. Law is nothing but common sense. So it's not just about substantial law, but also a mix of substantial and procedural. And henceforth, I feel my expectation to somebody who comes to my office as a entrepreneur, as a person who has started up a litigation firm, is that you must have that soul. First of all, you should love the profession. You should have that niche or knack that you want to do litigation. Number one. Number two, it is not important that you are just fixated with how the technology is going to be for the next 5 years. Of course, it's a challenge. But at the same time, you must remember that it's about creativity. What new thing are you bringing to the platter?
Thank you. Thank you, Pragya. I'll take that point to Dr. Sudhir. Dr. Sudhir, can we have your quick thoughts on the gaps identified by the panel so far on, how students need to really come face to face with how courts function or the industry functions? Your 2 cents on how that can really be done or is being done.
So let me try to come at these questions with a slightly different angle. I mean, I know that the panelists have all gone through legal education in India. Many of them have studied outside, and the one thing that I think might be common across their various pathways is that we should not expect an undergraduate degree, a BA, LLB, or whatever combination of 5-year degree, or the 3-year LLB to somehow prepare somebody who is tailor-made for one of your offices. I mean, I've said this before, it's slightly unpopular thing to say, that's not our job. Our job is closer to what Pragya closed with, which is, can we educate fundamentally strong, very creative, rigorous thinkers in the law? And that is the only insurance against a fast-changing field, right? The content of what we teach our students is going to change. So Dr. Mukul has done work on competition law at a time when competition law was an emerging field. And like that, there will be other areas that will emerge, new modes of regulation that our students have to be well placed to embrace and build on. And the way to do that is to focus on these core skills, right? These core ways of thinking, both theoretically, and I'm not going to disavow a theoretical understanding of law. That is fundamental to what the university is there for. So we would not, I think all of us would agree, you can't give up on that. So while I did mention that we should do a lot of experiential learning, I don't see that as a sort of a binary choice, which is that somehow we all have to pivot to teach all these skills, and then students should somehow now get jobs at a law firm and be highly productive on day one or something like that. I mean, I think that is a view sometimes taken of legal education or professional education. We must immerse our students in the professional field, and keep them. They have to actually learn the dispositions and the cultures of that field. That's what they have to learn. They don't have to learn what it takes to be, to fly off the shelves on day one or something. I think that's a sort of, at least to my mind, not the main priority for legal education. So I'll say one more thing that might be useful here, which is that to go back to the evaluation point that you raised early in the panel, I think this evaluation problem needs to be tackled, because the old universities, Pragya spoke about memorizing and producing answers to questions. I mean, what plagues the old university system is we know the questions beforehand because it's a subset of 20 or 25 questions. We also know the answers, and the answers are also dated because they're the answers that should have been written in 1985, because that answer is what will get you a very high mark in the old university system. So we have a serious problem there. And the shift away from that kind of testing to strongly hypothetical, problem-based scenario style testing is, I think, a sharp revolution that all of us in our various institutions can sign up to. So we insist in our evaluation that we do this, because otherwise you're not going to get these sharp thinking, creative lawyers at all. So I'm just mentioning two things that panel addressed that caught my attention. But back to you, Ashima. I know you have a tight time frame.
Thank you, Dr. Sudhir. I'll take that question now to Dr. Karuna. Dr. Karuna, we've heard the panel is kind of divided on the two sides. One is that the institutes are nurturing the students to be critical thinkers. And we also have the industry that has certain amount of expectation that on day one, students should be industry ready for some aspects of the work that they're going to do. Now, as a educator, how do you build a dynamic course for your students? What is, in your experience, the best way that has worked to keep them industry ready?
It's a very relevant question because at the D.Y. Patil University School of Law, we have a specially designed curricula from semester 1 itself. We are introducing drafting, pleading, conveyancing skills from semester 1 itself till the 10th semester, specially designed as per the subjects which are introduced to the students. For example, Contract Act. So we are teaching them drafts of the Contract Act at the same semester. Also, we have connected the industry advisory board and the advisory board in the form of mentors to our students, so that at the time of understanding the theoretical aspects of the subject, a student is also understanding that what industry is expecting or what I have to give back when I become a lawyer, when I take a profession as a lawyer.
Yeah.
So it is very important for any law school to specially design a curriculum which will make a blend of theory as well as the industry exposure, which a student, like ultimately after becoming a lawyer, has to give back to the society.
Absolutely. Thank you, Dr. Karuna. We'll wrap the session here. Thank you all for your insights, and we hope to be able to give back to the students some actionable points. Any quick question from the students that you'd like to ask our panel? I'll take one question only. Anyone? Sorry, I can't. Please stand up for a question. Yeah.
On the AI. So is the future is looking like the lawyers will be tackling the AI, like a case is held and one side AI is tackling the case and other side lawyer is tackling the case. Is the future is looking like that? And the new problem really developed that how to teach a student to tackle with AI in laws and other cases.
Thank you for the question. May I have your name again, please? Thanks, Adar.
Hi,
Dr. Shastri.
So just since I made that point, so there's nothing to fear. I'll give an astrological answer to this. Like earlier, to make our natal chart, there's a mathematical solution, like all these 12 houses, and you place the 9 grahas there actually. Now that itself was an art, and people used to do that manually. Now, today, anybody can do that. If you know your place of birth, time of birth, date of birth, a computer can do that. So this is what the AI can do. It is fed on data and it can give you basic things. It can give you the basic drafting, the basic research. That can be done. Some basic things that AI can do because it has fed on data and the data it can just reproduce. But the intuitive thinking, the strategy, where to use, how to interpret that kundli and how to give answers to those things, like in chess, that intuitiveness, that for an AI to take over, it will take some time from legal strategy perspective. So therefore, what my advice will be to young minds, that think about the intuitiveness and strategical aspect of law and not merely know that, okay, for this is this section only has this as the ingredient and there are 10 case laws for this section, more than how to apply that section in real life. And what will be the intuitiveness and strategic part of that? And likewise for any other thing, like if you are doing an M&A deal, what are the intuitive aspect of it, rather than knowing only the contract law? So that is what will give you more edge in future. Obviously, AI or the legal technology is there. It is coming slowly and gradually. And legal tech is playing a big role. In industry, we are relying on legal tech for a lot of things, for a lot of data churning out, for data analysis. AI is being used, and it is going to get better and better in some time. But then that intuitive part and the strategic part, that cannot be taken over.
Thank you, Dr. Shastri. Pragya, you have one thing to add?
Athar, since you are in your law school, I would say you must really focus on the new criminal laws that starts from 1st of July. AI would be coming in a couple of years, but I'm sure to say that it is your cortical prowess, it is your ability to think out of the box that will always overpower a system or a computer designed whatever artificial intelligence is. So make sure that you're not heavily dependent upon technology so much so that you're able to, that you've stopped thinking. That's my only piece of advice.
Thank you, Pragya. Thank you all. And to her point, we also have a panel on criminal law reforms coming up right after this. I'm sure they'll throw more light on the subject. So thank you all for joining us today. Thank you, Dr. Sudhir, for being online with us.
Thank you.
Thank you. Thank you so much. Thank you. And thank you so much, Ashima, for doing that. Very quickly moving ahead with the next panel discussion on navigating criminal law reforms and careers in litigation and also in judiciary. And to share their views on the same, please join me in welcoming on stage Pramod Dubey, Senior Advocate, Supreme Court of India. Joining him is Advocate Tanveer Ahmed Mir, Founder, Chambers of Tanveer Ahmed Mir. Joining them is Dr. Mohammad Salim, Dean and Senior Director, Lloyd Law College. Joining them is Siddharth Batra, Advocate on Record, Supreme Court of India. Joining them is Neha Nagpal, Founder, NM Law Chambers. And this session will be chaired by Pallavi Pratap, Managing Partner, Pratap and College. Please welcome everybody. You know, I personally feel कि in सबका जो experience है ना, that requires a huge round of applause, at least from all the students who are here and aspire to be here. Thank you.
और आदित्य का जो एक्सपीरियंस है वो शायद हम सबके एक्सपीरियंस से ज्यादा बेहतर है since he's been being complimented since morning about every little thing. Huh? Aditya, you have to do that skit thing that you do, not the drama thing from NST. You must show us something. Neha is missing, I think. Because Siddharth has a flight to catch. Oh, he has little time for us then. All right, I'm not going to give any introduction to Siddharth is a high flyer. Oh, okay. All right, so nobody requires any introduction because I think they are all such illustrious people over here. I can't believe that I'm actually sitting with all of them. And the topic that we've been given is so relevant and so interesting for today, considering that 1st of July, we see a lot of differences. Also, the SLP spending, the writ petition rather is pending where they have been asking for stay. I don't think that's going to come about, but nonetheless, I'll start with Siddharth. Yeah. My first question, actually not really the question, but I would want all of you to give just about 2 minutes about what do you feel with respect to the criminal law reforms which are coming about.
Yeah, good afternoon, everyone. It's a new legislation, of course. Everybody is anxious. Maybe some people are excited as well. There are a lot of changes that have been made. In fact, if you ask me today, in fact, to spell all these 3 new legislations, I mean, even in Hindi, even I don't remember. But of course, there are changes coming with the technological advancement. One of the speakers before us was talking about AI. But of course, I don't think so. AI has anything to do with the new reforms. But of course, some part of IT is being brought in where there'll be examinations through video conferencing, and a lot of other definitions have been added. And some major changes have been made as well Like one of the major changes is that when you come to rash and negligent driving, what has been added in the new penal code is that if the person driving leaves the site of accident without even reporting, that's become a major offense. So some changes have been brought in, going by the experience, what the government has thought proper to do. So let's see, but I think this is still too nascent to be commenting upon how and how it's going to shape up. Of course, jurisprudence is going to develop over the years. Let's see. I think it's a very new phase, and what Pallavi was saying about the petition pending in Supreme Court, I really doubt, because government has a very serious intention, and it will be applicable for tomorrow. So I think all in all, let's see. It's going to be a big change.
Thanks. Pramod sir?
Thanks, Pallavi. Basically, we were accustomed to adopt a particular jurisprudence since long.
That's right.
Now it's a demand of the day, and since we are developing everywhere in economy, technology, everything, so it was decided by the government that we should also match the international standard and development in the society, because the law can develop as per the society demands. There are three main stakeholders in this matter apart from the litigants. That's the one is that in the criminal law, that's the defense counsel, the prosecution side, including the investigating agency, and the judges. So there is a lot of apprehension in the mind of the defense counsel, because we are practicing as a defense counsel. We have adopted this habit for defending the accused persons. Some cases we are also acted as a prosecutor, as a special public prosecutor. So there is some happiness in one side, some stress on the other side. There's a different side, and the judicial side we have already come across, like you have just mentioned, that's a PIL is pending in the Supreme Court. And Siddharth has mentioned that we are not hoping so much the government is serious. Apart from the seriousness of the government, we are coming across the comment from the sitting judges who are going to adjudicate this issue. This is the apprehension in the mind of the people. Judges should not make the comment on this issue, because the list is pending disposal before the court, and they are the person they are going to adjudicate. Nevertheless, they have made the changes, major changes. There's a procedural law in the Bharatiya Nagrik Suraksha Adhiniyam. So the purpose of this name is you have to protect the right of the citizen of this country, Bharatiya Nagrik Suraksha. And in that, they have made a lot of changes so far the procedure, like the arrest, remand, date, all these things. Because in our criminal jurisprudence, what we have been taught from the college day, still we are learning the concept, the personal liberty. And the germane of the entire criminal law is Article 21. So to meet that, they have brought all these sections. And we as a lawyer, practicing in the defense side, we must be analytical. We should be ready to match the demand and do our preparation. Because if you go through all the amendments, the debate everywhere, so my advice would be whether we should be the critical, we should be analytical, and we should go ahead, because tomorrow we are going to enter into the new arena of the criminal jurisprudence.
Thank you so much, sir. Salim sir, what is your take on it?
Good morning, everyone. My specific say on the way new criminal laws have actually came up is very positive, because if I put up the perspective of a student from a classroom, a teacher's perspective from a classroom who is teaching criminal law to a generation of students in last 20, 30, 40 years, or in last 150 plus years, what we see is this is a great welcome change which we have brought in our society, which was actually very earnestly required, because a lot of questions which were there in the mind of the student when we were teaching criminal laws in the classroom were very generic, very simple, very logical, which does not actually require a legal acumen to ask those questions. And questions are always complete. Answers are always lopsided or one-sided, or there is requirement of reformation in the answers. So all the four corners which are required to be there in any legislation, every legislation is made on four corners. One is the object clause, another is the subject clause, another the third is the jurisdiction of it, and the remedies. So when I assess the new criminal laws on these four corners of the legislative process or lawmaking system or lawmaking corners, I see that these criminal laws have actually provided answer to all those questions which we were unable to answer from the piece of legislation, which were somehow we have to be silent on it, or we have to provide an answer from somewhere outside the jurisdiction of India or outside our legal system. And introducing these changes in BSA or BNSS or the Evidence Act, this is something which is actually taking us not only improving the criminal justice system in terms of the time, in terms of the technology, in terms of the justice, in terms of addressing the justice system rather than only the punishment system. It has actually created a vibrancy in the criminal law justice system in terms of all the stakeholders, as Pramod sir, who is in the practice side, is saying that we are in a better position to provide answers to the defense, answers to the victims also. So this law is a great welcome and addressing a lot of things which are required at this point of time and way forward for us as a law abiding or criminal justice system society. But there are something which required some of the aspects which are required to be addressed more. But as of now, we can say that experimenting on this law for next 10 years will give us better insight and better justice system for our country. Thank you.
Neha, you are so much involved in white collar crime. What is your take on it with the changes that are coming along?
So thanks, Pallavi, and thanks for having us here, Ashima. But see, I look at it with a little bit of trepidation, and I'm not trying to be, sort of take a very different position from everybody, but I'm coming from a place of concern, which is twofold. One, while we needed, the question I ask myself is, did we need a reform? Absolutely, yes, to the Criminal Procedure Code as well as to the Indian Penal Code, and of course, the Evidence Act as well. Therefore, it is a welcome change. But how is it going to today impact the course of justice? That is yet to be seen, because we will see multiple challenges to multiple provisions. And Dubey sir will correct me if I'm wrong, that we will, and even me, Mr. Mir here, that the bail provisions and the remand provisions are something which have to be tested over multiple times today, and there will be multiple litigation over it. Even the right today, there is a bit of ambiguity on the procedural aspect of the right of an accused in a complaint case to, prior to cognizance, come and represent himself. So all these issues are going to go through vagaries of the judicial system. My worry is the concern in the ultimate dispensation of justice.
Correct.
How are we factoring that in? But of course, we cannot lose sight of the fact that with the advent of technology, with the advent of things like deepfake, with the advent of AI, we needed to upgrade our criminal laws to provide for offenses which will arise from things like this, which is AI and deepfake related. But at the same time, we have to be very careful and mindful as practicing lawyers of the burden on the system because of the delays that may or may not arise.
Yeah, I mean, I think basic fact of registering an FIR also, I don't know how equipped are our police officers to even, go, how much of capacity
as a power being diluted now.
So many things are there now. And I think Tanveer sir would be better equipped to inform us exactly what challenges are we looking at in terms of the law reforms that are coming along, sir.
Thank you very much. So, my take on, getting these three pieces of very important law, which has a direct interface with every person and citizen of our country, directly affects about 145 crores, is that the objectives which are stated in these three laws are not clearly defined. It seems to me that what the government is trying to do is to simply say to do away with colonial laws. And if what we call as colonial laws were so bad, then how is it that we have retained almost 90% of the old laws? Or the same laws which are applicable everywhere in the whole world, wherever Commonwealth is. The core concepts, core definitions are same. It seems to me that certainly with the the progress of technology, the new technologies must come to the fore for expeditious justice delivery system, and new amendments could have been welcomed. But what I see in the substantive law and substantive procedure is also a bit of enhancement or an intent to make our country a more a kind of a police state. I'll give one example of that. For example, in whenever there are custody deaths, unfortunately, a woman is raped in custody, police otherwise. There is violence in communal riots. Police accountability, executive accountability to the people of India. In 2005, the legislature amended 174 and brought in 174(1)(a), which covenanted that any time there are such heinous offenses, besides an inquiry by a magistrate under by an executive under 174, for example, in the case of a suicide, there will be mandatorily an inquiry by a judicial magistrate or by a metropolitan magistrate. So very simply, judicial magistrate first class in a state is equivalent to a metropolitan magistrate in a metropolitan area. Now, what the government has done is done away with the judicial magistrate and left it to the executive magistrate. So we don't understand, why have you taken the judicial magistrate out of the inquiry and left it to the executive? There is only one reason, that the government felt that the judges will always be a problem for us, but executive we can hold. Similarly, we had a judgment from the Supreme Court, Lalita Kumari, which said that any time a first information is brought before a police station, which discloses a cognizable offense, police should investigate a case. The 5 judges bench, where a lot of legal community labored, the judges toiled hard, wrote some very authentic, important judgments, have all been sought to be wiped out. Now before an FIR will be lodged, there is going to be a preliminary inquiry. What we irrefragably understand is 2 concepts in this initial statement is that, number one, when you give more uncanalized, unbridled power to the executive, power to the police, even the Supreme Court judges have 100 times said, even in Arnesh Kumar's case, that it is a seed for more corruption. So constantly, as the society progresses, whilst policing is important part of justice delivery system, there is also checks and balances. Secondly, even by bringing these 3 laws, the justice delivery system is not going to improve in our country, because the problem does not lie with defense lawyers or with the prosecutors or even with the cops. The problem lies with infrastructure. Infrastructure is what today in our country is less than 2 dozen judges for over 1 million people. The 40% sanctioned strength of high courts is vacant. I'll finish this with one example. The Allahabad High Court, Lucknow High Court is hearing a criminal appeal in 2024, which was lodged in 1988. Why is that so? That is because if Allahabad High Court has a sanctioned strength of 170 judges, for last 2 decades, you never had more than 80, maybe 110. So virtually, the fact of the matter is that the governments consistently, whoever may be in power, they are not willing to invest in the infrastructure of justice delivery system. They are more interested in something else. Now, insofar as change of forensic laws is taken into consideration, that's more than welcome. That we can deliberate later in the debate. So I personally, as a lawyer, as a citizen of this country, feel that none of these 3 laws were absolutely needed at all. You could have retained the old laws. If you just want to change the name, we don't have a problem, if that's your problem. But what you could have done is you could have made suitable amendments, just as previous amendments were made, based on situation. Revamping the whole law, throwing the same law in the dustbin, and getting the same 90% law again with some amendments doesn't make any sense at all from anybody's perspective.
Thank you so much, sir. Pramod sir, I have a question with respect to, how the law now changes from 1st, which is tomorrow. A lot of professionals are finding it difficult to keep themselves up to date. What is it that is, since you are a senior advocate and you've had so much experience with it, what is your word of advice to all the young lawyers also who are here as to how they should acclimatize to the changing environment?
I come to your question. First, Neha has flagged one issue, that is the summoning of the accused at the complaint stage. The law as on date today, that is 30th June. If you are filing the complaint under 200, so your statement would be recorded. That is called the pre-summoning evidence. And the pre-summoning evidence is recorded. It's a deemed taking cognizance. Unless and until you have taken the cognizance, the magistrate had taken cognizance, your statement would not be recorded. After the recording the pre-summoning evidence, the judge has to examine the material, that is the pre-summoning evidence, documents and the complaint, and then decide to summon the accused or not. But in the new law, which Neha has just flagged this issue, in new law, what they have brought, that at the time of the taking the cognizance, the court will hear the case of the accused, the prospective accused, and after hearing the accused, then court will decide whether the cognizance would be taken or not. So without taking the cognizance, how you can call the accused to put his defense at the nascent stage, at the stage where the court is itself not decided whether the prima facie case is made out or not. And if the accused is coming before you, disclosing his defense, there is adjudication on the dispute. And if you say, no, this is the case for the issuance of the process, so you are basically keeping aside his entire defense, the prospective accused. And this will also give the opportunity to challenge the order. There would be the multiplicity of the litigation.
Correct.
Mr. Mead has just mentioned that this is the infrastructure, the enforcement agency, that is the lack of the judicial officers in the different high court. Even in our Delhi High Court, their strength is, sanction strength is 60. We are somewhere around 40, 41. So you don't have the judges. Every day you are singing the song that is the pendency of the matter, pendency of the matter, pendency of the matter. But you are bringing the law which is going to be very complex. So I don't think how this act came into the picture. There must be delegation on all these things. The intelligent mind must have done all these things. We are not going to criticize here, but now I'm coming to your question. There is a 248 Law Commission report that is in 2023.
Right.
Bharatiya Saksh Adhiniyam, and there was some dissent also. So, and then 268 Law Commission report, 277 Law Commission report. So these all were put before the amendment came to the picture. There is a dissent also in those reports. So being the professional, we should also analyze the what were the dissent. And with the dissent, we can develop our case. See, I'm very optimistic. I won't say now the law is there, the president has given the assent, the law is going to be enforced midnight today itself. Today midnight, that's the. So I'm not going to say they should have not brought, they should have kept earlier law. I'm very optimistic. I have the firm belief, seeing the performance of the new law, the legislature would certainly bring the amendment in the law, seeing the performance, how the executive is doing these things, why the police agency, how the judiciary is doing. Because see, I have very simple philosophy in my life. There is always blessing in the disguise. And once you have developed the habit of finding the blessings, you will find everywhere blessing, you won't find the disguise in your life.
So beautifully said.
So, being the defense counsel practicing the criminal side, we have to be very optimistic and we have to be very analytical, which I have already mentioned. We always should be the high quality, the professionals, the lot of information are there because we have gone through so many draconian law, stringent law throughout our career, like the Kota came, Mokoka came, Tada came.
That's right.
Now the PMLA is there, SFIU, Companies Act is 2 and 2. These all are the stringent NDPS Act, Wildlife Protection Act. There is a clean condition. There's so many things. They are depriving the right of the citizen, UAPA. So we should not be so pessimistic. We should be optimistic. We are going to face the consequences. We are going to assist the court with the full strength. And our judicial system is very liberal. They decide the right of the accused. It is not like that we are entering the police society. Of course, there is a check and balance because the judges are also the part of the society. And they know what is the problem going on. They have the materials. They will have to educate everything. So the judges, lawyers, all should be the high court.
So before you miss your flight, I might just want Siddharth to add because you both are in the same flight and I don't want both of you to miss. Oh, okay. Oh, I thought he said that both of you are. But let's just not make sure that Siddharth doesn't miss his flight. So therefore, Siddharth, since we have a lot of law students here and you're a young, bright lawyer, would you like to share some snippets or some pointers for them so that, they can benefit out of it pertaining to criminal law reforms or, anything specific to that?
So you have the best panel here, starting from Mr. Mir, Mr. Dubey. Of course, the pessimism and the negativity, but I think I will remain in the middle. There's, of course, when these three laws are concerned, there's anxiety among the society. And maybe for Mr. Dubey, more stringent, more the money. So, I mean, of course. So, and though I tend to agree with what Mr. Mir said, that ultimately we may be reduced to a police state, which we do not want. If 90% of the laws are similar, then why did we need a change? Coming back to what Pallavi asked me about the profession, I think all of you are in a journey which has just begun for you. And this is one of the brightest professions we have in our country today. And earlier also what our Justice Midha said, retired judge of the Delhi High Court, if you've heard him, he said that, look, here you get paid to talk. You get paid to argue, you get paid to interpret. So it's a beautiful profession, and the way things are going in the country, the way economy is going, of course, this is set to grow as well. We are maybe a generation down with Mr. Dubey and Mr. Mir here, Pallavi is there, Neha is here. I think over the years, the profession has completely changed, not in terms of how the courts have started to function, but of course, with the increasing number of disputes, the way Indian economy is going, of course, we have the best experts on the panel today, white-collar crimes. White-collar crime is such a big deal today. And the new legislations which have come, whether it's the PMLA or what the SFIO is doing. So in criminal law also, it's much more to do than the Indian Penal Code. So I think sky is the limit. I wish you all the very best of luck, and I think you're going to be in a great profession. Thank you.
Thanks. Salim sir, my question to you is, now that, all of these changes have been brought about, how is it that as, professor and handling as a dean of a university, how is it that you are handling, how is it that you are coping up with it, educating the students with the new criminal law reforms that have come? How as an institution are you able to handle it, sir?
Okay, ma'am. I would say that because the new criminal laws has actually created a new world for whether there is in terms of practice and experience, yes, there is a difference between a student who is passing out this year and someone who is practicing from 20, 30, 40 years or 10 years. But in terms of the new criminal laws from tomorrow onwards, the learning has to be restarted for everyone. So the post to start is for everyone. He's a 10, 20, 30-year practitioner or a judge who is listening the matter or who is going to adjudge the matter, or a teacher or a student. So for everyone, the post has restarted actually. And there is a great scope for the law students and the teachers and for everyone. Apart from this, there are a lot of aspects which are going to be challenging for the law students and law teachers and law institutions. And we have already been doing that since last 2 months. We have been instructed by the Bar Council of India. We have got a letter from the Ministry of Home Affairs that we have to start the training program. And we are not only training our teachers, we are not only training our own staff, but we have started training the judicial officers on that. After the training of our teachers, we have started training the advocates in through the DLSA. We have started training of jail officers. We have started doing the programs in jails on the new criminal laws. So this is the last part that we are going to start the training of our students in the time to come. We have already adopted a lot of training frameworks which have been directed to us by the Ministry of Home Affairs, directly by the Ministry of Law and Justice. So Ministry of Law and Justice is directly involved in with the law institution, with the legal education institutions to adopt the new criminal laws and start training programs for all the stakeholders. And we have been doing since last 2 months. So there's no problem in that. But what I see is the changes which have been brought are very understandable to the young minds of students and young lawyers and in the modern time, because a lot of things are pro-technology and a lot of things are something which are like e-courts, like one of the most important aspects which have been addressed by this by these laws is speedy justice in terms of timelines, which was lagging behind not only because of the infrastructure of the court, but also because of the problems in laws and the implementation of laws. So one side of the criminal justice system in terms of delay in justice is addressed, and I hope with the infrastructure to come and government is very proactive in terms of providing the better infrastructure aligning with the new criminal laws. So I hope the infrastructure will improve, and with that we will see that both the sides, the better laws and the better infrastructure of the judicial system, will be able to address the problems of the lagging behind and delays in justice system, especially in criminal laws.
That's
Thank you.
beautifully said. Neha, on that note, that since it's going to be day one for learning for all of us, how is it that we learn and unlearn and learn again? What's your take as a professional and especially as a criminal lawyer? What's your take on it?
So, when I was just about starting the profession, I was told by one of my mentors that there is going to be no shortcut to reading. So now coming back to learning again, because certain things we just knew on the tips of our fingers and we took it for granted, like Lalita Kumari or Arnish Kumar. Today we have to be mindful, that we are learning again. We shouldn't forget what we know because we need that still. And 3, we shouldn't get confused between what we knew and what we're learning now. So I think the best way of going about it is really just, and we have access today to so much, the students today have access so much more information and authentic portals that we didn't while we were in schools and colleges. So I think live law and bar and bench is something which should be a must for all, even us, for us as professionals to keep abreast. And opinion articles that are written, and of course, picking up a Bear Act and reading it for yourself. I think there's really no substitute to that. Investing the time in it if you want to go make a go of it.
That's really nice. Tanvisa, you are one amazing criminal lawyer, and I really want that the students here actually get tips from you that you would like to share with them.
Well, the student community which will be who will be passing out in next couple of years, maybe 3 years from now, 4 years from now, and the moment you join the bar, you will have two kinds of cases that will hit your desk. One will be the cases which are pending as on date, which means at the strike of 12 o'clock today in the night. So cases which are already registered, cases where cause of action is already registered, which means that the offense has been committed prior to the law coming into the force. You will have to deal with those cases as according to the old law. And the cases which are registered, which means criminal felonies, which are committed and reported, which are actionable, cognizable offenses, non-cognizable offenses, which happen post the midnight today, you will have to work on new laws. So you will have to be abreast with both. The student community is best served in the university by having good, grasp on core concepts. In terms of the law professors teaching you basic constitutional rights, basic frameworks, basic concepts of, I went once to some university just to talk to the students. And I asked a gathering of about 800 students, what is evidence in a court of law? So unfortunately, nobody was able to sort of, raise his hand. Well, very simple, a witness who is permitted by a court of law to step into the witness box, take an oath and testify on a relevant oral account, and a documentary piece of evidence which is brought for inspection of a court in its original or secondary form. So, as Neha correctly said, is that there is no alternative to reading and contemplating the core concepts. Then their interplay and interface with factual scenarios as to what kind of law will apply, what will be the proper procedure under which the facts will be molded into a particular petition and filed before a court of competent jurisdiction. And there you are, there you go, and there you start. So this exercise is for now for all of us, because we have to back and read. But in the larger perspective, what is important today for all of us, as I said, is that any stakeholder, whether he's a stakeholder in the first court, in the appellate court, in the revisional court, in the Supreme Court, as you are, will now be dealing with old cases for next about 30 years. New cases post this midnight.
True, sir.
So every judge will have one set of laws, one set of judgments, one set of Bear Acts on his right side, one set of Bear Acts on the left side, and his ability, his desire to have brilliant assistance on tips from lawyers, from police officers. So the job of the judges and the stakeholders in the justice delivery profession, including the law professors as well, will be doubly difficult. But we have to be optimistic, and we have to be up to the challenge, and therefore game on. So let's go on and get to do what we do at our best. So let the student community ride the wave, have their core concepts. And when you hit the field, when one case that you do end to end, makes you a very strong lawyer. You grasp the concepts, you grasp the procedure, and then, nothing is then difficult. The only problem which I see is if you just take any, tomorrow, all these students can accompany us and practically see what happens in the district court. Say you go to a court of session in Patiala House Court, only a walking distance from here. There is no sessions court in India or a magisterial court in India, which on an average does not have at least 70 cases, 60 cases a day.
Yes, sir.
If you, out of 70 cases, have 25 cases where evidence is to be recorded, which means witnesses have been summoned, they are to testify, the lawyers have to cross-examine. Sometimes a witness will be cross-examined for half a day. As a concomitant result, the judge has to then mandatorily adjourn 19 matters. See, we don't do a jury trial in India where a jury is selected, then the jury is sequestered. The jury can't go back home, and the jury will be there till the trial comes to an end. So, core problem for justice delivery system in terms of expeditious is in lack of infrastructure. So, if a judge who is handling serious crime has 7 to 8 different murder trials in a day, how many witnesses will he examine? If a judge of the High Court has more than 100 cases, he's not a robot. You can't end AI to a judge. Ultimately, the judge is to decide on the basis of evidence. See, no human being can do about more than 40 cases a day, even as a judge. You're stretching it. The new laws will come with an explosion of petitions. And then a judge who had 120 will have about 180 cases now. But that's the reality, so let's face it.
Thank you so much, Tanvi sir. On that note, we'll just say thank you because Siddharth's about to miss his flight and he's probably going to hold BW legal responsible for it.
Salim sir, leader aa gaya na?
Thank you.
Thank you.
I hope you catch your flight. Safe journey.
तुम्हारे कोई करेगा.
But thank you so much, and thank you, Pallavi, for doing that. Very quickly, moving ahead for our next panel, it's on developing industry-specific legal skills, in-house perspective. And to share their views on the same, please join me in welcoming on stage Dr. Akhil Prasad, the Group General Counsel and CS, Boeing. Joining him is Amar Kumar Sundaram, General Counsel, Senior VP Legal and Chief Compliance Officer, NEC Corporation, India. Joining them is Debasmita Nandi, Head Legal, Cinepolis. Joining them is Mirul Bhavsar, Head of Legal, Manipal Academy of Higher Education. And joining them is Utkarsh Kumar, Principal Associate, Cyril Amarchand Mangaldas. And this session will be chaired by Rohail Amin, Senior Editor, BW Business World. Let's please welcome everybody to the stage. आपके जोरदार तालियों के साथ. थोड़ा और जोश, can we like put some more effort? Yeah. Thank you so much. Thank you. Please ask everyone to settle down. Bani, can we just sort of... Read, sir.
One is extra.
One is extra, sir.
एक हटा दो.
Rohit, just will request a check on the timer, please.
Sure. I think, wow. She made 15.
Listen,
Right.
the timer is absolutely not in
The
my hand.
problem is I'm dealing with lawyers, people from the legal world, and to stop them, I mean, in 2 minutes, it's impossible. But
आज lawyer बन जाओगे आप, कोशिश करो आज. For all the best.
all right. May I request people to just settle down so that we can start this conversation?
And we have the audience, a lot of students here, law schools, and on this side, people who are from the practical side, who have crossed over from their days in-house. So let me stick the basic questions, starting maybe with the ladies first. Maybe with you first. How have you see the legal education system, and you see the in-house careers, do you think they are trained enough and they are getting ready enough for this? Is there any big gap, any big concern that you see that needs to be addressed?
Thank you for the first opportunity. I'll be seeking from the first-hand experience. When I stepped out of law school, I had no idea what the in-house legal practice is all about. And after so many years of experience and being into education for good 7-8 years now, the situation hasn't changed. So I'm not very happy to make that comment, but yes, in fact, I'm taking this opportunity that being into education sector and advising them as an in-house, there is a lot that we need to do, make student and legal education industry ready as we speak. And we don't have to look far to take examples or inspirations. Say our professions which are quite competitive and you can say very complementary like CA and CS. Most of the students, they hit the ground running. And that is something that we need to achieve in legal profession as well. And in last, 3 panel discussion, I don't want to repeat that we are far lagging in that area. So there's a lot needs to be done. In the first session, Justice mentioned that along with the legal skill, we also need to train professionals for the people skill, the business skill, and the communication skills. So if we want to make lost students and legal professions industry ready, there is a complete overhaul in the legal education that is warranted. I would make that candid, you can say, confession from the industry. We have a very clear demand and supply ratio where the in-house are looking for lawyers who are who can fit into their scheme of things, and there are law students who are looking for placements or their you can say professional ahead.
Right.
So yes, there is a lot that needs to be done.
Right. Dr. Prasad, your initial comment on this, do we have enough training? Do we have the quality training at the education institution level, for making in-house careers?
My first reaction is, so when I studied law, this was in the 90s till now, I think there has been a sea change. And I should admit, the kind of institutions now, what we have today, is a far change from what used to be earlier. But the point is whether that is enough. So we have the national law universities. We have now the private institutions who have come up with in a very big way. They have really transformed the way the law is taught. But the question is, the first question, I want to come back to is general counsel or an in-house counsel. Today, in-house counsel is not even recognized as a lawyer, because the Advocate Act doesn't recognize in-house counsel as a lawyer. So whatever we have been hearing in the past 2 sessions, we were only talking about advocates. We were not even talking about general counsels. So if a general counsel does not exist in the eyes of law in India, how will the legal education look into the aspects of a general counsel? So I think we have to fix the problem first. First, recognize the general counsel as an advocate or a solicitor, and then think about what should be the ingredients of becoming a successful in-house counsel. In my own experience, I think we should not blame what is not there. The institutions will do, because institutions will also follow a process of the Ministry of Education. They will mandate, the Ministry of Law will mandate what the course should be. But for each one of us, is there an obstacle today? It never existed in my time. Why should there be an obstacle for you? If I was able to still do 11 degrees and, try my best to enhance my professional capability. Today, situation is much better for all of you. Today, you can go to any part of the world to achieve your dream. And that is what I would say, that if you have to become a successful lawyer, don't only think about a lawyer, you have to think about being a problem solver. How do you become a good problem solver for your client is the most important thing. For which you have to think what are the skills that you need. Somebody said communication, somebody said something. But I think there cannot be a template. There should not be a template. I think from the feedback that you get every day from your client should be a wake-up call for you. For instance, I was said many times when I was working for Modi Xerox, which was a joint venture, people used to say, and I then left Modi Xerox, I came to Electrolux. When it came about assessing my capability, so the Electrolux organization said, you are not a lawyer in UK. You are not a lawyer in US. They are paid more. So that was a wake-up call for me. So I said, now I should learn what is in UK, what is in US. And today nobody tells me that. Today they say, our global practices, you are being paid what a US lawyer is being paid. You are being paid what a UK lawyer is being paid. So for me, that was a wake-up call. What is it that I need to do? Whether a law college is teaching that or not teaching that should not be an innovation. You have to introspect, make a resolution every year that this is what I want to change in myself. And that is the scope of education that you should pursue. Let's not say that what law is not teaching, law schools are not teaching. What you want to become is more important for me.
You want to add? I want to add to what Akhil has just mentioned is, yes, in-house lawyering require more of self-learning, and that is why there is a gap of a continuous legal education that is missing in legal fraternity. Lawyer is all about, experiencing and exploring. So if after 5 years or if after a decade, if there are new area of law which is coming, or there is a new industry that is coming, there has to be a systematic, you can say, opportunity available where lawyers can upskill themselves. So yes, I think this is also a responsibility of universities and the institutions who are into legal education to fill this gap.
Right. I think constant learning beyond your degree, I think that's what you essentially mean. There was, I hope I'm pronouncing it right? Your initial view on when you look at the kind of education being offered, is it enough to develop industry-specific skills, especially when it comes to careers in-house?
So I have a slightly different view. I believe that in a law school, what the students should learn are the first principles of law, the basic tenets of being a lawyer, and it's very important that they undergo an academic rigor. I do not believe that students need to know any practical skill or anything, at least in the initial stage. I also believe that in the 5-year law course, especially which I went through, we were taught a lot of subjects which finally did not really benefit most of us. Very esoteric, very niche. And the best way, and when I first joined my profession, of course I felt very inadequate, which all of us would have felt in the first day. But I believe that's a gap on the of expectation on the industry side. A law firm or any company should not expect a fresher graduate to be like a full-fledged, expert lawyer, because the legal profession, we are always learning on the job. I'm still learning. We all are. Every day we all learn, we all grow. So the student who has come out from a law school, if his basics are very clear, if he is very skilled in the research and those basic lawyer skills, he will shine. Whether he tomorrow goes to a law firm or to an in-house career, it will not matter. What is, I believe, would have helped me, or all of us here might have been a long internship, and it's it's ingrained and it's in the systemized internship program where the BCI mandate say the law schools mandatorily 1 year, like 4 years you teach the law and 1 year you just let the student intern, because students also are not sure as to where they want to work, because I believe there's a lot of focus on pursuing a career in the corporate law. And when I ask the student, what do you mean by corporate law? Nobody really knows what is corporate law, right? Is it Companies Act? Is it what? Is it, I mean, it's a huge, vast area. And I believe students are also not exposed to everything. There's a legal education opens up a plethora of opportunities, and not all of them are law as lawyers, right? And if you, I mean, so that's where I believe a little bit of a reorientation of the education might work. And the best way is, of course, I believe there is now a system of inviting practitioners to teach, but that is also, I mean, fledgling, or it's not very popular.
Right.
Mainly because like West in India, practitioners in the West, professionals, they can go back to teach a semester and then go back to their own profession, and there is no problem. But here in India, that's not really the case. No practitioner is going to spend a lot of time maybe teaching, but that's all that is needed. Yes, and any specific skill about in-house, they are also lawyers. Any basic skill, whenever one joins a company, they learn, they observe, and beyond the basic, good communication skill, written communication skills, a little bit of a mindset to adapt to the changing, business industry perspective. I don't think anything more is required.
Wonderful. Utkarsh, your take on what can improve on the education side? How can they prepare better for this career?
Right. So I think we have had discussions, and we have seen that everyone, I mean, from GC's perspective, our honorable judge, in-house councils, everyone, I think we are on the same page that yes, we need certain reforms. But I also agree with the Gosmita that the academic rigor which a college gives is very important, and that is something which needs to continue. Yes, there are certain practical trainings which are obviously which will be advantages to the students. I think we as people from the industry should also participate more. I think internships generally has been a great way of doing that. But at the same time, I think even from a student's perspective, and some couple of years back, since I was running a edtech platform, so I had the opportunity to talk to a lot of students. So there is, I saw that there is a mindset that within the 4th or the 5th year, they are trying to streamline on a practice area or a niche which they are planning to do. Again, my personal opinion, and this is something which a lot of practitioners would agree now. I think in your college life, and maybe I would say in the first 5 or 10 years of your career, keep a very open mind. Our profession has evolved a lot. When we say industry specific, there are a lot of new industries to explore today. Say, so I work in CAM. Now, 10-15 years back, CAM did not had specialized practice areas like project finance or funds, or the IBC has come up, so we have a different insolvency team now. Previously, it was just bracketed, say, under a litigation or a corporate practice. So there is a lot of new practice area industries which are there to explore. The easiest way to explore is get into the industry through internships, if that is possible. If not, after college, get placements in different industries, see what is suiting you. Say, when we call, say, in-house perspective. Now, even in-house is a very different niche or a skill-based lawyer, what you become. Typically, as a college student, you can't experience what you are really expected out of an in-house counsel. But say, if you give that extra 5-10 years of your career to say work in a company and maybe in a firm as a practitioner, etc., you would get that what interests you, because the way you work, what you work is very different in all these different, career path. So yeah, I think even from a student perspective, you can think more about it.
Questions for the in-house experts. That's your chance. I have only one chance to give you a question. Anyone here? Come on, law students, come on. No? All right. Okay, well, let's show them the other way. Murul, tell them what are the big opportunities in the in-house career, that they can be excited about, and what are the challenges also in this?
Thank you for that specific questions. Because challenges are the place where you get the best of the opportunities. So yes, as it is an admitted fact that the law schools or the legal education doesn't teach anything about the in-house. So when you are thrown into the pool of this in-house practice or in-house lawyers, or have an opportunity to work in a corporate setup where you will simply feel lost for initial couple of months, that is where the opportunity lies to pick up those skills which is required for an in-house lawyers. And in the morning, Justice has mentioned the importance of the soft skills and the communication skills. I would like to add a point that if you are planning or if you're planning to take up in-house role, or even if you are not planning, it is worth spending couple of months in your initial months or initial couple of years of your profession to understand the business and operations in general. It is more to do like a skill that an MBA grad develops. Yes, we do have a specialization like MBA in HR or a finance or investment, but yes, there are certain general skill sets such as understanding the operational aspect, understanding the regulatory landscape is going to be very, very important if you are planning to go in-house. Because in India, the regulatory landscape is ever changing. From license Raj to liberal economy, and now we are into self-regulatory, you can say, season. So if you're planning to go in-house, please pay attention to the regulatory aspect and operational aspect. You may choose your field, or you will have your liking, like somebody like manufacturing, somebody will like mines and minerals, or a fintech or an ad tech. Yes, legal education will teach you law, but while you are in your initial year, understand the business and operations. That would be my, I would say, tips if you want to go in-house.
Wonderful. Dr. Prasad.
I think one of the important things which I learned when I speak to students is that in their fourth and fifth year, when they call me and they say, I want to become a specialist in aviation law. And my answer usually is that after 30 years, I'm still not a specialist. So to become first and foremost thing is you have to become a good lawyer first. And then, this is something which I think the universities and the colleges have to put a very strong thing is first train students to become good lawyers rather than advising them whether they should become an IP specialist or become a contract specialist or become a taxation specialist. Please make your student good lawyers first. That is the key. Because when a student who has done law is coming for an in-house role, I think the most important thing is the person has to be a journalist. The person should be able to understand corporate law as effectively as a contract law, as effectively as an IP law. It may not be so in a law firm when you're going for a job in a law firm, because and I have not worked for a law firm, I may be kindly be excused for this, but my impression is that when a student goes to work in a law firm, you tend to get a specialization, a department where you are working. But in an in-house, it has to be everything. And that is what the major difference is.
And thanks for sharing these thoughts. Of course, the basics have to be right first. Utkarsh wants to.
I think just to add to that, and being a good lawyer, obviously what the law school is doing is great, but that's my personal opinion is, I think first year or a couple of years, I really think that every lawyer, even if he wants to go into specialization of corporate law or only contracts or say even in-house, I feel that every student should try their hand on trial courts for the first year or couple of years. I think that will help you understand the very basics, the procedures, how the court operates, what the judges thinks, how I mean, tomorrow, even if you are drafting a contract, there will be something in your mind that tomorrow it might lead to dispute. How will that dispute turn out later? Right. So that's something which I want to add on, that everyone should, at least for a year or two, go to the very basics, go to the trial court, may not be the High Court or Supreme Court, but the lower courts, to just see how the court processes and the basics of law are operating in India.
Great. Yes.
In the era of, the questions we get, whether AI is going to impact legal and all of that, all I have to say is that when it comes to technology in law, I tell the students, please at least know please at least know the basic technology, which is Microsoft. And apart from Word, I don't think the students really know much, because I didn't know much. I have only worked on Word. It's very important that they train equally in PowerPoint and Excel. And lawyers should also know numbers very well. So reading financial information is very, very crucial, especially for an in-house lawyer. And even for any other career, whether in a law firm, in a banking, M&A, project finance, knowing numbers and understanding the company financial information is very, very important. So that's my 2 cents.
Thank you. And we kept to this time, so there'll be a special prize for that, right? Yeah. I wish we had more time, but thank you so much for this quick conversation. I think a lot of takeaways from here. Thank you all for joining us. Yeah.
I promise you the buzzer, the timer is not in my hand at all. और ना ही मैं direction देता हूँ. The business world team, please. Ashima, is it you who gives the instruction for playing that buzzer? तो कर कौन रहा है ये? जी. We'll just take a minute before we introduce our next panel. Gentlemen, can you please have the event TV? Okay. Our next panel, this is on from law school to law firm, navigating the learning curve. I think we have both of them in the audience. We also have students from the law school. We also have members from the law firm. So this is going to be highly interesting. Let's please welcome our panelists for the same. Pooja Mahajan, Managing Partner, Chandyok and Mahajan. Joining her is Ishani Chandra, Managing Partner, Sagar Chandra and Associates. Joining them is Jyoti Kumar Chaudhary, Partner, Hammurabi and Solomon Partners. And this session will be chaired by Ashima Ori, Managing Editor, BW Legal World.
Good afternoon, panelists. Thank you for joining us. And again, welcome to the BW Legal World Law School Ranking and Legal Summit. Before we begin, let me give you a precursor to what this session is about. This session will explore the transition from law school to law firm. Offline, a lot of students have been asking questions. I'm not sure if they'll be asking right now. Some of them have gone. But they've parked their questions with me, so I'll try to take as many with this panel. And we'd really like to get to the bottom of the debate today has been whether law institutes should be held accountable for producing students who are ready for the industry on day one. And some of our panelists before have shared their points that, they expect the students to have come from the institutes with certain amount of efficacy and communication skills or drafting, etc. Now, on the other hand, are the institutes who say that where is the industry? The industry intervention has been missing when these students were being nurtured by these institutes. So, Pooja, let me come back to you with that context. As a law firm managing partner, what is it that you look for in a student joining you on day one, on a mark or a milestone of 6 months and then 1 year?
Thanks. Thank you so much, Ashima, for inviting me. Now, I'm going to echo a lot of thoughts which have already been said in the earlier panels, but let me start by saying that at least I don't expect the students to be industry ready or ready-made lawyers at day one then when they come to us. That didn't happen when we were studying and when we joined, and that's not going to happen. A lot of what we do is very experiential. It's what we learn on the job. And really my expectation from the associates who join on day one is really, I just give them one advice: absorb everything. Be open to learning. A lot of times, the students come to us or the associates come to us expecting that on day one, they'll suddenly start arguing great matters or they'll be put into, a very important strategic M&A, but that's not how it works. First, I think first 6 months to 1 year, you need to be like a sponge. You need to be able to read a lot, just watch how your mentors and how your seniors are conducting matters. They need to be open to learning. And I think that is really the biggest expectation that I have is be open to learning and be open to experimenting with different things. And that's really what I would expect. In terms of, choosing a specialization, and I just want to weigh in on this because this is also something which was discussed earlier. I also personally think that it's good for the first six months to 1 year for associates to just maybe spend time with different teams and see what they really want to do, what is their interest level before actually picking up a specialization. And lastly, I think one other thing you mentioned about, day one, what really happens. And like I said, nothing really happens on day one. Most of the students would come and they join as an associate, and a lot of time is spent. The first initial 4 to 5 days is spent just on orientation. It's spent on learning the systems. It's spent on some very, very basic things. We think that the students would know, but they don't really know. A lot of issues regarding, let's say, ethics. And I'll give a very simple example about insider trading. A lot of the students don't know how insider trading works, and when you come to a law firm, how they need to protect the confidentiality of the matters, how they need to conduct themselves when it comes to trading. And I think these are some of the things that a law firm must focus on in the first few days, just to explain some of the very basic things on how systems work, how processes work, how procedures work, what is the expectation from them in terms of ethics. What is the expectation of the team from them, in the next 6 to 1 year? So 6 months to 1 year.
Right. Pooja, so let me go back a bit and ask, when you're evaluating students or you're going for recruitments, what is it that you want to see in a student that you'd see that, okay, this is somebody we want to bring back to the firm? And then what's your plan for them going forward for the 1 year? That how do you assess them in your firm that they make the cut for the work that you have for them?
The two basic things that I look at is drive and ambition, because it's a very tough profession. We as lawyers, we spend a lot of our time on the job, on work, and if you don't have the drive and ambition to do it, it's not a job that you can do half-heartedly.
Right.
I think that's the first thing that I really look for, and second is how open they are to learn. And these are the two primary things that I assess, because everything else you can learn, you can study, you can observe, you can absorb, but these two things are something which is primary for me.
Right. Thank you, Pooja. Ishani, let me come to you in that. What is your expectation of students coming in, one? And in your experience, what are the challenges that they seem to be grappling with when they come to a firm? We have these series and, shows and Netflix and everything else that paint a very different picture of how the legal industry looks. Indian legal industries are now being represented by some of the web series that are coming on the horizon. But otherwise, I think Suits is a very famous series that people look at and think that everything, all sorts of transactions can happen by just looking at a paper and then it's done. So how do you find that in your experience?
So thank you for the question, Ashima. So as far as what we expect in Sagar Chandra and Associates, I think one of the principles that we go by is that what law schools are teaching you is simply where to look, right? They're not teaching you what, they're teaching you where. And that is one of the skills that you're coming in with. Nobody's expecting you to be a fantastic lawyer and giving, instant solutions on day one. We're looking at the right attitude. We're looking for a willingness to put your head down and work, and to be open to learning and, like a sponge and basically taking in everything that is being taught to you. Those are the basic, principles that we're looking at. We're looking at honesty. We're looking at transparency. That's all that, like most managing partners of firms are looking at from an associate at day one. Now, as far as the challenges that, lawyers tend to face when they make that transition from student to associate or from intern to associate, because most of you would have done internships and you're doing the same work, right? You're doing the work that you have done in an internship. You're doing research, you're doing simple drafting. What is changing is the sense of responsibility that is attached to that work. As an intern, you're given a task and you're expected to return it, and you're then supposed to forget about it. But as an associate, what the firm is expecting from you is complete, responsibility or ownership of that work from 0 to 100. So if your, senior is giving you some work, the expectation is that there will be follow-up at your end to follow up with the senior to ensure that that work is eventually translated into real life. So if it's a draft, that it eventually gets filed. If it's a document, it eventually reaches the client. Those are the simple expectations, which is the major transition, which I feel that, students often have difficulty with when they transition from interns to associates. The second level of, difficulty that I see with that students have is actually communicating with the client. So when you are progressing in a firm, you're given more responsibility and you have to communicate with the client. Often, freshers are hesitant to do that because they don't know what is going to come at them, right? You're not supposed to have all the answers, but you should at least know what you are addressing a client with, right? You should do your basic homework. You should know your file completely, and you should be ready with the kind of questions that a client can pose you. And eventually it's all right to say that, no, I don't have all the answers and I need to reach out to my senior to give you an answer, but you have to be confident in dealing with the client, because at the end of the day, you are representing the firm. Another challenge that I see when you, sort of within a year or two, when you actually have put in the work in the firm, the responsibility that you get I see a lot of issues with delegation. I see a lot of issues with people then, sort of having that team building and sorry. No, that's fine. So I see issues with, delegation and actually then leading a team because you're so used to doing the work on your own that you have to then learn to let go and train someone else to do it. So these are the challenges.
And those are issues that even sometimes you see senior partners have it, right? I mean, delegation is a skill.
Absolutely. So we hear skills that are important so far is having the drive, crossing your T's and dotting your I's. That is, closing the loop every time, doing your follow-ups, and really when you go out there representing a firm, acting part of the firm, and shouldering that accountability, which was absent when you were a student. Jyoti, coming to you, some of these aspects we've discussed, but what is your take on students really cultivating these things? For instance, I'll give you a small example that a lot of the times that even I receive emails for a job is by Mr., Miss / something as basic as that is missing. What in your experience when an intern or an associate comes in, what are the basics that they can get right to have a successful career in a firm?
Thank you, Ashma, for the question. When a fresher comes to a law firm, I mean, to my view, he comes with raw learning. And the very important aspect that he has to address is the adaptability. He has to get adapted to the practice area of the law firm, the environment of the law firm, and all the aspects. So therefore, like there is, when comes up, there has to be some orientation. And there are actually orientation and induction programs where that particular person is introduced to, say, ERP system or the firm's rule system, rule books. Apart from that, certain firms are having even associate books because they are fresh to the firm. So they need to behave in a particular manner, in a disciplined manner. So therefore, there are associate rule book apart from the general rule books like filling of time sheets or attending the offices within time or leave. Apart from that, associates have separate rule books in many law firms. For example, if an associate comes up and gets an assignment and he is to deliver in certain timeline, during that period, he gets a second assignment from a second leader. Then that particular associate has to actually inform the first assigner that I have got this second assignment, which has a certain urgent timelines, and therefore I'll be having this particular assignment in between. So I will be responding to you in certain timelines so that the first assigner will then accordingly map up his own requirements. So as you said, your question was like, how to address and all. So he has to be oriented accordingly and he must be adaptable. He should adapt to the ways of the firm. So that is my response on that.
Right. Thank you, Shruti. Let me go around, in the interest of time and take some practical advice from the panel. And starting with you, Pooja, again. For a student coming in, what is something that you would advise in, as an add-on course maybe, or other things that are available to them? Like a lot of students now want to be mediators. There's this thing for the arbitration bar is here. So, people want to ask us whether we should do an LLM, we should do a mediator add-on course, we should do certain other negotiation skills or drafting skills add-on courses. In your opinion, is that something that's part of on-the-job training, or do you recommend certain level of proficiency on a tool or other such courses?
It really depends on the kind of work the associate is doing and what is the kind of work that he wants to do. It's always a good idea to constantly keep yourself updated and constantly upskill yourself. That I think goes without saying, whether you do it as part of the, a firm setup or you do it separately, upskilling is absolutely critical. I think 2 or 3 areas where I personally think the students will benefit a lot if they do these trainings is simple drafting. And a lot of law, in fact, we also do it as part of the orientation program as well, just to explain to them what is simple drafting, because end of the day, law is nothing but common sense and good communication.
So what does that really mean? Simple drafting means exactly
Well,
what?
you know, we are very used to when you're in a when you're studying, at least that used to be, at least when I was studying, the general impression was fill up the number, as many number of sheets you fill up, the more marks you will get, right? So people forget how to write simply,
Yeah.
and they forget how to write in short sentences, and they forget how to communicate very effectively. And you tend to use a lot of language which is very archaic, which is not really used in day-to-day communication. So that needs to be simplified. So doing something very simply and effectively is a skill set which I think they need to develop. The second thing is on numbers, a basic understanding of how finances work. And that's very critical for people who are doing either corporate law or commercial litigation or banking or finance or anything to do with commercial laws. It's important to have a very basic understanding of how balance sheets read. Just, you know, what is meant by simple terms like a bit, you know, things like that. That I think is important. And if you're not getting that knowledge within the law firm, it's good to do a course for upskilling yourself. And third, a very, very, very basic thing which are very close to my heart is how to do research. Because it's very easy now to, you know, if I give a research proposition to someone in the office, I think the first instinct is to just go to Google and type it down and see what comes out. And that, according to me, is dangerous because it's not about getting the right or wrong answer. I think it stunts your ability to think.
Absolutely.
So I think that's something which I would recommend.
Thank you, Pooja. I'll take that to Ishani. Ishani, in terms of research skill building, we now have AI research tools coming up. Is there one tool that you would want to recommend to students that is being used by the firm? Or do you think we're still a few miles away from really, getting there in terms of tools coming up yet?
I think we're still a few miles away. I think everybody here would have used ChatGPT, and you know the kind of outputs that come out. There've been cases where real life lawyers have used ChatGPT and
with fictitious names.
There have been fictitious cases with fictitious citations. So cross-check everything. There is nothing wrong with simplifying your work by using AI, but you have to cross-check everything. I think currently, the way we stand, you need to be good at, those all your online research tools like Manupatra and LinkLaw and anything, your SEC onlines. Those are the things that you need to be good at. AI is still on its way. Use it, enjoy it, but don't depend on it.
Thanks, Ishani. Jyoti, coming to you, there are a lot of avenues that are opening up for students other than core law at law firms. You have your, knowledge management, you have your PR and communication, you have possibly now your social media managers. What are your thoughts on some of those aspects that students can try as associates when they come into the firm?
Yes, they are actually important aspects. See, one of the important aspects for a career progression is to take up non-legal aspects as well, non-legal issues as well. For example, in our firm, there is a procurement committee, knowledge management committee, HR committee. So lawyers are being involved into that.
Right.
And so that gives them a different perspective. We have even a BD committee having lawyers into it. So that gives them an impetus to develop the interpersonal skills as well. So that is that gives them a holistic development. So that is important aspect.
Right. Thank you, Jyoti. So I hope our students have some insights from our panel today. Thank you so much, panelists, for sharing your practical pieces of advice with them. It's been a wonderful having you.
Thank you. Thank you so much. I always say this from food for thought. It's now time for food for your stomachs. It's time for lunch. It's 1:45. Let's please be back by 2:15. 15 so that we can start with the next panel discussion then. Thank you so much. Please enjoy your lunch.
Audio Jungle. 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 Audio Jungle.
Hello. May I please request everybody to take their seats so we can start now. That's the next panel. I know the drill by now. Yes, I believe it's okay. Shall we start? Yes or no? Let me ask you. Oh, lovely. Rohil? Okay. Our next panel with some tips on building a successful career in ADR, practitioners' perspective. And to share their perspective, please join me in welcoming on stage Tejas Karya, partner and head arbitration, Shardul Amarchand Mangaldas. Joining Tejas is Ira Majid, signing counsel, central government executive director, APCAM. Joining them is Divyam Agrawal, equity partner, J. Sagar and Associates. Joining them is Mehak Oberoi, legal head, Hydro APAC GE, Vernova. Joining them is Pavit Singh Katoch, group general counsel, In Shorts. And this session will be chaired by Dr. Kanika Arora, founder and managing partner, Nirka Law Advisories. Please welcome them now together, साथ में मिलके, आपकी तालियों के साथ. You know what? I personally believe after lunch, either only the two of you will clap, which makes it very scary for them, or all of you will clap with lots of energy. Let's try that. The second one, थोड़े और जोश में. बढ़िया. Thank you so much.
Hello, fellow panelists, and good afternoon to everyone over here. Extremely happy to see that we are all having a very constructive Sunday, and after lunch especially. So let me just dive into the topics that we have for today's panel discussion. Of course, the ADR industry has been evolving, has been stable and unstable both in the last decade or so in India. And a lot of students are very attracted to entering into this industry and starting practice from here, knowing very little of the complexities involved. So from your experience, let's start with Divyam. Of course, we've seen the arbitration sector develop, and the courts of India have been extremely proactive in encouraging arbitration in contracts. But we've also seen that the industry has been subjected to constant uncertainties. What would be your view on the emerging landscape of ADR in India?
Thanks. Good afternoon, everyone. I said good afternoon. So I think just before I start my session, in 17th century USA, there used to be mill workers who were made to work on midnight shifts. Those shifts became popular as graveyard shifts. Now, post-lunch sessions in these conferences have become the graveyard shifts. So we'll try to keep it as brief and as topical. So coming to your point, ADR, I think the two most important ones are mediation and arbitration. We have seen something, a good development in mediation, which I'm sure Iram is going to talk about. She's the champion for that. And on the arbitration, I would classify them into good, bad, and ugly. The good has been that there is, of course, some very good decisions from Supreme Court. There is the arbitration bar of India now, which is streamlining the process. There is a big movement towards institutionalizing arbitration. Now there is an institution coming up literally in every state. Some of them are doing phenomenal work. There is a lot of cross-border disputes which are happening. India is becoming popular. There have been some good decisions where there are certainties attached to it. However, recently we faced, which brings me to the bad, is the decision of the Honorable Supreme Court of India in the DMRC case, where they allowed a curative and set aside an arbitral award. And we were just discussing that it was 7 years and 6 forums. You realize that your award, there is no certainty attached to it. While it was a domestic award, the uncertainty even goes to the foreign shores. A similar thing, one can't rule out a possibility that at a later point of time, a foreign award faces a similar consequence. So that's not good for the Indian landscape. You expect some certainty. If you need to compete with Singapore, London, and Dubai of the world, you need to have some certainty attached to it. You need to make it a more attractive jurisdiction. So that's the bad. The ugly is what just happened, and let's keep our fingers crossed and hope that it does not happen, is the circular which was issued recently by the government of India, where they have, while thankfully given some impetus to mediation, but on the arbitration, they're literally putting a red flag. They're not, they're giving an idea, don't proceed with it. The Arbitration Bar of India and the Indian Arbitration Forum has now written to them. Hopefully they'll come up with some kind of a view, try to taper down that circular, bring the expectation down. Otherwise it's, sorry? Yeah, some saving grace. Otherwise we are looking at it as a death nail for arbitration, because the biggest litigant in India is the government. One good thing that has happened just recently, let's see how it pans out, is the decision which was taken by the Bar Council of India and the UK government, which just happened a week back, wherein they have discussed, and hopefully they'll come up with some regulation. For most importantly for the law students, it's a very important news to follow, as that would really set the standard if the foreign law firms are actually allowed to come to India. There is definitely going to be an increase in competition, and hopefully the law students can thrive out of it. So that's like the few bits I have on.
All right. Thanks, Divya. Of course, we've seen that India has come a long way in the last couple of years, but can we call ourselves stable as of now? No, we can't really do that. But are we heading in the right direction? Hopefully, if all goes as per track. But of course, in the middle, just like every other jurisdiction, India also experienced the COVID pandemic. And because of the pandemic, us as lawyers had to get ourselves used to a new way of working, where suddenly there was conversation about AI or virtual hearings, which didn't exist. So Mehak, I would like to ask you, is adapting to virtual hearings, for example, law firms also increasingly resorted to softwares for document management or for drafting of pleadings. What role, according to you, does technology play in modern ADR, and how can lawyers leverage online dispute resolution platforms and AI to enhance their practice?
So I think technology plays a very, very vital role now in ADR. I think the obvious would be your optimizing your data management, analyzing data, document review, contract management, selection of arbitrators, and making it simple for mediators to come up with creative solutions. But I think it goes deeper than that. I think we still don't have enough foresight into what's going to happen. We're looking at legal hearings in the metaverse. We're looking at evidence being submitted in digital form, which doesn't mean that's just in soft copy. It is in the form of reconstruction, animations, simulations. We're looking at blockchain technology in ADR as well. So I think in times to come, probably court is not going to be a place anymore. It's going to be a service. So yeah, there's a lot that's coming up. And I think the law students need to be geared up and brace themselves for the new era. What's got you here is not going to get you there.
All right. Well, of course, as lawyers, we're very used to working with our hard copies and have a very tough time getting used to laptops and in virtual soft copy briefs
now.
So we're all getting used to working on laptops and iPads more than our physical briefs. Let me go back to the painful circular which was circulated, as Divyam pointed out. And let's throw some light on that. We are increasingly, as all of us might agree, that we are constantly faced by a question from clients that is arbitration really that effective? Whether it may be cost or whether it may be time. So Tejas, I'd like to ask you that because of so many uncertainties in the legislative perspective of ADR, I think larger floodgates have opened for discussions on how effective ADR really is. So what are some common misconceptions about ADR that, we can clarify for the students entering the industry? And how can lawyers and legal educators work best to gain a better understanding of ADR methods?
Thanks, Kanika. Good afternoon, everyone. Yeah, it's a bit surprised when we saw the circular. When I spoke to the stakeholders in the government, they tried to justify by saying it is only for the public procurement contract and doesn't apply to all the government contract. But the answer to their justification is that EPC contract includes procurement, and most of the construction contracts are EPC contracts. So how do you justify saying that it only applies to procurement contracts and not to the other? Now, the finance ministry and the law ministry are two different entities within the government where they try to keep themselves separate. Now, law ministry is also saying that we have nothing to do with that circular, which is also concerning because finance ministry does not have the power to pass such kind of circular. So there are certain fundamental issues with regard to the jurisdiction of that circular. We have raised concerns on behalf of the Arbitration Bar of India, and also CII has written a communication to the ministry to look into this circular, because the circular is based on a lot of misconception about the arbitration. And the one being that it is time consuming. Second is it's very costly. Third is that the arbitrators are not applying the law. Fourth is that the courts are interfering too much. Now, we have answers to that. We have already worked on those issues, which are the major concerns about the arbitration is that it is taking time. We have the timelines in place. We are not even now spending time on Section 9. Once the tribunal is constituted, we refer the matter to the arbitral tribunal for interim measures. For Section 29A takes care of the timelines, and the courts are extending the timelines only in the cases where there is a justifiable grounds. Even in terms of challenge to the award and enforcement, yes, it is taking a lot of time. For that, we need to have dedicated bench in each jurisdiction. Now in Delhi High Court, from tomorrow, we are going to have 3 separate arbitration benches. Earlier, it used to be both suits, original side. Now, original side is divided into arbitration, IP, and the suits. So that is a positive development as far as Delhi is concerned. We are seeing a lot of changes in terms of the original side judges deciding 34s and also ensuring that 36 enforcement matters are decided at the earliest. Plus, the institutional arbitration is something, a great answer to that, starting from the appointment till the passing of the award. Institution can oversee the process of arbitration. So if you select the institutional arbitration, then all these answers can be there. From the government's perspective, it is again a big concern, because they are saying that anything less than 10 crores will go to arbitration. Anything more than 10 crores will go to the litigation. Now, courts are overburdened. If you compare courts and statistics, there is no time available. In the previous session also, we were hearing that the courts are overburdened. We don't have judges who are equipped to handle this kind of workload, and especially more than 10 crores, you'll have a heavy documentation, evidence, and all that will not be possible. Now, the other way to work around it, which the government has not realized, is that you'll have multiple arbitrations for the same contract less than 10 crores. So how would you avoid that? Because if you have an arbitration clause, and you want to initiate arbitration, you will ensure that your claim is less than 10 crores and you can still go for arbitration. So those are the loopholes in this circular. Of course, mediation is tried to be promoted, but the answer to that also is that you can have multi-tiered dispute resolution clauses where you go for mediation first, fail, or have a hybrid of med or ab kind of dispute resolution mechanisms. So the core of the issue is in drafting of the good effective arbitration clause, going for institutional arbitration, and having dedicated benches in the court to decide the issues arising out of the arbitration. I don't think we need this kind of circulars, and over a period of time, we will ensure that some clarity is brought about in terms of this kind of circulars.
All right. I think all of us very much agree with what Tejas has said over here. And that gives us a good macro view of how arbitration works. Now, let's go a bit into the micro aspects. Even, for example, if I talk about a construction arbitration, many a times as a lawyer, we put together the best team of technical experts, lawyers who understand technical contracts, prepare our submissions accordingly. And most of the construction infrastructure contracts are highly technical for that matter. But many a times, I think an issue that we have to face in ADR generally is whether the forum that we're presenting before is understanding the technicalities of the matter which is being discussed. So let me ask you that as mediation and arbitration are becoming increasingly preferred methods of dispute resolution, what steps can be taken to enhance the quality of the mediators and arbitrators to perform their job during the hearings, as well as to help India-seated arbitrations come at par with international standards?
Thank you so much, Kanika. And before I give my answer, I would like to acknowledge the presence of teachers from the different colleges and the students. So whatever I'll be speaking, it is not only for the students, but also for the teachers, because the students, if suppose whatever I'll be saying, it is not possible without the hand-holding of the teachers and the colleges. The first thing is that we have to see that there's a drastic change is happening in the world of ADR, in this universe. And the only thing is we need to develop a good pool of arbitrators and mediators. That is not possible without having a good trainings. So if I talk about the training, it is not just a certificate course which we keep across, in one day or other day. It is not just that kind of trainings. If I am seeing the training, then you have to understand, many students, they fall into that pit and they see that, okay, this person is teaching in this training program, this person is teaching in this training program, I should offer that. So I should go for this training. So you have to understand the importance of that certificate, whether that certificate will take you somewhere or not. If that certificate is just a paper, it's not going to take you anywhere. That I just ask you not, I just recommend you not to go for those trainings unless those training programs will impanel you somewhere, will give you some work, or will give you accreditation. That is something which is very important. Accreditations are different from the certifications or the certificate course. So if you see globally, why the people are now doing in ICC mediations, ICC arbitrations, and SIAC and all, because they have good accreditations. If you see Tejas sir's name in front of his name, you will read FCIR. So that is a kind of accreditation. If you read my name, there is an MCR, ACIA, IMI. These are the accreditations. You have to achieve those accreditations to get or to achieve international level. So because these are the things which has not been told to you by the colleges and all. So that is why in my initial, thing, I told you that the college should also, make sure that these kind of accreditations should be given to the students. Second thing is that I would like to say networking and collaboration. Networking and collaboration is something which is very, very important at your stage. Don't feel that after completion of my law, I'll be going for the, networking and all. And after that only I'll be meeting with other people. See, network is more important than your work, or equally important as your work. So don't miss on that. Integration of technology. That is also something which is very important. It was Mehak has mentioned, and she has emphasized on the AI thing and all. So integration of the technology is very important. Now, these days in ADR, people are doing virtual mediations and virtual arbitrations, and they are claiming that it is online arbitration as mediation. See, that is not online. Online means dedicated platform to perform these kind of arbitrations and mediations. It's not something which is virtual. So you have to understand that how to use a dedicated platform or how to develop a dedicated platform. Third thing which is very important is, and it is important for the industry, for the users, for the students, for the teachers, and for practitioners as well, that there should be ethical code of conduct we should follow. By having all these things, we can achieve, the standard, because this practice liberates jurisdiction. It's a global profession. You have to understand that. By sitting over here, I'm doing mediation under ICC rules, directly appointed by Paris head office. So how it is possible? Because we follow certain code of conducts. We know what are the ethics of this game or ethics of this this profession. So we have to understand that even in the Singapore Convention, I do not know how many of you know about the Singapore Convention, which is the Convention for the Enforcement of Settlement of International Mediation Settlement Agreement. See, in the Singapore Convention, the one of the most important ground for the refusal for the enforcement is that if the award is, the settlement agreement is non-comprehensible, and if it is not, if the mediator breached the code of conduct, but we don't know what is the code of conduct. We don't follow any kind of code of conduct. We have no understanding of that. So these are the things I think we need to understand. If I summarize the trainings, accreditations, integration of technology, ethical code of conducts, collaboration, networking, and last thing I would like to say, the mentor. You need to have good mentor, who can give you a clear idea and who can hold your hand. So this is what my take on this.
All right. Thanks, Iram. I think that's very, very helpful for all the students and teachers sitting here. But now that we're talking about technology, we'll take our last question with Pavit. Lawyers haven't spoken about technology as much as they've spoken after COVID. Suddenly, everyone has iPads and virtual briefs with them. But on the other hand, we have also seen a lot of technology-driven disputes. Issues such as data privacy, issues of intellectual properties or smart contracts that Mehek also pointed out that we have seen so much of a development there. What are the general issues that crop up with the newer age technology contracts or issues that companies are facing on that side? And that's one part of the question. And the other part of the question is that what can students who are entering this industry do best to become as tech savvy as now we are or we're attempting to be?
Thanks. Good afternoon, everyone. I think we are short on time, so I'll just keep it short. So as you said, as Mac also said, technology is everywhere. So every industry has adopted technology, which has resulted in more complex disputes. Because as you would remember, when internet came, everyone was worried about it, like how it's going to affect our lives. And then over the years, it has almost been part of every sphere of our life. Similarly, any new technology which comes, be it AI, smart contracts, blockchain, they are going to affect us in a major way. And obviously, the disputes will also be very complex. So what we need to do to handle such kind of disputes, obviously courts are still not, Indian courts at least are not at that level that they can handle such complex disputes. So that's why ADR is preferred in tech disputes, and it can range from an IP issue, a cyber breach, a data privacy issue, a data which now everyone is worried about. Every time we open our phone, there are 1,000 impressions which are made based on our one move. So all these, then you have obviously smart contracts, which is combined with blockchain. You have the AI. Everyone is worried about AI. Will it take my job away? Obviously, for lawyers, for law students, it will not take your job away, but you have to use it. Otherwise, you will become, you'll not be valid anymore. Like you have to adopt it. It's a good servant, so you should use it. Anyone who's not using it will be falling behind. And even the traditional M&A disputes wherein, the technology is involved, there also the ADR has a lot of scope because these are all tech-related disputes wherein we don't want our data or the technology to be out in the open in the court. You want to do it in a confidential manner. So all these kind of disputes would definitely lead to a point where ADR is preferred for tech disputes. And I believe that especially for budding lawyers or the students, it's important for them to also adopt technology and ensure that they're also learning how ADR works. I've heard whole day we were talking about, going to courts, spending some time there. Don't forget going to an arbitration, learning how a mediation is done. Also negotiation. I think a lot of us don't realize that every agreement these days have a clause which says before a dispute, have 15 days to, have discussed between the two parties, and that helps a lot. I've seen it from both from the side of a practicing lawyer now being in-house. Sometimes a lot of dispute get resolved those ways. So for students, I'll say adopt technology,
try to do internships, watch such mediations, arbitrations. ODR again was raised by them. That will be the next big thing. A lot of dispute will be handled online. You know, you will have these companies having their ODR setups wherein if you have a problem, instead of going to a consumer court, you may get a resolution through ODR. So for all students, it's relevant to adopt all these technologies and be prepared for the future.
All right, that was very helpful. I don't think we have much time to take another round of questions because I think half an hour is too less to cover the topic that we have here. But before we proceed to closing remarks, if there are any questions from the audience, we can take that now. Yeah.
What is the scope of forensic auditors in the coming for investigating the veracity of digital evidence?
I can take that. Yeah, very relevant question. I didn't have time, otherwise I would have definitely spoken about forensics. Any tech dispute would involve forensic because everything happens on a digital sphere. Physically, you can go house and search, but you know, in a tech world, that doesn't work. Forensic is the next thing. You know, these days companies are spending lakhs of rupees to ensure they have systems wherein they can store digital data. And tomorrow, if there's a forensic team which can check for evidences, who has written what was the whole process. So forensics are here to stay along with audits. So for any tech disputes, forensics are here. And anyone who wants to study forensics, when I started my career, I was very much interested. I could hack a smaller system. I could spoof emails just for the, you know, like an ethical hacker. I'm sure Pawan ji is here. He can speak on it for hours and hours. But definitely forensics, you have to learn forensic. As a lawyer, you should also understand it works because you have to explain it to the judge or the arbitrator how it works. So very relevant to our context, and forensics should be again learned by everyone if they have time. And
yeah, and I can add to that is you asked about electronic evidence. Now, electronic evidence is part of every proceedings now, even in the court or the arbitration, where you have to prove the digitally stored information. How do you do it? Because ultimately it is in the hard drive with the original is there. You have to prove it by way of producing a copy which is authenticated by way of a procedure which is laid down under the law under 65B, and now from tomorrow another section. So that way we'll have to see that we have forensic audit done by an authenticated expert who can come as an expert to prove before the court or the arbitral tribunal that the data or the information which is produced before the court or the tribunal is authenticated. So authenticity is very important for proving electronic evidence. You can give the certificate, and if it is done by the forensic auditor, then it adds value to the entire electronic evidence.
Any other questions from the audience?
Question for Tejas and the group. So 3rd June 24, you found it troubling. But the most important thing you missed out in your comment, and I want you to attract your attention to, and I'll get an answer. It displays in 2 pages out of 6 wide-ranging distrust of arbitration as a dispute resolution mechanism in public sector. We have Virat sitting there who's a counsel for the government. So I'm sure she's heard some concerns about it. Institution doing things around is all very well. How are you addressing it? Because to go back to the government and say 3rd June is not good enough, must also have resolutions from the bar, from the association, to come forward and say we'll make it credible. If one party is distrusting, and secondly, it suggests mediation. Mediation by section 6 read with the schedule. Please read paras 5, 6, 7, 8, and 11, 12. Rules out literally every contract in public procurement. It's a complete vacuum they've created. And I'm surprised that you've not picked that up. So I'd love to hear.
No, that's a great comment. See, we are already working on, so that's what I started by saying that it's a misconception when which the government is working on. Government itself is coming up with the Arbitration Council of India. They are in process of formulating Arbitration Council of India. They will accredit the arbitrators. They will set up the entire system as per the law. So government is only answering the questions which the government is posing to itself. They are saying that we don't trust the arbitrators, we don't trust the process. That is not correct. The correct way of doing it is to strengthen. As far as bar is concerned, we are consolidating ourselves, the Arbitration Bar of India, where Attorney General and the Solicitor General are the patrons, also shows involvement of the government, saying that like, yes, we have a consolidated bar where we will give priority to arbitration and not give priority to litigation if we have a conflict. So those are the steps we are already taking. It's been overlooked. It's a aberration where we feel that right information provided to the stakeholders will, yes, you're right. Ultimately, we have to build trust and confidence in the public sector undertaking. That can only come by fixing certain things which we already know the answers of. So it's not that we don't know and we are going to search for the answers. We know the answers. We are already taking steps. And if we do it in a right way, I'm sure it's going to be an effective way to assuage the concerns. The second thing about mediation. The mediation is a non-concessional thing. It cannot replace arbitration. It is an additional thing. It's an additional dispute resolution mechanism which complements arbitration in a big way. If we talk about Singapore, they have used it to the maximum advantage with the Singapore Convention being there. There we are a signatory, but we have not incorporated that into the cross-border in our Mediation Act. We have the Mediation Act. Mediation Council of India is going to come, and we are going to use mediation and arbitration both together, and we can't use it as an alternative to each other. So I'm sure with all the right answers to the stakeholders, we can definitely answer to all the concerns with regard to the public sector not having trust in the system of arbitration.
All right. So we'll wrap up this session. I'll just take one round for each of you to give one tip in one line to the students who are entering the career of ADR. What would be your 2 cents on it? Just one tip in one line.
Yes, I'll start with it. So, so for students, I believe they need to first decide what they want to do throughout their life. ADR is a very good career prospects where you can know with certainty that you are going to use your time constructively for advising on a commercial disputes. It's not easy. It involves drafting skills. It involves the procedural aspects of that, and you need a lot of training for that. One is that you get trained in all these courses which Iram mentioned, and also on the job. So you have to work with somebody who is doing ADR practice over a period of time and see that you like that practice to do it. Of course, internship helps in your student career, and after that, you should choose an office or a firm where you can develop your skills into ADR practice. And one more thing which I would like to add is, as Pavit mentioned about technology. Technology is here to stay. We are surviving because of technology in ADR. So ADR and technology goes hand in hand, and we have to use best use of the technology as student from the student life itself. So when you come into practice, you will be expert in using technology for ADR mechanisms.
Ira?
Yeah, so from my side, you should have patience, and you should be consistent. You should not change or believe in 2 minutes relationship, senior and junior. And if you are joining somewhere as an intern and all, please try to give at least 3 months in every internship. If you feel that 4 weeks are enough, that is not enough, because 4 weeks, the senior will understand you and you will understand that place. At least 3 months time should be given. Keep patience, and you have to, understand that place, and that place will give you a lot. Please, after your completion of your law, you have to connect with some senior where you have to again, keep patience, and you have to be there for years and years, because the tag which you keep on your forehead, that matters. If you will keep on changing the tag of your senior again and again, you will be nowhere. So you have to keep a single tag for some years, and I'm sure that you will be going to get something from that place. So patience is the key.
Divya?
So being a byproduct of internship, I'll certainly say internship as the top thing. Second, I would say for ADR and especially for lawyers who want to get into litigation, arbitration, mediation, moot courts is very important. It will help in developing court craft. It will help in developing your oratory skills. So it's important that you do focus on that. These are my two bits.
Mehak? Okay, I have to get shorter than that now. Okay, so I had correlated with technology. So you need to evaluate and reevaluate the usage of AI in your day jobs so that you don't become redundant. And I don't mean to scare you. It's not going to end up in unemployment. It's going to end up in redeployment. So the nature of your jobs in the legal fraternity are going to change. And two, like Iram had said earlier, networking is very important. Your network is your net worth. So it's not what you know, it is who you know. And choose your mentor. Don't wait for your mentee, for the mentor to come up and choose the mentee. Choose your mentor carefully, the one that you think can take you places. So don't wait for the mentor to come to you. Pavid?
Yeah. Just wanted to add that ADR has a lot of scope in India. So do consider ADR as a career choice. I am sure there's a lot of scope. India is moving to a more evolved country. Just like Western countries, ADR will be very helpful.
All right, and I will copy paste everything that you all just said. And just add 2 lines to it. One is, of course, getting yourself a good mentor, and I can't emphasize enough on that. Having the right mentor in the first 5 years of your career can shape up the entire career magically and beyond your belief. And second, and very importantly, is take risks. I think that is something that we all can say from experience, that taking the right risks, making the right decisions at the right time is extremely, extremely important. And getting yourself out of that comfort zone to be able to learn and grow throughout the tenure of your profession. And I think with that, we can wrap up this discussion. Thank you so much, everyone, and thank you to all the speakers here.
Thank you so much. A picture, please. And thank you so much, Dr. Kanega, for moderating that. Thank you. Thank you. And picking up from our last panelist, from where Tejas mentioned that technology is here to stay, from where Pavit mentioned that AI is to help you, to serve you. So please make use of it. Our next panel is on crystal gazing into innovative uses of AI in legal education and also in profession. And to share the views on the same, please join me in welcoming on stage Dr. Pawan Duggal, cyber law expert. Joining Dr. Duggal is Dr. Pradeep Kulshrestha, Dean, School of Law, Bennett University. Joining them is Dr. Devanshu Srivastava, Assistant Dean and Associate Professor of School of Law, GD Ganga University. Joining them is Rohan Rohatgi, Partner, RSR Legal Advocates. And this one will be moderated by Kaustubh Mehta, Editorial Lead, BW Legal World. Let's please welcome everybody. आपके जोरदार तालियों के साथ थोड़ा और जोश. And I understand you have a few. Thank you to the 3 who are sitting there consistently with me.
Check. Good afternoon, everybody. The topic is quite interesting. It's about artificial intelligence. And as you all are aware, artificial intelligence is being used by lawyers across law firms and across practitioners. But it raises a lot of ethical concerns as well. So without further ado, let's cut to the chase and let's listen what our panelists have to say. We have an honored panel of Dr. Pawan Duggal, Dr. Pradeep Kulshrestha, Dr. Devanshu Srivastava, and Mr. Rohan Rohatgi. So the first question would be,
to Mr. Dugal. How will AI change the role of lawyers and legal professionals? And what new skills will be required to work effectively with AI systems?
Thank you, Kaustav. I think today AI will change the legal profession totally. But more significantly, it's going to make lawyers more nervous. Why? Well, 2 days back, you've seen Universal and Sony now coming up with a new lawsuit against AI music generators. So once you as lawyers will be generating content, these could be legal pleadings, these could be draftings, the potentiality of a potential legal exposure for the legal profession is going to be there. Number one, cut, copy, paste is gone. The second current approach is humanizing the AI content. I think with now Turnitin coming up with a dedicated AI tool, even humanizing of AI content is now passé. Therefore, you'll have to only look at inspiration, but not direct cut, copy, paste. Thirdly, I think you have to still realize that a large chunk of data that's been used for training is still not yet Indian data. It's been primarily Western data. So expecting a kind of an impartial viewpoint from AI will be a complete no-no. Let's given a basic presumption that bias and discrimination will be our constant lifelong companions in the AI journey. And therefore, being aware of hallucination will be of topmost priority. The chances of unethical approaches being adopted by AI to guide, misguide, or shall I take you to a different direction could not be ruled out. Therefore, you will have to be having your guardrails on, more so as a legal professional, as to what kind of ethical prisms and the color lenses that you need to look at the output of AI. And finally, AI is getting very, very unreliable. So if you are not going to learn from the case of these two lawyers in the US who copy pasted the written arguments generated by AI, presented in court, and found that 6 cases that were quoted therein were actually nothing but fake and fabricated cases, you're actually going to be playing with fire. So double due diligence, care and caution will be mantra for you moving forward. Needless to say, the positives are so many. It just is that as a lawyer, you need to be mindful of the fact that the use of AI could add a new exposure to the legal liability of the legal professional. And this exposure could come in not just from existing, but even from potential lawyers and potential stakeholders with whom you may not necessarily have a direct privity of contract. But all said and done, we cannot run away to the Himalayas. We will have to be here. So it's more a kind of a suraksha kavach that you can bring around you so as to make yourself more prepared, more protected, and also be more holistic in your approach. It's hard to predict. Why? Give yourself 3 years. By 2027, the super intelligence is coming in, which is going to be superseding human intelligence. So if you have just about 3 to 4 years for this kind of a time frame to get prepared, I think the focus has to be more on creating more capacities, more awareness, and being aware of the fact that we are going to be riding a running tiger. We will not have the ability to get off the tiger. We will need to calibrate our approaches as we move on in this tiger race on the AI ecosystem. Thanks.
So we will have to be prepared to mitigate the risks associated with AI. So my next question would be to Mr. Rohatgi. What ethical considerations arise when using AI in legal education and practice, and how can they be addressed? Thank you, Kaustav. Before I proceed, I feel a bit out of place with all the doctors here. So I think Dr. Dugal covered most of this aspect in terms of ethical considerations. But to start with, I think we have a live example that you mentioned. In the US, there have been cases and there are proceedings, now bar council proceedings that are going on against these lawyers who have now utilized what came out of ChatGPT for referred cases without accountability, without cross-checking that these cases really exist in the first place. So there has to be accountability, and secondly, there has to be accuracy. That even if I go onto a ChatGPT, which is now, let's say, in our ChatGPT 3.0, which is most of the students will probably relate to this, is what we call generative AI. And what generative AI is really doing is, if I type in a certain problem, and I'm looking for a case law in relation to a certain problem, ChatGPT will help me in finding that, correct? But it is our responsibility, ethically and professionally, to cross-check that is this case there, it doesn't really exist. The findings of ChatGPT, are they really true? Because we also need to know how this system works. ChatGPT is basically putting all data together. It's not creating data. It's only giving you an analysis of what is already been fed into the system. So that is very important. Thirdly, I believe what will really happen is till now, we have, in terms of, let's say, the Bar Council here, we have ethics that we are regulated by. And these ethics don't specifically deal with, tomorrow it could be that when you are writing to clients, today when we send out an email, we say, whatever we say is protected by attorney-client privilege. There could be a scenario where we need to say that, we're using ChatGPT for advisory services as well, because the client is coming to you for an advisory. And if they can get this from ChatGPT, you are not required anymore. But the difference here is AI or ChatGPT or whatever be the synonyms that we use for it can only assist you in finding data. You will still need lawyers to analyze, to present. That cannot be, at this point of time at least, done by robotics. You can't have robots going fed with AI and saying, okay, this is what it is. So in terms of ethical considerations, I feel accountability, accuracy, balance, and something which is very important is privacy and confidentiality. Now, what AI is really throwing up, we do not know what all that data is really, right? A lot of that data could be confidential data, which has been fed into the system. Tomorrow, if you're using that for legal proceedings, you could be in a soup. So that again, it all comes down to, I believe, accountability, right? Ethics and accountability is all that. Now, there's one more aspect before I close this. We also need to understand when we see the legal profession today, when we operate our firms or legal practices, there are two aspects to this. One is the legal side to it, the other is the administrative side to it, right? A lot of us are already using AI-based softwares for our administrative sides of our practice. On the legal sides also, I believe a lot of us are using softwares, which are in a way at the back end are AI-based. It could be case law management, it could be case law generators, it could be management of your IPs, it could be searches and watches in relation to IP. So there are already tools which are there in the market that we're using, but they are very, I would say 1.0 to 2.0. There's already usage of AI, and I think there's been acceptability to a large extent. It's just that when we move forward, are we able to adapt and improve in terms of what is there and what we propose to really utilize it in? Thank you.
Thank you, Mr. Rodgi. My next question would be to Dr. Devanshu Srivastav. What are the implications of data privacy regulations on the use of AI in legal services?
Yeah, thank you so much for that question. And before, I guess, the 5 pointers that we generally see out of an data privacy or in generative AI has very well been covered by Dr. Dugal and when Mr. Rodgi was taking it up. Also, one line that I like to borrow when Mr. Rodgi said that it is a thing where a panel has 3 doctors and he himself not being a doctor. But I guess the technological era isn't seeing that. So it is immaterial whether at this stage we having doctors or professors in front of our name and someone who is so technologically advanced that he's ready to use a 3.0 or ready for a 4.0. And before I take this up, we'll all should understand that it is just a tool. Now, a generative AI, by whatever means, is merely a tool, and how well we as legal educators, we as law students, or we as lawyers are using it up. Now, when I'm talking about the law, The GDPR specifically talks about the Article 6, Article 8, Article 22. But we should not forget, which is very important, and somewhere the DPDP Act is missing onto, is the Article 35. Now, Article 35 talks about the impact assessment of the data protection and privacy, which when we see, and as per the question when Costa was taking that question up, the transparency is there, the biasness as is very well being covered, the accountability is covered, but what is not being covered is how you are utilizing it and what would be its impact. Sir rightly mentioned that 2027, when we are seeing to a super intelligent level, where technology is going to come and go again. Now, the only difference between a good lawyer and a dedicated lawyer was not of what the content you are getting. So if that content was ready with us, with the case laws, but the cross-checking and getting an accountable there, how well we are using that particular. This happens with the law students when they go for a moot court. They get a US case on the same point, but then one of your team members would come out and say, isn't it having a persuasive value? How can we get a Supreme Court judgment and authority over the same, which if it is an Indian moot court where we are taking on to, can be brought all together? And this exactly is the fifth point, that is the accountability with ethics, with biasness, and with the transparency should also have an impact assessment over the point. Now, as for my law students, how well we are taking it up, be advanced when the technology is there. Do not make yourself reliable on the tool rather than use the tool to be reliable on you and whatever is the output that you are getting by the click of that enter. Make sure the 5 parameters or the 5 tests that you are getting before you are presenting it as your assignment, as your dissertation, or in future as a brief to your client or as a judgment to what the advocates are being presenting on you, should all pass with the final thing of the impact that it's going to make. Whether it is reliable, that where your biasness comes into play, and you need to be very clear with it. So that would be all how it possibility.
Thank you. Dr. Kulshrestha, I'd like to ask you, what are the most promising applications of AI in legal research and writing? And how can law students develop skills to work effectively with these tools?
Thank you very much. Good question. My encounter with AI was with ChatGPT. When my students started bringing their homework and assignments on ChatGPT, and I was taking them not knowing about it, then someone leaked this information to me that they are from ChatGPT. So then I went on net and I found out that this is the tool they're using. Then thanks God, Turnitin came and they started checking that how much is from AI. So I don't know which tool next is going to use for home assignments and for research, which again, we will have to wait for some other tool to come to check. On a serious note, now this is the time when law schools should start training students on use of AI. Because technology lastly is here and we have to make best use of it. And for India to develop our legal student, law student, they have to be technologically savvy. And I must tell you, we are well equipped and students are quite smart. And I'm sure they're going to use AI in a best possible manner. We at Bennett Law School have a school of AI and we are partnering with the faculty of AI. And from this coming semester, we are going to impart systematic training to law students on legal tech, on generative AI, on AI, so that how they can make best use of this. Because we can't keep sitting and fearing that what will happen next 3 years, 4 years. We have to adapt the technology, we have to be ready for the changes. And this is not only going to stop at AI or generative AI. The future for me is full of possibilities, full of opportunity. Maybe shape of employment will change, but no technology, to my understanding, is going to replace human being. Because the critical thinking which we are having, perhaps I may go wrong, I don't know what lies in future, because Dr. Pawan Tugal is, as told, we are going to ride a tiger. And if we are to ride a tiger, we shall and we can. But to my understanding, we have law teachers here, we have law students, we have practicing advocates. we should now come forward and train this generation of law students so that next 4 or 5 years we are ready to face this challenge. Otherwise, it will be like hit and trial method, which we are doing. That may create problem because what to prompt, how to prompt, that all has to be in place. So this is the right time for us to embrace the change, come forward, and I am thankful to Dr. Pawan Tuggal. He has been very kind. Whenever we request him, he comes out to our place, and I see him. He goes to most of the law schools. So that way, we are fortunate in this profession. All of us, judges, practitioners, teachers, law students, they all are quite adaptive. And you reach out to anyone, they take out their time and they are ready to handhold. So this is another thing which I'll touch upon, that mentorship. Because if you have a strong mentorship, then we can really take care of this technological change, and we shall make best of this. I'm quite sure. But we need strong handholding. We need all stakeholders to come together. Like in COVID, we all saw how technology saved us. Again, AI is going to maybe enhance our productivity. We saw internet. There was so much fear. I remember Rajiv Gandhi government, when they were bringing computers, they were opposition that computers are going to take away jobs. 80s, I remember. But thanks to him, he brought, and now they have helped us become more efficient. Similarly, internet, they also brought next level of efficiency. AI is going to make us more efficient. Maybe employment nature may change, but we have to make best use of this. Thank you very much.
Thank you. Any questions from the audience? Please.
So I work for a law firm, and recently we had a few interns from them. They're reliant on, they were so reliant on AI that even to send out emails, they would put it through ChatGPT and Perplexity. And after a while, it becomes so obvious, when you're reading them, you're like, okay, this is not how you talk, this is not how you draft. And how do you tackle that? Because earlier on in the panel, someone mentioned that communication is key. And if students are not taught that in their educational days, it becomes very difficult as a professional for them to grow or understand the importance of, how communication is important. Because as someone rightly said, that you make money for communicating. That's what lawyers do. And this is the one thing that they're lacking on. So what advice would you give to law students for these things? Because it's too much. It's too much AI at this point, so I just wanted to ask you that. What are your opinions regarding that?
Well, let me begin by asking stakeholders that if you are in the legal ecosystem, stop using AI for your day-to-day routine stuff because it's getting identifiable very quickly. Also, your creativity is going for a big six. None of these students or the interns that are coming in want to think creativity or think out of the box. Why? Because they think, well, let me go to the paid version of GPT-4o, and that's about all. I'll have 10 points, and what I will talk, nobody else will talk, and that's good. Well, very quickly, you'll have to start realizing you are on a way of decay, a way of stagnation. So interpersonal relationships will be more crucial, but at least people need to be sensitized. Today, youngsters come in and they think that they are so tech savvy that their so-called law firms or employers will not even get to know what they are currently doing. I think it's a mindset we'll have to slightly change, but it'll take some time. Don't expect overnight things. I'm not expecting that. But over to you. Thanks. I like to add here. See, writing a mail, maybe it took for me 5 years how to write a mail, and I learned from my seniors. Now, if a student is attempting to write a mail, and I know he's using ChatGPT, we should not be discouraging so much. I think he's trying to cover those 5-6 years which I have gone through. So they are taking their baby steps. Eventually, they will also, as in morning session, it was told exponential learning. So life is all about exponential learning. So they are maybe they are lucky to have ChatGPT at first step. We didn't have. So fine, it is. You can take it with a pinch of salt that they are at least making it an attempt.
I would just answer you that first I'll compliment you that at least you have that knowledge of identifying whether it is coming from an AI, number one. So I guess that's the first part of the answer, that if these students are getting, I guess I am advanced enough to take it up. So I'll just give a small example. So at my law school, I frame, not really, I am ready with an open book. Again, gone are those days when I'm going for an open book exam. Today I'm going for an open mobile or an open internet answers. And I myself check it whether my question is there and whether the chat GPT 4.0 is, I have that paid version of it. I use Gemini, I use, it was earlier Bard, it was coming on to, whether it has an answer to it or not. And till the time it doesn't has an answer, that question is not posted to the student. First part. Second, I can tell you my internship days, and then the legal databases like Manu Patra, like LexisNexis is the off lately thing. But Manu at that time was a big thing. And when I'm talking it to be a big thing, I was scolded by my senior and a senior advocate at Supreme Court that no, go to the library, take that AIR, write on it, and then bring it to me. I don't want this shortcut of getting into Manupatra. And as I said in my opening remark, we need to remember it is just a tool. And this is specifically for my law students. These are just tools. Don't let the tool become the master and the master become the tool. That's a simple answer to it. And with the technology, believe me, the times would be there. And I agree when Pradeep sir rightly mentioned that when in 80s computers were there and it would take away the job of the people. No, because it is made by a human and it would again be an artificial. I would even bring in yesterday's thing. Okay, so everybody could have predicted, and I don't know whether you have done that or not. You could have predicted yesterday's match results on AI. And it was a predicted meter there. I would recall it back. There was a chance where it was showing 17% to India and 83% to South Africa, where 30 runs were required for 30 balls. But the result, yeah?
It was 3.5%.
Okay. So sir was way too advanced to see that thing as well. Well, I was like, no, I am focusing on match as well. So, but the result was something which AI would have never predicted. And sir, when he's mentioned about 3.5, I can again recall Melbourne, India-Pakistan match where that particular thing. So first, we as where when we are a step ahead as teachers, as law firm people, as even judges. So we need to be, I am so happy to see the Supreme Court where my justices are with their iPads. And that is also a change, believe me for this. So this is a big change that I'm seeing. Okay, if the submissions to whom it is submitted is well advanced, and we are recognizing it to be a tool. So I can easily recognize even by the first phase of it that it is an AI generated thing. I can even tell you the ways to wake up to it, how to meet that thing. And there are technologies. I can name the AIs right now, but again, that would not be a good thing as a law teacher to take it up. But yes, that's rightly mentioned. The law schools have taken that step up. So law schools are providing the master's degree where technology and law are coming together. The teachers are well equipped with it. And I guess that's a very clear answer. Plus, this is also giving you an answer to put a filter up. So that is all for my side.
Because a question is posed more to what you teach. And the question is, why are the law colleges not teaching reasoning, logic, analytical writing? If we are also saying go ahead for ChatGPT, no, nothing great. This analytical part, the ability to think out of the box, come out with a new solution, is dead out. Why are you doing that? So I am asking that question to all our law colleges here, and I request you, please go back and look at your writing. How much of actual logical thinking, reasoning, analytical writing is being taught? Not. India never teaches logic in the undergrad, and very rarely even post.
I don't agree.
Yeah.
I would love to see the curriculum.
It's a simple generalization. You see legal education post independence, and you make you see legal education post independence, maybe from 50 to 80.
88 back.
Yeah, and then you can again see from 80 to maybe 90, and then you can see post NLUs, and then you can see post maybe private universities. There's a sea change. You can't say that law schools are not doing anything. They are not. They are not. They are. No, I'm not offensive. What I'm saying. Yeah.
My question, sir, is very simple. What the candidate asked you actually makes us think, I am as a professional, as a managing partner of a large firm in the country, you as a dean of a college have to think about it.
See, you are questioning her question.
You are right.
Her question was, is student are writing mail from ChatGPT? See, student is taught how to write right from class 1. How to write application, how to write mails, and they all are writing. You can't expect everything for law schools to do.
If I just may add, just to her question, I believe these are just to add on to this these are comprehension issues as well that we're looking at. If there's somebody, and I'm looking at it from a professional angle, if somebody can't, draft a basic email, is that a person that I can really give a draft of a legal proceeding or a basic CND notice? So that, because then this AI becomes for me an associate intelligence. I don't need an associate. I have AI as an associate. So I'm not saying don't use ChatGPT. Even the Supreme Court today is using an AI tool for translation into vernacular languages. Recently, even a Gujarat High Court judge has said that I used for my case law searches, I used ChatGPT. Like I said earlier, use it, but don't be reliant on it. Basic stuff like writing emails, drafting cannot be supplemented because, today all of us who are sitting here as professionals have spent years and years to develop that craft. And while they can use ChatGPT, the question is, are we developing the craft properly? If you remember when social media came in, firms started blocking, you couldn't go to your office and access social media. I feel there could be a time where there could be a blockage, but even if you're using ChatGPT, you can only use to this much extent. You can't use it beyond that. Today, you can't access a Facebook, or Instagram in most of the offices. Leave aside, law firms. I feel this could be the next prohibition probably at the firms in terms of the technology aspect.
With the permission, can I make one comment, please?
Please.
This is to Pawan. Pawan, you say that after 3 or 4 years, the things are going to be very, very difficult. But to me, there are only 26 alphabets. We create so many words, so many sentences. Now, what AI does, AI is a tool, just a tool. What does it do? What the machine learns? Whatever prediction has been given, they capture it and they store it. Now, when we search it, we get those predictions only. And under a different types of assumptions, under a different types of environment. But today, when a judge is going to give a decision, the context has changed, environment has changed, scenario has changed. So he has to use his own acumen, his own understanding for giving the judgment. He may use them as a tool, but he cannot use them as a judgment. So that's my take.
Thank you, sir. I mean, you're bang on target. My only thing is the tool is getting so powerful that if you have the wherewithal, the ability, and the will to misuse it, you can misuse it with that much ease. And when the super intelligence comes in by 2027, it'll actually supersede the cumulative intelligence of humanity as a whole. So if you're using it in positive sense, wonderful. 2 things. Number 1, how do we control it? We still have no idea. Number 2, assuming somebody wants to misuse it, then the potentiality of that could actually have a huge disruptive approach. Again, this is based on what is available on the horizon right now. In my recent book, Super Intelligence and the Law, I've argued that the time for building the legal guardrails is right now when you're building AI. Because when it's a super intelligence that's coming in, by the time you realize that it's beyond you, the game is over. You'll be at no point of time be in the driver's seat because this super intelligence will always have the ability to be potentially used against humanity, against human interest. And in the coming times, I'm expecting more and more judges, more and more legal professionals to just give their propositions to the AIs just to get an idea, just to get an inspiration. Yes, we will have to disconnect ourselves, but somewhere down the line, to the extent we can use the constructive areas of the utilization of this tool, it's great. But again, sir, it's all about traditional thinking. If we are trained that we'll only use the tool for a particular amount or for a particular quantum, then I think we are far more well equipped to deal with these changes. But if you think everything is dependent on ChatGPT, from morning till evening. Well, people are not realizing with the latest version, ChatGPT 4.0, they have now created a new function. It's called the memory updation function. It is constantly creating a memory file about you. Everything that you talk about, everything that you ask of is being documented in a memory file, which tomorrow is going to be used for the purposes of making you listen to music that you would want to listen. So basically, it's going to be customizing the answers in such a manner so that it can suit your particular appetite. So it's a very interesting times, very dangerous times, but it's interregnum times and we'll have to be prepared.
That's absolutely fine. But it is throughout the human life, we have seen it, where there is a technological disruptions. People have either used this as a boon or as a bane. So this is also going to be used. If you can use it, it will be boon, otherwise it will be bane.
Thank you so much, sir. With this, let's wrap up the discussion. Thank you so much, panelists.
Thank you. Thank you so much. Thank you so much to all our panelists and also, of course, for all of you for sharing your experience as well. And Costa for moderating that. Thank you. With that, time for our last panel discussion of the day on integrating ESG and climate consciousness in law. And to share their views, please join me in welcoming on stage Amit Kapoor, Joint Managing Partner at JSA Advocates and Solicitors. Joining Amit is Dr. Sanjeev Gemawat, Group General Counsel, Vedanta Group. Joining them is Zamir Nathani, Group General Counsel, Kar Dekho. Joining them is Vaibhav Kakkar, Senior Partner, Saraf and Partners. And this session will be chaired by Dr. Ritu Gupta, Professor of Law, NLU, Delhi. Let's please welcome them, ladies and gentlemen, to the stage with your round of applause and some energy and some josh and some love. Thank you.
Yes, I'll check so that
Right, you can see him there.
Hi Sanjeev, how are you? Hi Sanjeev.
Hi, good to see all of you. Good afternoon. Hi.
Yeah, hi, very good afternoon, everybody. And this is the last session. Very deliberate and well-planned act of the organizers to having made sit an academician there for the last session. And what many expectations of the industry, which Professor Pradeep Kulsresh and my fellow academicians, we are here and will in our humbleness, all our humbleness, we are going to take all these suggestions so that we ensure that the future ready lawyers are there. But I'm very sure that, law schools are juggling to equip. See, AI has posed those challenges. I believe that everybody is juggling and so are the law schools. And starting from, the first panel, Professor Sudhir was there, and before that, Justice Midha. So whatever has been pointed out, that's very well taken. But at the same time, I invite all the industry experts and the panelists to have refresher course who feel that they have not had enough in their law schools and not enough was taught there. So let us top up your knowledge once again with the freshest courses in different subjects. So to begin with this panel 7 on which we are going to talk about something which is very important other than legal education, but at the same time, which we think that we need to inculcate in legal education. And I welcome all my fellow panelists here, and I have Dr. Sanjeev Gemawat here, who has joined online. Hello, how are you? And I hope you are doing well and ready to answer all those questions that not only, you see, the kind of weather that we are facing, environment, all those issues which talk about climate change, those issues which pertain to global warming, that pertain to environment in Delhi and all that, all those problems that we have been facing, that's one. And the second is social. So when we talk about all those, social things, whether there has been a fair play, whether there have been implementation of labor legislations, and when we talk about governance, so be it corporate governance or be it any kind of transparency, accountability. So all these issues we are going to, all the industry experts are here with whom I am going to steer through this session. So my question goes to all the panelists here. And my first question, if you have to come back to your law schools, which course do you think in ESG, which kind of module, which kind of course, which kind of course content or syllabi would you recommend for the law students? Over to you. So it should be all of you, one by one. And choices module.
I know. No, but the advantage is you speak first, the last guy has a problem. So good afternoon, everyone. And so my name is Zamir Nathani. I am the Group General Counsel for Car Dekho. Car Dekho is in the limelight because Amit Jain also is now on the Shark Tank. I head the ESG in the company in addition to the legal compliance and governance. If you ask me the question on what is the kind of course or the curriculum we would expect if we visit the university, I'll divide this into 3 parts. All right. So just I'll give you some background of the information. Like, for example, $20.9 billion were allocated in United States 5 years back for any company which is focused on ESG. The overall fund dedication in Europe was about 132 billion. Okay. So when we are talking of these numbers, these are equivalent to the richest people in India. Okay. So that's the kind of numbers I'm talking about. Number 2 is that when you speak about ESG, there were certain incidences which had taken place and what was the kind of impact it had created on the companies. I'll give you one example is about Petrobras or for example, Enron, all right? Or there was a Gulf oil spill which had taken place. The shares of those companies reduced by 50%. You can imagine the loss which was consumed by that. All right. So these are the 2 critical things which are now being factored for ESG compliance by your investors. Okay. Now, when you talk about the 3 things which you should put down in a course in ESG, number 1 is what are the ESG compliance from an environment, social and governance perspective you're looking at. Okay. Like for example, when you speak about Car Dekho. Now, my business is about selling of used car, new car, car insurance, and car financing. These are the 4 mandates I've got. Now, used car, of course, when you take as a standalone company, the emission rate is very high because when you sell anything which is used car, the emission is high. So what did we do? We increased the sale of the EV car to offset the ESG impact. Okay. Number 2, most important, when you conduct that ESG activity, there's a report known as Business Sustainability and Responsibility Report. All right. BRSR report, BSR report, which is there. This is your ESG report. So with all the data you have collected, right, from your electricity bill to the air travel, which has been done by the people, you arrive at a number of emission. For example, 800 is your emission. That BSR report is your second subject matter because it shows what is the impact which is happening when you have the ESG compliance in place, how you can reduce that particular emission level. All right. And third is the recognition which you can get on a global stature. All right. So when Car Dekho came out last year with their first ever ESG report of one of the unlisted startups with high disclosure, we send it to the United Nations Framework Convention on Climate Change. There is a recognition of bronze and silver as a starting point you have got. So I think the meaning of the ESG part, which has to be covered in letter and spirit, ESG report, and global recognition, which the entity can obtain or by filing it with various authorities like United Nations. I think these are 3 points I would like to
Right.
cover in my curriculum.
Yeah.
Thank you.
So from after listening to unicorn from unicorn's mouth, now we can have Amit. So what would you like to say from JSA?
I would love to see a curriculum, and I'd love to go back myself and encourage my partners, where you would train lawyers to look at risk and value in changing realities. So I would say that when you're looking at the AI development, you're looking at the digital platform, you're looking at climate change. How is a lawyer to understand the legal regulatory policy and the commercial realities, and to re-equip the business that they are assisting and working with to realize value and mitigate risks? Unless you are able to encourage lawyers to start thinking out of the box beyond Section 5 and Rule 3, to engage with the real world, we will always have a challenge that most lawyers in practice find. And therefore, law schools have to move to that level where they integrate the knowledge with technology, and management schools, and provide that kind of training. We are unfortunately a little distance away. I think we are moving in that right direction. Some of the private universities are coming around to it, but I have still found, because lots of youngsters, every year we are recruiting people who are coming from these law schools, who ought to have done the cross credits, but I don't find the genuine cross credits. And that is a gap, which is a skill gap. I'm not on the dais to criticize. I'm here to suggest so that we can do better. There is a lot to be done. As Pawan, my batchmate and good friend, said in the last session, the guardrails have to be built while you're flying the aircraft, not after you land. These are changing realities. Climate change is on us. Now, when the changing reality is in your face, look at Indian situation. Let's examine one question. You need to go through energy transition, which means migrate to renewables, while simultaneously securing energy security. We are still a developing nation. Citizens in remote corners still don't have access to 24 hours of electricity. They are still getting there. Industries are still struggling with it from time to time. Now, in that scenario, we can't give up coal. Yet we have to migrate. Now, this is a real world solution, which will be found not just by looking at law, not just by looking at economics, not just technology, but pulling it all together. Are we now in a situation where we can offer to lawyers in practice every 5 or 6 years to go back to a law school in an integrated course, 1 week, 2 week program, where they could re-equip themselves in any such scenario? That is the first thing I would look at, and I would love to see that. And I will do that till the last day of my life, because keeping yourself engaged with realities and the future is all there is to your being alive and successful as a professional and a living person. Thank you.
Yeah, Babu.
Thank you. Thank you for that question. First of all, good afternoon, everyone. My name is Vaibhav Kakkar. I'm a senior partner at Saraf and Partners. When you look at the term ESG, it has actually 3 components to it: environment, social, and governance. I would like to particularly focus on the last one, which is governance. See, if you look at India's sort of business climate, you look from how post-liberalization, how our capital markets have done really well. Most businesses, which about 15 years back were largely promoter-owned and promoter-controlled. Today, when some of us do IPOs of companies, we don't even know who the promoter of the company is. Most companies these days, the startups, by the time their growth story goes through an engine and they get to the IPO mode, there's so many institutional investors, private equity, venture capital investors sitting in the company, that the promoter or the founder is actually sitting with sub 10% equity, very similar to what the US culture is. And in that kind of paradigm where promoter holdings are going down, this overall framework in which businesses were being largely run as promoter shops and they would run businesses as they please. That is changing. There is now a responsibility that the board has towards all stakeholders. The key is now that they're not accountable just to the promoter. And if they will be accountable just to the promoter, you will see all kind of messes that happen, a lot of scams that happened in India over the last few years. So company has to be a separate sort of accountable player in the sector. You will not be seen as being only answerable to the promoters. And you know that Lala mentality will give way to professionalism because investors also in the unlisted space. Full disclosure, we are representing one very large founder of an education tech company, which is in the middle of a lot of news. But you're seeing across the board, where the earlier shareholder activism was largely seen in the listed space. You're now seeing that in the unlisted space as well, where equity investors, institutional investors are sitting. And those institutional investors look the other way. And I'm not calling out any names here. If any delinquent founders or any notorious founders are not booted out when they see anything wrong happening, then even those investors are questioned in turn by their own investors who put money in those funds. So I think governance is, I think, going to be an important focus in times to come. And shareholder activism is one course or one subject that ought to be definitely a credit course in law schools. Class actions, shareholder class actions. That's another sort of area where, Indian law is nothing but a cut copy paste of the US law. Insofar as class action is concerned, very recently class action proceedings have actually started. Incidentally, we are on one side and his side is on the other side, where we are actually trying to pursue a class action. So I think shareholder activism is going to be one very important area where we will see a lot of action, and therefore that's one area that law school should really focus on. One very quick point also would be the fact that, as both fine gentlemen sort of pointed out, if India has to reach its goal of becoming a $10 trillion economy, we need a lot of capital. We need a lot of equity and debt money. And guess what? We as a country don't have that much. That's the harsh reality. All of that money will come in from the developed world. India on the debt side has now been added to JP Morgan index, and you saw almost a $20 billion upswing coming in for India on the government securities side. So all of that money which will come in from the developed world will come in with riders on ESG, because they are now taking it very seriously. And I say this with utmost responsibility. It's because the global West has screwed the environment. They have completely damaged and consumed the environment in a way. And India, therefore, as a country with the highest population in the world, has a very, very important responsibility of making sure they take everybody to the growth path, as Sir was pointing out, but at the same time making sure that we keep environment in mind. And therefore, what will happen now is there will be a lot of disruption India will see. So even at a macroeconomic level, if you see, India is a country which is extremely dependent on all other global countries. So each time there's a global conflict, India's balance of power crisis starts happening. So India has to very quickly move to new technologies. So just like how India almost saw a jump on the internet side where computer and laptops just gave way to smartphones, EV technology will now move very quickly. So I think what law schools now need to do is look at the global models. What are the new forms of technology that are being embraced, and run courses around, for instance, regulations around what EV technology will look like. What are the various components of it? So you have to almost anticipate what could be those new disruptors. And I generally think India will see an EV movement far quicker than most of the Western countries have. Just like our UPI. Our digital payment system is one of the most developed in the world. And it happened in a way that most other countries are not able to understand at the pace it did. So I think similarly, you will see those kind of changes, in law schools also need to have courses around those.
Yeah. So Sanjeev, would you like to add something to what all these three gentlemen in the panel, they have suggested too many things. What would you have to add?
So that is the difficulty, that they have suggested almost everything. But then first, let me thank BW Legal World for inviting me to share my views on this topic. But, Ritu, if I go by your question, I think fundamentals have significantly changed. And that is what the reason of the discussion today, what we are having. And when I say the fundamentals have changed, even the concept and relevance of ESG, when it was introduced 20 years back in 2004, that concept had also undergone a change today. And I will give you a few reasons for that. When this concept came 20 years back, 2 decades back, at that point of time, there was a report, and report was Who Cares Wins. And it was basically in terms of the investment criteria or to give credence to non-financial elements in financial decisions or investment decisions. But then since then, this concept had undergone a complete change because of two major reasons. One is there's a complete shift today from what we were talking about shareholder capitalism, which was propounded, in late 70s, early 70s. And that concept of shareholders capitalism has changed to stakeholder capitalism. And so that is one fundamental shift. And the second fundamental shift reason was the fourth industrial revolution, as we were talking about those artificial intelligence and all that. So we are on the edge of fourth industrial revolution, and we have changed the concept of shareholders capitalism to stakeholders capitalism. So it essentially means that there should be a purpose for all, and that purpose for all should lead to growth for all. And the moment we think about these concepts, and you will realize that this is not only just a climate. Some basic data, if you notice, last 50 years, we have reduced nearly 70% animal population got reduced. Still, in terms of emission norms, we are 30%, we are using, fossil fuel. Now, all these are just a reflection, some data points, but then do we have a solution? So we don't have. Now, to find a solution, we will have to essentially go by these concepts of ESG. And when you said that the legal education part, I think legal education, because of these concepts, the fundamentals of education had completely undergone a change. So it is not the legal education in terms of only the legal aspects of legislative framework. It is basically the profession is now aiming at in terms of or addressing the societal needs. And that is the big transformation which has come as far as the legal profession is concerned. And we all know that professions do evolve, professions do get created, and they get created because of the societal needs. And societal needs suggest today that in the fourth industrial revolution, with technology, with innovation, government would have very, very limited and restrictive role in terms of controlling corporates who would be controlling the lives of people. Now, somewhere we will have to discipline ourselves, and that is why the reason of in terms of or the concept of ESG becomes relevant. So ESG, from a traditional concept of giving a number to a non-financial parameter, it has gone beyond all that understanding also, and that is what the I think is requirement as far as the legal education is concerned. So this is what my initial thoughts on this is, but then I'm open in terms of further questions on this.
Thank you, Sanjeev. And before we move on to the second round of questions, we invite Professor Bandyopadhyay, Professor D.K. Bandyopadhyay, as one of the panelists here. So please welcome and join the panel. Professor D.K. Bandyopadhyay is Chief Advisor and Chairman, Law School, Amity Group. And sir has been former Vice Chancellor, Guru Gobind Singh Prastha University. Welcome, sir. Yeah. So my next question, and that question, sir, I'll start with you. What kind of skills and competencies do you think when we are talking about all these ESG, the things which are relevant to future world, say 5 and 10 years down the lane? So what are the kinds of competencies and skills that you think that we as academic institutions should equip our budding lawyers with?
Thank you, Ritu. Thank you, my panelists over sitting over here. As hearing that, they were all looking at the ESG concept from a different perspective. But I have a totally different perspective in my mind. My perspective is that long time we have been discussing that if we want to survive in this planet, we have to balance 4 P's. One of the P is no doubt profit. Half of the where the business are lying. No business can survive without profit. Second is the people who are doing this business, who are associated with the business, who are getting the benefit of the business, who are the customer of the business, who are the supply chain members of the business. The people concept. Third is my mother planet, where from we are all taking the resources, whether it's the natural resources, whether it is air, water, mining, everything, coal, petrol, everything we are taking it from mother planet. So these three P's, unless and until we create a balance, the world is going to be destroyed. Why? Why these three P's are becoming very important? Because every one of us wants to live in this planet with peaceful mind. So the concept of the four P's are very much lying over there in the discussion forum of the committee of COP 21, COP 15, COP 26. And COP 15, Committee of Parties, they decided that the developed world must give billions of dollars, at least $100 billion to the developing countries. And this $100 billion, when they saw in 2023, they were supposed to come, not a single penny has come from the developed countries. It is the developed country who has actually spoiled it. It is a developed country, in the name of their development, they have totally disturbed the balances of the 3P. Now, if that is so, if the money is not coming from there, where from money comes? Where from money comes? That's the reason the concept of the ESG has come up in a very, very big way. That if you are a company, whatever company you may be, you have to follow the different parameter. Previously it was BRS, now BRRRS. You have to follow it up. You have to get it audited. And it has been made compulsory for the at least 1,000 stock listed companies. It has been made compulsory, and now developed countries have realized we are not able to give money. Then at least whenever there is going to be any export coming to us, or we need to import to any other countries, we must follow the environmental parameters. And if we do not follow this environmental parameter, possibly the things cannot be sold. Many times our Indian products, when they are getting exported, they are getting rejected by the developed country because we are not following those environmental parameters. So coming back to the point, this is the way how the company is going to take care both the financial and non-financial part. The non-financial part comes to the ESGs. Now, our students, coming back to the point, our students must be well versed on the skills, specifically the law schools. We have got plethora of laws, Pollution Control Act, Water Act, then your Money Laundering Act, your SEBI Act, all the acts are possible, and in pieces, millions, they are in existence. But there is no as such any ESG regulation till today, ESG law today. So there is a need for formulating an ESG law. That's the point number one. Point number two, the law student must be well aware what is the actual balance we are talking about. Where from the money will be coming. And this money will be needed in terms of use, reuse, reproduce, recycle, and reproduce. These 4 R's are going to be very, very important for us in future life. So our students should be sensitized about them and the skill they needed in terms of understanding these environmental issues. They need to understanding the social issues, how the society is going to be hampered. Today we are seeing the floods, we are seeing the temperature rise, we are feeling the temperature 45 as 55 degree temperature. Why this type of things have been coming? These are all due to this parameter. So our students should be in a position to understand and to actually capture those skills.
Right. Thank you so much, sir. And my next question for you, Zamir. So what I want to ask, in last sessions, we have talked a lot about experiential learning. We have talked about clinical legal education. So what do you think when it comes to drafting of the contracts? So sustainability, how do we equip our students to add on to that component of sustainability to those drafting skills?
So, today when you draft any contract for shareholders, for example, when somebody is investing in your company, all right? Now, of late, last 2 years, you have seen, and very recently, if I talk about some 6 months back, you've seen these contracts having ESG clauses. And initially, 2 years back, they were just clauses in an agreement, which is about 4 lines or 8 lines or probably 3 paragraphs. The recent contract, which I saw 6 months back, had an admixture of the compliances which are required for ESG. All right. So initially, 2 years back, you would see an ESG clause saying that you should have a ESG policy in place. 1140. So one of the if I want an easy example which you can access, go to the website of Invest and Labor. All right, they have ESG policies which are put. They're all 4-5 pages per policy. So that was one of the first things we also did. Not even 100 or 200 pages policy. We draft principal policies about 4-5 pages, which you will not only implement in letter but also in spirit. Okay. So now your contracts are specifically having annexures on what compliances are required. What policies are in place. All right, your governance mechanism is there. The board meeting is conducted in accordance with the governance norms, etc. With part out of that list. And if you don't comply with that, it's a breach of contract, which means the contract can be terminated by the shareholder investor and there can be consequences flowing to it. All right. So initial stage was that you had contracts where you put our best effort to have an ESG policy is now converted into an obligation. So what I feel is that once you understand the concept of ESG, ESG report, which is a SR report, SR report, what we call a business responsibility and sustainability report. And then you have the total global practices, Indian practices, global practices put in place. I think 3 things which will remain now fundamentally becoming part of the contract is scope 1, scope 2, and scope 3. All right. Just to give you a simple example of scope 1, scope 2, scope 3. Scope 1 means the electricity which you are using right now in this premises. Scope 2 will mean the electricity which is now provided by the electric company from whom you are taking this electricity. And scope 3 means the electricity company which is giving you the electricity, how are they buying out their coal or electricity? Okay. So when we were sitting at Harvard Business School and discussing about BMW case, scope 1 for BMW is what they are consuming. Scope 2 is that what are the consumptions or the ESG compliance of the partners from whom they are putting out these suppliers. And scope 3 is what are their suppliers doing to comply with ESG norms. Right? That's the requirement of the fundamentals of ESG which is coming up now in the contracts. So I think it's not only implemented in letter, it's required in spirit. It's not a best effort basis. It's not becoming an obligation for ESG compliance. That's the way forward I see.
Yeah. Thank you, Zamir. And my next question is to Amit. What do you think, whatever Zamir just mentioned? Say, if we talk about 10 years down the lane, what else do you think that students who become future lawyers will have to keep in mind? Like suddenly we had to face this chat GPT, we were talking about AI. So if something of this sort happens in as far as these ESGs are concerned, so what are your advice to those students?
So you heard from one of the leading practitioners in cyber laws in the previous session. And he said, we don't know what will come in 2027. Now you're asking me to tell you what is coming in 2034.
Yeah, and that to be...
So what is coming is the fact there's a future which is evolving.
Yeah.
Therefore, what the students and practitioners, even me, has to be alert to is the changing reality and re-equip yourself. You have to constantly engage with the changing supply chain, changing realities of the world, changing demand of the competing economies, and retool yourself. Now, what that technology will be, God knows. Are you equipped to handle it? You jolly well should be. Otherwise, you'll be left by the side. You'll not be able to assist a client. Do you understand their needs? Well, this is your job because you are ultimately providing a service as a counsel to assist them on handling risk, on actualizing value, on developing business propositions that are going to sustain. So that's the whole play. It is not a set of issues which you can put on a sheet and say, all right, year one, I'm going to read this, year two, I'm going to read that. No, it's a dynamic, evolving reality. Your ability to change with the reality and your ability to keep ahead of the curve is the basic.
Right.
That's what all you have to do.
All right. And my next question is for Vaibhav. So when we are talking, these ESGs, while doing this ESG due diligence in your respective corporate firms, so what do you think, what is very common thing which is usually overlooked? Because ultimately you are there for profit. Everybody is. So what are those things that usually firms compromise with?
Yeah, so I think, look, even today, the reality is that if out of 100 M&A deals or 100 investment deals that we see, most of them have ESG completely missing. Until and unless the investment is coming in from, say, a developed world, it's coming in from certain investors in Europe, certain kind of investors from the US. So not all investors from the US and Europe also, by the way. So it's a certain pedigree of investors who raise capital from their own investors on the strength of giving commitments for ESG. And it's those kind of investors who actually get ESG diligence separately done. Because as law firms, the reality is today, it's mostly a compliance-driven analysis that lawyers do, which is making sure they have all their environmental clearances, they have their environmental certifications, they're complying with all your labor laws. And generally the framework of governance. That's the overall sort of tick the box, light touch kind of compliance driven diligences that are actually undertaken. That, however, as I said, the color of money and the quality and the nature of money is driving specific ESG diligences. I must share with all of you that about a year back, and I was sharing with some of the other panelists offline, that I represented one of the large listed Indian private sector banks, which raised a few $100 million from a big multilateral global institution, And when they gave in that money came in as equity, it was perhaps one of the first green equity deals. Why? Because when that global multilateral institution gave in those hundreds of millions of dollars to that bank, they put a lot of riders. They said, going forward, you will not finance thermal. Going forward, if you finance a project which is not going to be carbon neutral 5 years later, you will not finance them. And so on and so forth. So they put a lot of riders on that equity money. And one very interesting issue that we actually had to deal with was that the board of that company, it's a large listed bank with no promoter, and so a lot of independent directors, and they were all saying, why should we take this money with these kind of riders? Because this will affect the growth of the bank, because if bank has the ability to lend to certain thermal power projects, why not? And why should they deprive themselves of the opportunity? So as Professor Sir said, profit, you cannot leave that issue aside. So the bank had to really struggle and say, why should we take this equity from them with so many riders? But eventually they all realized that, look, if you want to be seen as a go-to bank in your sector and be also regarded as a top bank globally, somewhere you'll have to take these poison pills. Which might be viewed as being poison, I beg your pardon, but certainly in the long run, will catapult you into a different growth story. And that's what happened with them. And so if you, like I said, I'm repeating myself, but very quickly, you want that global pool of capital, those changes will happen as a result of that. It's ironic. I mean, I know these changes should happen organically with the kind of climate change that we're seeing happening around us. I mean, I was just telling somebody, if anybody now tells me climate change is not a reality, I would smack them for having spent 1 month in Delhi. They experience the kind of heat and then 1 day of rainfall and look what happened. So look, I think the reality is if organically we will not change with the climate, the money will make you change. And the money flow is now going to be driven by those requirements.
Absolutely. And my next question goes to Dr. Sanjeev. So, lot many things we are talking about legal education and academia. So, if I ask, what are the measures that these corporate firms are taking to reduce their carbon footprints or promoting environment sustainability? So, if you could share industry experience on that.
Sure. I think, fundamentally, let's first understand the fundamentals. Fundamentals are that, yes, ESG is now not only it's not a fashionable word, so to say. Organizations are seriously complying with those ESG norms. One is certain legal mandates. And even if there are no legal mandates, there are organizations which are focusing on these agenda items for the simple reason that organizations do believe that as those that World Economic Forum rightly puts it, the all organizations have one objective and universal purpose, and that universal purpose is continuity for all the stakeholders, not only the owners or promoters, but also so many other stakeholders, like from government to employees and so on. So now, with this kind of thought, there are mandates available today from as the professors have also mentioned about BRSR reporting and all that. So all these mandates are being followed by the organizations. But then I have also noticed that there are many organizations who are having only single focus in terms of all their business activities, even if they are diversified businesses, and that single objective is enter into all those businesses where the focus is on decarbonization. Now, that is a big shift, as Professor Saab mentioned about that profit motive would always be there as far as commercial organizations are concerned. But then organizations do realize that they have certain duties and responsibilities towards society. And the whole purpose is that the organization should be serving all the stakeholders. I think that's a big shift, big change in terms of the overall thoughts as far as business organizations are concerned. But then if I come to specifically the legal profession, and the sense it's gathering of the legal students, I see that from a legal student's standpoint, they cannot be just limiting themselves in terms of the legal framework which is available today in terms of compliance of those ESG related norms. And whenever we are talk about ESG, we are just limiting ourselves to climate or environmental issues. But then ESG is beyond all that. It's also on the governance part, as Weber also pointed out earlier, from governance to social related issues. Also, compliance is on that part. But then, so the biggest thing which is required is from a legal profession standpoint is that the students or the legal professionals should have that a business orientation, and they should realize that whatever they do in terms of whether from a litigation to contract to compliances, if anything wrong is done, that may lead to a severe and adverse or a grave impact on the organization from a reputational standpoint to business disruption standpoint to financial obligations standpoint. I think that realization would give them the thought that how and why ESG is not a fashionable term. In fact, it is the base of the organization for the 21st century. This is how I look at it. Yeah, thank you.
Yeah, so Professor Bandyopadhyay? In a nutshell, I'd like to flag 3 points. First point, the law students should understand the jurisprudential side of ESG. Why ESG came. What is the rationale behind the ESG? Because carbon which are there in the atmosphere is a very long term, 100 years they stay. But we can reduce the carbon footprint year by year by year. So tonnage, gigatons of carbon can be reduced if we are able to follow certain procedures. And most of the companies which are now compelled, no company will be willing to do it, but they are compelled to do it because there is just so much of pressure from different corners. Even the head of the institution, they have started speaking about, we must reach the goalpost by 2030, then they have reached to 2045, then said 2070, the net zero concept. Now, if the net zero is the concept for the survival of the mankind, then essentially the jurisprudential side of the ESG must be understood by each and every law student. Why I am doing it? Otherwise, even the company, they must understand why they are doing it. because they are indirectly financing it. They are indirectly through the ESG compliance, they are financing it from the source to the sink. So this is my take.
Absolutely right. And thank you, because the mandate from the organizers is to wind up the session. And I'm very sure that through this session, all the panelists have contributed and flagged this important issue, that future lawyers should be well equipped and well trained with all those, awareness and learning of the legal framework about ESG. And of course, that consciousness in the society. So that social norm is also there. So with that, I thank all my panelists and I thank Dr. Sanjeev for joining online. And if the panelists would like to say any one of you in one sentence, any message for law students.
I think I would definitely like.
So just one sentence.
Yes, like to re-emphasize what Professor said. Climate consciousness and doing things in your own sphere is the start point. For example, 1 unit of electricity that you consume from coal versus solar, rooftop solar, is and wind is 178, literally 1.3% of the same amount of carbon footprint. So without doing anything, by just that substitution, you are able to help the environment. And there's so many other things, single-use plastic, various other things that could be done, carrying your own cloth bag in your car or along with your bag whenever you're going out, rather than taking plastic from the store. All of these can make a huge difference without our realizing. So minor adjustments can go along.
Absolutely. So this is what.
Sentence for the law student, that try to take up ESG as a career. It has a bright future.
Thank you so much. And all these suggestions from the panelists and all those exhibarating expectations of the industry from law institutions and law students. So here I just hand it over to Ashima and the organizers. Thank you. Thanks.
Thank you very much. Thank you.
Thank you.
A picture, please.
Second one.
Yes.
You want your picture?
Thank you, sir.
Thank you to the moderator also. Yes, thank you.
Never, yeah.
This much autonomy we have.
Bucket of yes, considered social factor on yes.
Yes.
She was able to thank you, everyone.
Yes,
Thank you.
thank you.
That's how we have.
Thank you very much.
Thank you, sir.
Yeah.
Pleasure being on with you.
Thank you. Thank you so much.
Thank you.
Thank you so much, sir.
Thank you.
Thank you. How much am I? It wasn't a part of my fundamental.
Thank you. Thank you so much to all our panelists and also to Dr. Gupta for sharing that session. Thank you so much, ma'am. Thank you. Next is a fireside chat, which is on chalking a career in criminal litigation. And please join me in welcoming on stage a senior advocate, Geeta Luthra, Supreme Court of India, and joining her to ask some grilling questions is Ashima Uri, Managing Editor of BW Legal World.
Good evening, ladies and gentlemen. It is a privilege to welcome Senior Advocate Ms. Geeta Luthra for this fireside chat with us today. A luminary in the field of criminal law with a career spanning over 3 decades, ma'am.
We don't want to say so.
And established herself as one of India's leading criminal lawyers, known for her exceptional advocacy skills, sharp legal acumen, and unwavering commitment to justice. And also, if I may add, nicest human beings that I've ever met, truly, in the fraternity. Today, we have the opportunity to learn from you, ma'am, and your vast experience and insights, and we warmly welcome you once again to this chat.
Thank you. Thank you, Ashima, and thank you, BW. All of you have been so gracious to us all these years.
So, ma'am,
thank you.
We're very blessed with your guidance on matters that we call you on for to discuss. And today, we'd actually like to delve into your career and drive inspiration from how you've built such a formidable practice for yourself. So, was there ever a moment that you decided that, okay, criminal law is my true calling?
So I was fortunate. My father was one of the most leading criminal lawyers of the country. And one of the aspects when I started practice was, he said, "You're not going to be a lawyer. Women are not successful lawyers. There are no women in the profession." So we started with that, but all said and done, he didn't ever come in the way. He would be on the hockey field, encouraging me if I was playing hockey for Delhi, and if I was taking part in a debate or a moot court, he'd be there, and both my parents would be there. So I don't think I ever look back on the profession. But since at that time there were very few women, or there were no women virtually in the profession, my father thought that if it had to be an option, perhaps it could be service law. The arbitration wasn't as big a field as then as today. Criminal law was big, but white collar crime, which was his specialization, was not. I mean, there was a very niche area of criminal law where the biggest criminal law cases were Official Secret Act cases. And because I was fortunate, I got into a huge one because of him at the beginning of my career. But women would have been seen more happily, say in service law, matrimonial law, those fields of law, rather than criminal law. So my father was telling me, he said, "You do this." And I said, "All right, I'll do this also. But I'm not going to be restricting myself to that field." And therefore, I don't think there was ever a doubt in my mind. And I pretty much took everything in my stride, whatever came my way. We were very fortunate that one, the guidance of a person, even if you don't practice with them. So I had a friend with whom I wanted to work, and I got invited to various organizations, one of them Ford Foundation, to do their legal policy head. And I said, "But do you have two positions?" They said, "No, we have one." I said, "Could it be part-time for two people?" They said, "No." I said, "All right, then I'm practicing." So, so it went, and therefore, I don't think I ever doubted doing criminal law, and I ever doubt. In fact, there is a thrill in getting, when you are fighting for the liberty of a person. See, in civil law, a lot of the time, it's not liberty, it's property, it's commercials. But in the criminal law field, the stakes become higher. You're fighting for a person, proving a person's innocence or proving a person's guilt, whichever way you go. And one of the aspects where I was very fortunate is that whichever side I'm representing, I'm always convinced that they're 100% right, or at least 90% right. So that courage of conviction helps you to develop your argument and to look at what is possible to help the person either achieve a conviction or an acquittal. And I don't think I doubted myself.
Wonderful, ma'am. In fact, my next question, like you almost predicted in your answer itself, was going to be: have you have ever had a moment where you were faced by a challenge of your own biases or assumptions for a person you were representing in a matter?
So yes, one field that I decided that I wasn't going to do when I was doing criminal law was do rape cases. I said, I'm not going to appear for an accused. And very early in my career, there was a purported rape case of a person where the complainant had made the second or the third complaint, and you could see it was a tailor, perhaps, of whom she had complained of Sangam Vihar. And you could make out that it was a doctored complaint because the tailor was working for a design house and therefore not doing badly, but not well off. You know, he was living, but maybe he was better off than the lady. And so I said, look, but my conviction prevents me, and my promise to myself, I've broken that promise a couple of times later in life. But my promise to myself that I never do a rape case for a man or a accused is going to stand in my way. And I didn't do it. And I watched while in the sidelines, and I asked, in fact, my father to do the matter because I thought it was perhaps genuine. But since I'd promised this to myself, I said, I'm not doing it. And sure enough, the Supreme Court saw that this person had made, and nobody else was looking, because rape has always been looked at with so much abhorrence and as something which is so heinous to society that it militated even against the trial court, the sessions, the high court, even to look at the bail. But the Supreme Court looked at the two similar FIRs the lady had lodged, which were like verse for verse against another two accused, and said, you know, this is a trumped up case, and gave bail. But I didn't appear. I said, I can't. So yes, the courage of your convictions sometimes comes against you. And I've had this question asked to me for various controversial criminal cases, sometimes pertaining to Me Too movement, sometimes others, where I've been questioned, how can you be doing this, Ms. Luthra? And then you have to answer according to your conscience, whatever you think is right. And if you are really not convinced of a person's case, and if your heart is not in it, I feel sometimes we shouldn't be doing it for commercial purposes, because more justice would be done if someone else defends the case. So I think that's the only thing. Most cases I take in my stride, and I feel very strongly that an accused has an equal chance of defense. There are very often two sides to a coin. So it's not always all black or all white. Sometimes there are shades of gray, and sometimes what may appear black is white. So I go with the courage of my convictions. And I must say that the tougher the case, the more I like doing the defense, because I feel that perhaps there is that teeny weeny chance that I will get the person what I feel is justly owed to them.
Thank you, ma'am. We're currently at the cusp of the time when tomorrow the new legal reforms come in. What is your advice to the gathering here on building a career from your experience into something, stepping into something new? Of course, it comes with the background of the, the laws that we've seen and studied, and for the students who've actually, possibly mucked up the CPCs and IPCs with section by section. But how do you proceed from here? Do we have to balance ourselves in two boats, one of the yesteryear and one of the era coming forward?
Yes, I think when you talked and when the subject was chalking a career in the criminal law, I thought, well, we all have to start chalking a fresh career from tomorrow, which is 1st July. Whatever careers we've had in the past, now is going to be a new career because we'll have to learn all our 420 all over again. And I am telling you that according to me, this old wine in no bottle with some changes made it, and this is what I think of all legislation within India. I'm not restricting it to these three criminal laws. We do not have enough lawmakers who are educated in lawmaking. I don't mean parliament. I mean lawmakers, say, in the ministry, in the law commissions, who look clause by clause, sentence by sentence, phrase by phrase, to see is the expression legally tenable or are we leaving loopholes? Why would a PMLA need so many amendments? Why should an arbitration act need so many amendments? And why should the criminal laws be turned upside down? Retaining a lot of their substance, maybe 80% of their substance, but changing the nomenclature in sections. So having said that, I can see a sign saying time is up. And I'm very happy because there's going to be a very, very long answer. And the closing session won't begin if I were to start giving the answer. So all I can say is, I think we need to actually ruminate about it. We need to think about the new laws. We need to take out the sections where there are changes and just have final looks at it through expert committees before we actually start, because we already have so much pending litigation. We're going to enhance it many times over. The police, I read in Bombay, is just rushing to file the FIRs under the old provisions. From tomorrow, the new provisions will start, or will they do it under the old provisions? Everybody is confused, and they've had only 5 days of training. Can't have 5 days of training over this. So I can only say, good luck to everyone who's starting a criminal law career. Thank you.
Thank you, ma'am. Before we finish this, I know time's up. One last word of advice to our students and lawyers and women and everybody. The first day that you step in court, what would be your advice to them? What to take in, what to go expecting, and how to build the career ahead?
So my first advice to anyone who does criminal law, and this is despite the fact that they've been very successful criminal lawyers who've started at the top from Supreme Court and High Court and who've never come to trial court, is for God's sake, do some criminal trials. Please start with criminal trials. Learn. I go sometimes to the High Court and Supreme Court, and I see that those who haven't, and it's actually contemptuous virtually to say it, but those who haven't done trials don't know what cross-examination is, to the extent they don't know what proving evidence is. They don't know, because even if you do 2 trials or 3 trials or 4 trials, it's enough. You'll get a foothold to understanding law. Ultimately, to practice law, you may be very efficient, you may be very competent, you may be, one of the most erudite of speakers, but you need to know the basics of law. And I think to do a trial is to know the basics of law. Thank you.
Thank you, ma'am. Thank you so much for this wonderful conversation. Thank you all.
Thank you.
Thank you so much, ma'am, for doing that, and also Ashima for asking those questions. Thank you. And now it's time for our last keynote session, and after that we shall begin with the award ceremony. We wait for them to clear the stage. And the next and the last one for today, before we begin with the award ceremony, is a guiding thoughts session, let's say, and to share the experience, the thoughts. Please join me in welcoming on stage, or rather to the podium, Surabhama Chaturvedi, a senior advocate, former assistant professor law in NLSIU Bangalore. Everybody, please. Do you want a hand mic or this is okay? It's fine, absolutely fine.
Good evening, everyone. My colleagues, my senior colleague, Madam Luthra, and my future colleague sitting over here, and all learned guests from the fraternity and outside the fraternity. Well, instead of guiding, I would say I'm going to share my experience, which may have some guiding element, because I started from law school and presently in Supreme Court. So journey started from academia, where I saw law from the classroom, and then I came to practice assisting the court in interpreting. And then in between, I was fortunate, I got to experience some law making process. So I'm taking from where Madam Luthra left, and I want to start from the basics. And in daytime, whatever the discussion has taken place. So I congratulate BW for making such a good event, curating it so beautifully, accommodating every relevant topic. What I understood while looking at schedule, everything important has been discussed. And I'm also sitting from few sessions I could hear. But what I feel when we discuss education, legal education specifically, and making it good for industry, as I said, I appreciate the way it was curated, that how legal education should be used for the industry, how better lawyers should come for litigation, even in-house, everything was accommodated. What I feel, and I want to start with, how socially sensitive lawyers we can make in law schools, because once one is socially sensitive, know for what law is made, I think the productivity, performance, everything follows. So I want to start from that basic. And that's where I said, I'm not guiding, I'm sharing what I have experienced. And I have written one article, 3 C's of legal profession: classroom, courtroom, and corporate. And I'm fortunate to see at least all these 3 sides. So it is an admitted fact, if I talk in legal terminology, that yes, there is a divide when we see classroom law and the courtroom law. It is very clearly. I taught for 6 years in so many jurisdictions before I came to practice law. And I was wise enough to consider myself fresher and started as fresher, started learning everything, and I realized everything was zero. Whatever I have studied, I knew the law. I knew the law, but how to apply it. Now, here, as I said, I will start with where ma'am left. Knowing law, the basics, it's very important. And when we discuss how to make the law industry usable, we miss that basic aspect. Knowing law is necessary. But when we go to law, which is a first generation reform, law school system of 5 years, then that basic law doesn't get primacy and the exposure to the industry gets the specific importance. Of course, it is a good thing. I'm not denying. Now, the second generation law reform, as Bar Council claims, has also come. They are trying to do another experiment. What I'm saying, this divide, these experimentations with the experience are necessary. But to fill that, to bridge that divide, are we really using those experiences? That's where I doubt. The moment in 85 we started to come up with NLS Bangalore, we realized that we need to have early A's and we start grooming in a specific direction. Integrated law courses started, BLLB. Let me just confine with BLLB, but it's same for BSc, BCom, all LLBs. So law school begin with the sociology, economics, all those basic subjects. Why? Because one has to know for what you are going to learn. Until you know the sociology, you don't know the basics, why the law is needed. Now, I have been teaching in law school of that first generation experiment, and I myself has studied in the traditional law school. And I still have my juniors from DU as well as from both places, and I see the difference every day. Subjects when it comes to law school are always prioritized. Like one of the panelists was saying that there has to be shareholding, teaching this credit code, that credit code. That's all necessary, and that's where law schools are going ahead. But are we able to balance it? Why are we discussing today again after this bridging the gap? And why I'm saying that yes, this gap is still exists, because still after all experiment, needful is not done. Now, with my experience, I just want to highlight the points which I see. And there is no foolproof solution to any problem, but how I see we can tackle it. So one is definitely the method of teaching. And perhaps that was thought when the law school first reform came, because integrated course, then the teaching methodology, everything was worked out. Even Bar Council has come up with the amended regulation and talked about the teaching experiments. Still, are we really seeing the application of those rules and reform at equal level when we see those 3 years law schools of traditional universities as well as the 5 years law schools? No. So one is the problem that yes, we do have the problem in way of teaching, but at the same time, in one of the Delhi High Court judgment, Vandana Bhandari, I was reading that Nani Palkhiwala's quote was quoted that our law learning starts from classroom, but it goes on forever. So inculcating the habit, the thought to law students at that basic stage that it is law is not all about teaching. Law is about learning. How good a teacher is every day in every law college, students sit and judge. We do have the feedback systems as well, which is good for the teaching standard. But at the same time, are we not failing to inculcate this, that it is all about good learner as well, because this is one profession where forever the learning has to continue. So when we talk about teaching, of course, we require change and we still require change. I'll give one example. We focus on teaching the law. And again, when I'm saying, I'm not quoting any law school or any traditional university in general. We focus upon teaching the law. We don't focus upon how they can understand and interpret the law, because law is not something static. Today there is, like for criminal law, yes, today we have another law, tomorrow we are going to have another law. Now, if a student know how to understand the law, then it will be more useful than what IPC was or what any particular law is. Now, interpretation of statute, I always say, is the most important subject which we teach, but no law school gives actually genuine focus on that. So important laws which are necessary are generally not focused because of the career focus, which starts at very early, industry specific focus, which starts very early. So can we think of having the module or revising the syllabus and pattern where from third year or fourth year onwards, we can give certain subject not only optional to choose, but at the same time give complete option to leave and focus on the industry specific, because what is required for an industry in corporate house would not be the same for an NGO, would not be the same for the person who wants to pursue higher education. So instead of just bulldozing all credit courses, can't we think of specifying and dividing those directions? So one, working on syllabus. That one suggestion I would like to give. Second, involving state bar councils. If so far state bar councils are more focused to registration, and only Bar Council of India is supposed to do the major role of accreditation, etc. The State Bar Council should also take up more role, because infrastructure in law schools are still major problem. And the major problem at the beginning stage starts when the Bar Council start judging law schools at one scale all over India. We cannot have same infrastructure, and we cannot have all primacy of syllabus everywhere. We might require a specific thing in particular sections, but that may not be equally relevant for other. So can't we think of involving a state bar council and give more role to that, which is already by law given to them, but it's not effective. Just one member from state bar council goes with the Bar Council of India team and inspection is over. Afterwards, what is happening in that state bar council is definitely not relevant for them. So increasing role of state bar council is another point I think should be taken in mind. Then when it comes to legal education, clinical legal education, training, we are doing a lot. We have been doing a lot, but the effective part is yet to happen. Internship or tutorial classes or legal education involvement of students, legal aid involvement of students. We talk about everything, but that's limited to certain level of law schools only, and it's not yet implemented everywhere. So one is what law we have, regulations we have, and second, how to get that implemented to improve the legal standard. At both stages, I think it is necessary to divide the points and work upon that. An important point, what I see the last session was on ESG. ESG is the right solution, not ESG as a subject, but ESG as the concept is the right solution for standard of improvement in standard of legal education. If environment is thought, then we are going to have all electronic database in all law schools. Then when it comes to society, then legal aid department of the law school should be strengthened. More student involvement should be there. Then governance, if governance part is taken care, then faculty standard and upgradation should be taken on priority. We do have the regulations, UGC requirement for promotions and refresher courses, etc. But when it comes to regular development of the faculties, updating the faculties, I think at that front, law schools are yet to take substantial steps. And when you say law schools, traditional law universities are neither in better position. So on these points, I believe that we require to work on. Medium is also one reason, but I still don't consider it as a very big reason, for the simple reason that majority of high courts have the English as a common language. So that has its own role to play, that often we get confused with the knowledge of language and the knowledge of content law. So that confusion still exists. So this can also be one thing to be thought of. For that, honestly, I don't have exact solution. I would still not say teach law only in mother tongue, but at the same time, this is something to be thought of, because law is for litigants. That concept is very important. And then a final point which I want to highlight, when we start teaching students, we must focus on ethics. We must focus on professional ethics, professionalism. Only knowledge of law, having the marketable subject, good grades in that, is not going to bring us better lawyers in any industry. We were discussing in another session about AI and how it is going to be tackled. It's very simple. If a lawyer knows the ethics, then AI is not posing anything new. ChatGPT to be used as tool to facilitate or to be used just to take over our mind, ethics would give the simple answer. If a lawyer or anyone is morally equipped about professionalism and ethics, then these new days problems are very easily going to be tackled. So Teaching Advocates Act and considering that complete professional ethics is taught in end of the final year when they are already placed and they are least bothered about knowing about that is definitely not the right way. I believe professional ethics should be at the time when we are teaching sociology in first year, economics at that stage, so they can understand for which the law is made and what is their limitation. So when students go for internship, they can show similar level of commitment and professionalism and they can understand better, because nowadays internship are not that helpful because half of the time they don't get access to confidential assignments because we are not sure how much they would understand and take it seriously. So this is also one of the point which I think it is to be taken in mind. So if I need to list to conclude with, one, the syllabus, which is problem in traditional universities, that autonomy is not there to offer new subject, as I have seen in LS Bangalore, that one can very well have number of experts offering all new courses, students are getting equipped. That facility is not available everywhere. So how in traditional universities where the administrative process is too huge to edit and amend the syllabus, how the industry related updated subjects to reach the students, syllabus changing process has to be thought of, and then how a student should be professionally equipped to understand that it is an ongoing learning profession where professionalism is more important than only knowing the law. Thank you so much, BW, for having me and giving me opportunity to share my thoughts. And as I said, there can never be a final solution to ABC that these are the solutions, but there are some solutions which I thought and I suggested, and I believe as legal learning is an ongoing process, these kind of, the moment we face the problem, we will have to come up with the solutions, and have being professionally sound and knowing the basic laws would always make us equipped to face the solution, find the solutions and face new challenges, whatever it comes. Thank you so much.
Thank you so much, ma'am, for your address. And now from the afternoon's discussions, it's time to move towards the evening's celebrations. Once again, my name is Aditya Malik, and it's an honor and a pleasure to welcome all of you to the third edition of the BW Legal World Law School Rankings 2024 Awards ceremony. Today, we gather here to celebrate and also honor the institutions that have excelled in the realm of legal education, setting benchmarks, and also fostering a culture of innovation, of excellence, of industry integration. I would also take this moment to thank our associate partners for the day. ICFI Law School, Hyderabad, GD Goenka University, and also GD Goenka School of Law. Our own partners, Atik Sheikh Factory, Joy Travels Private Limited, Reality Plus, Exchange for Media, IWM Buzz, Impact, Pitch, Fandrum, and also Daily Coffee. Now, before we begin with the award ceremony, from the time you nominate yourselves to the time or till the time we arrive at this list that I was just given, and of course we also celebrate that with you. This entire jury process, क्या क्या इस process में होता है, how do we reach, how does the shortlisting happen, etc. How are the rankings decided, why are they decided, why is someone chosen on a specific rank and why not? We would like to take you through the entire jury process once. So can you please have the jury, Avi? Can you please give a huge round of applause to all our jury members? It's actually their efforts that has brought about this list for the day. Also, exactly आज क्या क्या हुआ? Who were our speakers all throughout the day? To give you a glimpse of that, may I please request our team to once again play the event TV? So all throughout the day, we were privileged to have the finest minds in the legal realm with us. For jurists, our lawyers, general counsels, also professors who give us insightful sessions, etc. And also before we open the award ceremony, we also have the recent magazine cover launch. Can you please have the magazine cover, Evie? You want 2 minutes? That's okay. It's okay. It's okay. Take your time. Chalta hai. No panic. So while we do that, while we're getting ready to formally welcome all of you also to open the award ceremony, please join me in welcoming on stage Dr. Anurag Batra, Chairman and Editor-in-Chief of PW Business World, and also founder of the Exchange for Media Group. Sir, everybody please.
Good afternoon. It's my honor and privilege to welcome you to the BW Legal World Law School ranking event and the felicitation that kind of flows out of the rankings. It's an honor to welcome Honorable Justice Midha. Thank you for making time today and being with us. Thank you, Geeta ji, for being with us. All the legal luminaries in the room, my friends from the media, young students, directors of law schools. I can only say, talking to Geeta ji outside, one thing that's changed about the legal profession is my friends who started around 30 years back, in summer holidays, they used to go to Nainital, Missouri. These days, lawyers go to Switzerland, they go to London, they go to Croatia. So, and that's, I may say it jokingly, but it just tells you that the legal profession has done well. It's a fact. It's not a opinion that I'm sharing. and the best time on the legal profession, especially on the corporate side, uh, is ahead of us. The legal services domain is growing as India's GDP is growing. The legal services domain is growing. Of course, from a legal services standpoint, justice standpoint, we have a huge pendency of cases. Of course, beyond arbitration, we are going towards mediation because arbitration as a tool for speedy judgments and cost effective process hasn't served its purpose like it was envisaged. Hopefully mediation will ease the pressure. There are more than 5 crore cases, 5 crore plus cases pending, and I can just say that there is a term called soft skills. And I don't know who called it soft skills because they are the real skills: communication, empathy, problem solving. They're the real skills. They are the super skills. In the legal profession, I can only say the skills of empathy, putting yourself in the other person's shoes and being able to, figure out how the person is looking at the issue. And even if you have to finally solve it through arbitration, mediation, you'll have to do that. The ability to communicate, in a succinct way, the ability to find the needle in the haystack, so to say, from a huge amount of information coming to the central, just the ability to be working as teams, collaborative work. So the soft skills, or what I call the super skills, apart from the technical knowledge, and they are young because of our events in the legal world in the 40, under 40, 30. I meet people who spend a lot of time on networking, and which is great. Connecting with people from your profession, having a mentor is great. But spend a lot more time, kind of honing your craft, whether you're in the court or you're a law firm briefing a senior. I think that's what counts and builds your body of work and eventually makes you successful. I think in more than any profession, the mentorship is the most important. I mean, I meet lawyers. When I was with a friend of mine early in the morning in Gorakhpur, and he started his internship or first job with Geetaji. I don't know when did he work with you, but almost 25 years back. And he's done well. And I know of many cases where the people you worked with really shaped your career. I mean, it happens in every profession, but I think in legal, because it's very intensive, and if you're an understudy, you do research, and then you eventually work on the case, and someday you get a chance to be able to represent fully. So I keep giving the example of this astronaut called Mr. Rakesh Sharma, who was the number 2 on the list to go to the US, to the space, and the number 1 didn't make it, so he went. So luck and destiny plays its role, but it's about preparation. So I don't want to stand between you and Justice Midda's address and the unveiling of the rankings. Vaibhav is here. He does a lot of hiring at Saraf & Company, so you should talk to him for hiring. I can only say that I was telling Ashrama that we should do it earlier in the year, maybe in the March or April when the weather is pleasant, when we can get more directors. Right now, all the directors are admission centric, they're focusing on admissions and the new batches starting. So hopefully we'll do it earlier in the year. And it's a very important part of what we are doing in BW legal world. And Justice Midda, I just want to share with you, how are you, Mr. Sundaram? I just want to, you're sporting a hairstyle like me. No, that's why it took me a second to recognize. No problem. We charge you an IP fee. I don't know. Mahatma Gandhi Trust, we'll have to give him a lot of IP fees. Right. But on a serious note, I think, Justice Midda, I want to tell you that while Business World is in the 45th year, the last 10 years, I've had the good pleasure of leading it. And I can only say we're not in the business of magazines, website events. We built, of course, Business World is very B2C. We built many B2C. B2C, for those who want to know, is business to consumer. I'm sure all of you know. And many B2B communities, which is B2B. So legal community is at the cusp of business and law. We do about 6 events. We do a magazine, and we have a daily website. We have a long way to go, but we are making progress every day, thanks to Ashima Krishnendra, Kaustab, and many other colleagues that work behind the curtains to be able to put the initiative together. My sales colleague Ravi was there in the room. They bring in the money to be able to make sure we do events. And so this is, I think, the third year of the rankings. And this is the third year of the ranking. We did the first year also in this room. Mr. Shardul Shroff was our keynote speaker. And he was really, really, I think it's one of the best speeches for students I've heard, where he really simplified how one's career should progress. So I will wish you luck. I went to a business school in Gurgaon 30 years back. It's called MDI. And then I had, for the last 3.5 years, I served on the board of MDI. I'm also the chairman of the MDI alumni. My parents are academicians. And I last night and today morning I was in Gorakhpur for a friend's education trust. They run a school there, which is very popular and very old. It's almost 48 years old school. And I can only tell you, education is only about one thing. It's the quality of teachers. The director of the institute matters, the principal matters, but it's the quality of the faculty that builds any institution. That's why own example, first-hand experience. At MDI, we did okay because our professor was great. Our placements were fantastic. And MDI had a certain background in executive education and MDPs. We retired with Kellogg. But it's our teachers which were really did the heavy lifting in making sure that MDI grew. And of course, in certain institutes, it's the quality of students that come in. But I think it doesn't matter once you're in an institute. It doesn't matter which institute you're in. Today, there are law firms which are looking for people. And sometimes being from tier 2, tier 3 law school is better because you work harder. In life, it's about how hungry you are, how much effort you put in. It's not about which institute you go to. Yes, if you go to a good institute, it will get you jobs in a certain places, but then it's an equalizer. So really, I wish you luck in your endeavor to build your careers. I salute all the professors, teachers, deans, directors who lead law schools. As the legal services domain, it is projected in the next 6-7 years, it will quadruple. It will become 400% growth. And it's not exit poll predictions. Okay. So I'm from the media, my first. Yeah. These days you blame everything on AI. One day my WhatsApp about 2 months back got shut for like 1 day or 3 days. And because of what I do, I know the top guys. And they say, no, it's all AI driven. So they took 2 or 3 days to kind of restore my WhatsApp. So everything you don't understand, you blame it on AI. I'm going to say everything is AI driven, right? But on a serious note, the legal services industry is growing. AI is impacting every domain. AI will just make sure that the data that you have to look at, it can be done easier, faster. It can synthesize it. It can give you, like life is about asking the right questions. You'll get the right answer. AI is about prompts. If you put the right prompts, it will help you do it. But the role of representing, the role of which point to be able to use to be able to present to the judge, what is the strategy, that cannot be decided by AI. So the AI will eliminate lower end jobs of processing. The jobs of a lawyer in the foreseeable future is not replaceable, and foreseeable future at least 10 years. So wish you luck, and I look forward to the ranking and look forward to Justice Meera's address. And, thank you, sir, for making your time and being with us. Hopefully, they'll be able to benefit from what you share with them, and your presence means a lot. Thank you, Geeta ji, for being here. Thank you, Mr. Amar Sundaram. Everybody, God bless you. And I'll go back so that we can invite Justice Meera.
So our day today began with listening to Justice Medan. I think before we begin with the awards ceremony, Sir's here with us. It's apt and also a request. May we please request you to join us on the stage and also say a few words of encouragement for all our lovely students who are here, our faculty members, lawyers, justices, everybody, please. Justice J.R. Mehta, former judge, Delhi High Court, everybody. Can you be louder? More warmer? Badhiya, thank you.
Thank you very much, Dr. Anurag Batra, Asma, Ori, Senior Advocate Geeta Luthra ji, and all the dignitaries present here. I thank Business World for inviting me on this occasion. And in my keynote address, I have already shared my thoughts on the future of legal education. I have already shared my views that the legal education in our country is not comprehensive. A law graduate is not market ready. There's need to incorporate the teaching of communication skills, rational thinking, fundamentals of law, psychology, and so many other things, so that a law graduate is ready to move on day one. And one more point I would like to emphasize today is that today is the time when this transformation is taking place because of AI. I'll give a very small example. You said till few years back, a person you knew all the routes and destinations, everything, he was very relevant, no? But with the Google Maps, that person has become irrelevant. You don't require anybody to contact anybody. Google Map gives you the answer. So till now, a person who had full knowledge of law, he can clear the judge examination also in one shot, no? So it will become still easy, but to do judging, the AI can't give the answer. Similarly, till now, a person who knows all the laws and all the judgments was relevant. But within next 5 years, you will find everybody will know the law. Even the litigant from the AI will be able to find out the law and judgments. To my mind, no discussion may take place in court. So a lawyer who will succeed has to give a solution, not merely tell what law is. In next 5 years, you will find everybody will know the law. So litigant will not come to for the opinion, please tell me what is the law and what is the relevant judgment. He will say, what is the solution? So therefore, only that person will survive who ultimately is able to deliver, not merely having the knowledge. Therefore, this is a time when we should reform the legal education. And as I shared in the morning, I think many of you were not there. I'll once again share my thoughts. Most important skill of a lawyer is the communication skill. If he's not able to communicate, everything is multiplied with 0. Second important skill is the rational thing, how to think logically and rationally. If he's not able to think rationally and find logical answers, nothing to do with law. And justice delivery system is ultimately based on finding out the truth and doing justice. For finding out the truth, we all have the skill. It is only that we have to sharpen the skill to do justice. And many times we shared some cases in the morning where the whole world knows the truth. But when it comes to the court, justice fails. So judgment and justice are two different things. We discussed the case of Jessica Lal murder case in the morning, where murder took place in front of 100 persons. And the courts had acquitted the person. We again shared the case of Priyadarshini Mattu, where murder took place, the whole world knew, and the court acquitted. Finally, in High Court, in both cases, High Court and Supreme Court then reversed the acquittal. And now, recently, the case which we discussed in the morning, Nithari murder case with Geeta Luthra ji is now pursuing in Supreme Court, where 19 rapes followed by 19 murders, then rape with the corpse, then cutting the body and cooking and eating the body and skull, all the skulls found in the drain behind the house. And punishment of death by hanging given by Sessions Court, but the High Court has acquitted. So therefore, to my mind, this is a time where legal education, and I agree with Dr. Batra, today we don't have good law teachers. The number of law colleges mushroomed in the country are so much, we don't have good law teachers. And as Professor Vajpayee said in the recent Teachers Conclave on 31st January, that there is no process of making teachers or building teachers. Teacher becomes a teacher by appointment letter. You get a degree, you get an appointment, you are a teacher. But how to teach? Therefore, there is a need, some institution or university should take up the opportunity to build up a center for training the teachers. There is also need of teaching advocacy skills. I am, so see, post-retirement, although I was teaching in Delhi University from 89 to 92 after Justice Sikri demitted, they completed his term. And now post-retirement, now teaching in NLU as a professor of practice and also Galgotia's University and also associated with Munjal University. So there in all the three places, I am conducting mentor-mentee course. So we select the 20 best students of the university and then train those 20 students. Many of them are present here. I think 6 or 7 students are there. They just raise their hands. So we conduct the mentor-mentee course and train those students fully so they are ready. And to my mind, since the profession of legal profession is like the other, it is different from all other professions where the performance of a lawyer comes in public domain on day one. Unlike other professions, only in 2 other professions, in cricket, films and legal profession. So if a lawyer on day one, let's assume a lawyer is fully trained and we tell the Chief Justice that look, he will today argue the first case and he will argue better than the top lawyers of the country. So his performance comes in public domain. He is recognized on day one. So there is a need, to my mind, as I strongly favor that education policy of Singapore, from where from day one they keep on segregating the students and they find out whose student is meant for what is the best talent in him. And they keep on segregating and say that who tomorrow should become the IAS officer, who should become the engineer, who should become the doctor, who should become the driver, who should become the plumber. So here also in law school, we should select the at least 20 or 30 best students. And out of them also, who can be the best, who has a best talent for a lawyer, who has a good talent for a judge, who has a good talent for a teacher, and then train them and then produce the top lawyers and top judges and top teachers. So I think we had a very good session today. Business World has done a very wonderful work. I wish they should have associated me earlier. To my mind, I suggested that for ranking of law college, we should test the ultimate product. We should tell them, please show us your 5 best students. Ultimately, if you are not able to show that result, what is the use of infrastructure? What is the use of other things? Ultimate test, please show me 5 students. Have you been able to, are they today market ready? Do they have all the talents of a good lawyer or a good judge? And to my mind, every university should have, and Business World, since you are associated with the legal field, you should work on doing some activity where we are short of good teachers all over the country. There's a very great shortage. We should produce good teachers. We should conduct a course on advocacy skills. We should conduct a course on judicial service training. And that is, to my mind, the need of our. Thank you very much and best of luck.
Thank you. Thank you so much, Justice Mehta. Thank you for your words. Today's award ceremony, it's being streamed live across all BW Business World platforms, including the social media channels and also on www.bwlegalworld.com. Please join in the celebrations of the evening by using the hashtag BW Law School Rankings. And before we start with the ceremony, a humble request to all our winners. Once you come to the stage, you receive your award. Please step down from stage left and wait there for an individual picture. And then also stay back till the end for a group picture, both for the magazines and also for the digital world as well. And now, to reveal the winners of the 3rd edition of the BW Legal World Law School Rankings 2024. Please join me in welcoming our presenters for the same. Let's please welcome Dr. Anurag Batra, Chairman and Editor-in-Chief of BW Business World and founder of the Exchange of Media Group. Joining sir is Justice J.R. Midda, former judge, Delhi High Court, and joining them is Ms. Geeta Luthra, Senior Advocate, Supreme Court of India. Please, ma'am. We'll do it zone wise. And of course, once we call out the winners, you should also see the ranks on the screen. Yes? Now, this is in the private category. And in the West region, this is rank number 1. And this goes to the massive law school. Honey. We have with us Dr. Wasim Ahmed, Assistant Professor to receive the award. Dr. Wasim, a few words from you.
Yes, please. First of all, I'm honored to accept this award on behalf of Symbiosis Law School, Pune. This recognition reflects the hard work, dedication, and commitment of our entire university community. And we are grateful for this acknowledgement and will continue to strive for excellence in legal education and research. Thank you so much for this prestigious honor. Thank you so much.
Congratulations from that side, sir. Number of the pictures, please. Next, again from West, this is rank number 4. Please. School of Law, D.Y. Patil University. We have with us Dr. Karuna Akshay Malviya, the director to receive the award. And the rankings, I'm telling you, these are regional rankings, not the national. Yes?
On behalf of D.Y. Patil University School of Law, gratitude to BW Business World for organizing, for recognizing what we are doing in the field of education and research. And this is kind of motivation for us to give back to the society in a more better way. So thanks.
Congratulations, ma'am. To you and everybody back home. Congratulations. Moving ahead, again, it's from the West, rank number 12. Please. Faculty from Raleigh University, Rajkot. We have with us Devansh Rathore, the college representative, to receive the award. Devansh, to say something.
Firstly, a very good evening to one and all present here. My name is Devansh Kanatra. It's an absolute honor for me to be present here and to collect this award on behalf of faculty of Law, Marwar University. I'm utterly grateful to our Dean, faculty of Law, Marwar University, that is Dr. Rishikesh Dave sir, and BW's World Business Legal Group for this award. Thank you so much.
Congratulations. Now we move towards our next zone, which is the East zone. And in that, rank number 1, please. Shiksha O Anusandhan National School from Bangladesh, Nayak, OSD, the founder. President also Ripti Das, Director, Industry Engagement and Corporate Relations, received the award.
A warm good evening to all of you, and a sincere congratulations to BW team, and our gratitude to include us, honoring our efforts in education. As we are from East, and of late, East is the region where a lot of focus is happening across India, in especially in education. So it gives us not only a lot of happiness, but at the same time a responsibility to do a better job. And I'm sure with our team we are going to prosper further. Thank you very much.
Congratulations. Let us not forget to individual picture and also group picture in the end. Next, we move ahead towards the North Zone. Rank number 3, North Zone, please. School of Law, University of Petroleum and Energy Studies, we have with us the Dean, Dr. Abhishek Sinha, to receive the award. For them, please, everybody.
Thank you very much. Thank you very much, PW Legal. As a law school, when you try and make efforts to move away from a traditional law school setup and focus more on experiential learning, participatory learning, more on the clinical education side, and these kind of recognitions is more of a reminder that maybe we are treading the right path. So thank you very much.
Congratulations. Congratulations, sir. And with that, thank you so much, ma'am, for advance awards. Thank you so much. Thank you. Everybody wants a hand, please. Thank you. Please request Mr. Vaibhav Kakkar, Senior Partner, Supporting Partners, to please join us on the stage and help us present awards to next level winners. So, everybody, let's welcome him. Moving ahead in the motion from rank number 5, please. So, as of last point, we have with us Dr. Wasim Ahmed, Assistant Professor, to receive the award again. Yes. So, this is also called Noida. You wish to say something again, please?
Again, thank you so much for this award. And I'm very grateful to BW Legal that organized such a event, which encourage us to do a better thing in the for the future, for the students and community as well. Thank you so much.
Congratulations. Also, please request Swargama Chaturvedi, Senior Advocate, a former Assistant Professor in Law, NLS IM Bangalore, please join us on the campus present awards to next level as well. Please welcome everybody.
I don't see you, otherwise I would have taken your name. I thought students were sitting there and am I? Thank you for being here. Why don't you go? And Bani, I forgot to take your name. So I know I get into trouble in the office next day when people send me, you don't take my name. So I know you contributed a lot, so thank you. And Krishna, now I've taken your name twice, okay? So be nice to me tomorrow, okay?
Thank you. Moving ahead next in the North Region, rank number 6, please. We have with us Professor Shafali Razada, Director, Amity Law School, Noida, to receive the award. Please.
Very good evening, everyone on the dais and off the dais, or the distinguished, eminent legal fraternity personalities here. I'm Dr. Shifali Raiza, the Director, Amity Law School. Feel so honored and privileged to be here standing before you and receiving this award. It means a lot. And thank you, Business World. Thank you, Dr. Anurag Batra. Thank you, Justice Midra sir and Senior Advocate Ms. Geeta Luthra Madam and others for acknowledging law school and giving us so much of cherishing celebration on this evening. Thank you so very much.
Congratulations. May I don't forget individual pictures, just a reminder. Congratulations. Moving ahead next to rank number 7 in the North Region, please. Another School of Law and Legal Studies, Yeats, Professor Dr. Rashmi So, Baker to receive the award.
Audio jungle.
Thank you so much, BW Business World, Legal World. Thank you so much, our Vivekananda Institute of Professional Studies, for giving us opportunity to groom the future generation. So every day we encourage our students. We also need one day when someone will pat us that yes, you are doing a great job, that you are building the future of our nation. Thank you so much, BW Legal World. Thank you.
Yes, Shazan. Moving with the rank number 8 in the last region, please. School of Law, JD Goenka University, Gurugram. And with us, Associate Dean of School of Law, Dr. Devanshu Srivastava for Safra Award. Anybody else?
A very good evening to one and all. I'd like to thank the entire management of GD Goenka University and the BW Legal World. Uh, I totally resonate with what my previous speakers have said, that yes, the good works and the lauds are always appreciated. But also, yes, it's a reminder of what we are and how we'll have to grow. So thank you so much. And all the legal fraternity, including the legal worlds, the futures. Thank you so much, each one of you. Thank you so much.
Congratulations, sir. Thank you so much with that. Thank you so much, Mr. Kakkar, for this of the awards. Thank you so much, sir. Anybody else, sir, please also our panelist today.
That jury, they honestly was like 3 million. Like, when they took ownership, he won it. Honestly, we were award. Nobody did. Yeah. We let that mostly running the award. Zero independence. They told me you don't know law, so you don't participate. I think. You know, luckily we, somebody who's doing very well. I'm sure his best is like. Thank you, sir. Thank you. Thank you very much.
We request Samar Kumar, Sovereign General Counsel, Senior VP Legal and also Chief Compliance Officer, NEC Corporation, India, to please join us on stage and help us present the awards to the next webinars. Please. So, moving ahead, North Region again, rank number 13, please. Faculty of Law, SRM University, Delhi, NCR, Sonipat, Haryana, Vyavadas Professor, Dr. Abhishek Kaur Singh, Dean, Faculty of Law, to receive the award.
Good evening, everyone. On behalf of the management of the SRM University, Sonipat, first of all, thank you to the BW Legal World for giving this award. It means a lot for the staff, particularly of the law school, as well as the students who put in a lot of effort to grow. And definitely a reminder to move forward in the rankings in the coming years. Thank you. Thank you, everyone.
Congratulations. Congratulations to you and everybody back home. Moving ahead, North again, rank number 14. Please. All story of law Applicants Assistant Professor Dr. Manvendra Singh to receive the award. Everybody moves.
Good evening, everyone. I deeply honored to accept this award, BW Legal Award 2024, on behalf of Sharda School of Law, Sharda University. And this is all possible because of the dedicated faculty, hardworking students, and the supportive administrative staff. And definitely, this award will inspire us to reach new milestones. Thank you. Thank you, everyone.
Congratulations. Moving ahead, next, North. Again, rank number 16. Please. Bennett University School of Law, we have a Professor Pradeep Kushwacha Dev, Bennett School of Law to receive the award.
Thank you, Business World. Thank you, Dr. Batra. And thank you, my friends in the hall. We have been waiting since morning. And one thing we can be happy that there are more than 1,500 law schools in India. We are in top 100. Thank you, Dr. Batra, for this wonderful recognition. And this will certainly inspire us to do better. And I, on my personal behalf and on behalf of our Chancellor, Mr. Vinit Jain, faculty, colleagues, and students, once again, thank you very much, sir.
Congratulations. A request for your winners, please don't forget your individual pictures and also the group picture in the end. With that, thank you so much, Chaturvedi ma'am. Thank you so much. Thank you so much for helping us, ma'am. Thank you. Also, ma'am, please, everybody. She also had our last call for the day. I request Yeats Shukla, founder and CEO of Milo Martin, also advisor to BW Retail World, to please join us on the stage and help us present awards. Let's welcome sir, everybody. Red North, rank number 18. IMS Law College in Noida. We have with us the Director General, Dr. Vikas Dhawan, to receive the award. You can be louder or what happened? Where did we go? Everybody for now?
Very good evening to one and all in the dais, off the dais, on the dais. So actually, I'm a mechanical engineer. I'm not from the law fraternity, but yes, I've got a good exposure to the law schools as I've been leading good campuses. Personally speaking, I think law schools need to improve in the country. The experiential learning is poor. And to be honest, long back when my grandfather was a criminal lawyer, so everybody used to pass out from the law and then practice under a good lawyer and then go ahead to become a good lawyer at the end of the day. And it's old said that a lawyer in his young age is not very rich, but at the end of his career, he gets rich when there's no fun in earning money and he cannot spend upon himself. So anyway, God bless you all. Thank you to the business world for felicitating us. Thank you.
Yes, so congratulations to you. Moving ahead, North, rank number 19. School of Law, Sushant University, Gurugram, Haryana. Well, that's Dr. Surakshana Banerjee, Associate Professor of Law, to receive the award. Anybody else? We don't do a last few.
Good evening, everyone. It's indeed an honor to receive this prestigious award for the last consecutive 3 years. Thank you so much, Dr. Batra and his entire team, and all providing us this wonderful opportunity every time. It is actually a mode of inspiration to all of us. Thanks a lot.
Congratulations, man. Thank you so much, Wade, for helping us with the awards. Everybody wants to wait, so please. Thank you. I please request Kritika Krishnamurthy, our founding partner of Making Partners, to please join us on the stage and help us present awards to master winners. Let's welcome home, everybody. Okay, over here. Now we'll ask for next, again from North, rank number 20. From there, from the same College of Higher Studies and School of Law, we have with us Dr. Ahmed Jain, Director, Corporate Affairs, to receive the award, along with him. Everybody? Thank you so much, BW Legal, especially President and his team for this awards, very successful award ceremony. Thank you so much. Congratulations to you and everybody who awaits this trophy back home. Congratulations. So we have 3 more from the North region and 1 from the Central region that's left. Congratulations. Rank number 20.
Honestly, I showed up here in the late afternoon. This has been put together by Ashima, and Justice Meera has given me another problem to be solved. So I would request Ashima to come up. Miss Ashima Uri, who's our managing editor. Ashima, it's your and KJ and Kaustub's hard work. So please give Ashima a big round of applause. He does a fantastic job in, to be able to curate it.
Next, rank number 22 from the North section again. Speaker from one of Rachna University, we have with us Miss Pooja Das, Assistant Professor, School of Law, to receive the award. Anybody else? Show some love, some more. Thank you.
Hi, good evening, everyone. This is to be like an honor for me to be representing School of Law, Manavratna University. And thank you, BW Legal, for this recognition. As everybody said in the evening, like it is an encouragement indeed. So thank you so much for this. Thank you.
I want to promise this. Justice Meera is here and he's given me one or two ideas, but next year we'll do it earlier. We'll make sure all the directors are there, all the major recruiters, which are law firms, the managing partners, and we'll do a 2-day event. Make sure you meet your fraternity and also do some breakaway workshops which really address conferences of certain purpose, but do more deep dive which addresses some of the gaps. One of the gap is that every year I get like barrage of CVs for internships because you run a business magazine, you run a legal platform. Can you help? And I call my friends like Mr. Sundaram, Seema, Sudhir, Geeta ji, and I do it informally. Some extended family or friends. So that's one. Second, he said about this, there are lots of people who get entry into law firms or law careers. Some who want to be professors and teachers. Can we create a structured workshop or program, whatever you want to, which is 2 months, 3 months for them to really own that. Like when I was in MD, I used to do this, train the trainers, teach the trainers. My mom at SCRT, she was in SCRT Gurgaon. I grew up in old Gurgaon. Not that I've grown up. Loss of hair is no proof of growing up. She used to run a program in SCRT called Train the Trainer. So I think you've given me 2 problem statements, which I'm sure we'll address in the next 3-4 months. So I'm grateful for that, because the more we are impactful in the community, the more value we can add, and really that becomes our purpose, so to say. So thank you for that. At this point, I'd also like to call Mr. Khatri, so that he makes sure that we raise enough money next year to be able to do a big show today. That's why I'm calling you upon, and my gratitude to you for all the hard work that you. Ravi used to look like this 7 years back. 8, you joined us 8 years. He still looks like that. He doesn't work hard, I guess. There is a colleague of mine, Noor. I asked her when is his birthday. It's my hobby. Like when I first asked her when is her birthday, and then asked her when she got married, husband's birthday, and it turned out that her husband's birthday and my birthday is same. Then it turned out he went to MDI, right? So I was asking her, Justice Meera, when's his birthday, and he was gracious enough to tell me. And she's my oldest colleague as me. She's not old in age, but she'll start 22nd year of working with me. No, she's a group editorial director and the most meticulous person I know. Like if she takes 40 minutes off, she'll log it. I'm off for 40 minutes. Whatever, this is small. And like all the holding company CEOs are friends, because she'll reach 1 hour before the meeting for the last 20 years. She started in advertising reporting with me, and last 11 years she works with me in business world, 10 years at Exchange for Media. So she had black hair, her hair are white. There are people who lost hair working in me 10 years.
So what is the secret of not losing hair looking like this?
I'm working smartly, sir.
Okay, good.
Okay, congratulations to all of you. All that also helps us for next year. What that for this year? In the North Region again, rank number 24, please. Ability of Swami Vivekananda, Sabarthi University, Delhi, NCR, Meerut, India. We have with us Assistant Professor, Dr. Durvesh Pundi, to receive the award. Please.
Jai Hind, everyone. Myself, Dr. Durvesh Pundir from Swami Vivekananda Bharati University, Meerut. And thank you so much, the BW Legal and Management Committee for this award. Thank you so very much. Jai Hind.
Congratulations, sir. Now we are last two, one from North and one from Central. North first, rank number 25. Please. IIMT College of Law, Noida. We have with us Dr. Tanushree, Assistant Professor, and Mr. Akash M. Nair, Assistant Professor again, to receive the award. IIMT College of Law, everybody.
Very good evening, everyone. On behalf of IMT College of Law, I extend my heartfelt thanks to BW Legal. It was a pleasure to be amongst you all. Thank you so much.
The pleasure is ours, man. Congratulations to all and to everybody back home as well. Now, for the last one, this is in the Central region, rank number 2. Please. Faculty of Law, Jharkhand Lake City University, Bhopal. We have with us Professor Dr. Sachin Rastogi, Dean, Faculty of Law, to receive this award. A request to all the winners. After this, we'll also have the group picture. Vani, can you make sure no winners outside? They're all inside. Can you please make sure? Everybody?
Yeah, very good evening to all of you present here. On behalf of Jagran Lake City University, Bhopal, I am greatly thankful to BW Legal and especially Mr. Batra for this award. This award is basically a recognition of the hard work we have put in and a motivation to do better. Thank you so much.
9 years back, I had the good pleasure of coming to the university at the convocation, and it's it's a university that's going from strength to strength. All the best.
Congratulations. And with that, we come to an end of the awards ceremony for this year, which also means it's time for a group picture. May I please request all the winners to join us on the stage with their trophies. We'll first do a picture with the jury members. and then only with the winners. Please, all the winners are here with your trophies. Costa, can you please make sure no winners outside or inside? Group picture. Can you please check? Are you? A couple of you can come down as well. The ones who are tall can come downstairs as well. Let him check. Okay, we'll first do the main camera and then you can do your phones as well. The main camera first, please. The main camera, please, first.
No, not elevate. Please wait, we'll do another one. Just your answer. Can you also I
Thank you. Congratulations to all of you. Thank you.